ಮೆಮೊ ಇಲ್ವಾ? ಮೆಮೊ ತಗೊಳ್ಳಲ್ಲ. ಯಾವ ನಾಡಿದ್ದು?
ನಾಳೆ ನಾಡಿದ್ದು 2 ದಿವಸ ಡೇಟ್ ಕೊಡ್ತೀವಿ.
ನಾಡಿದ್ದು ಕೊಡಿ.
ಶುಕ್ರವಾರ ಇಲ್ಲ ಅಂದ್ರೆ ಸೋಮವಾರ.
ಅಲ್ಲಿ ತಗೊಳ್ತಾರೆ. One submission.
Fresh matters.
Friday.
Fresh matter, my lords. Fresh matter.
Friday ಆಗ್ತಿರ್ಲಿಲ್ಲ.
Fresh matter tomorrow ಬರುತ್ತೆ. First okay.
Fresh matter. Lords is a pending. Pending matter. Pending. Fresh matter.
Pending ಎಲ್ಲ
ಯಾವಾಗ ಹಾಕಿರೋದು?
6 ತಿಂಗಳಾದ್ರೂ ಬರ್ತಾ ಇಲ್ಲ.
ನೋಡೋಣ ಕೊಡಿ. ಫೋಟೋ ಸರ್. ಬರೀ 13 ಮ್ಯಾಟರ್ ಆಗ್ತದೆ. 20 ಮ್ಯಾಟರ್ ಆಗ್ತದೆ. ಅರ್ಥನೇ ಆಗೋದಿಲ್ಲ ಸರ್, ಯಾಕೆ ಹಿಂಗ್ ಮಾಡ್ತಾರೆ?
Number 1, fresh matter serial number 1, Hiramata Akka Mahadevi.
Password serial quota lating matter. First matter.
Password.
Number 2,
Petition.
30th January 2020 is the AC order. Before ordinance, same parties. WP 3271 of 20.
Up to the petition.
To appear before the Assistant Commissioner on 22nd of April.
serial number 3.
For petitioner, my lord, the mandamus to consider my representation, which is annexure G. Matter is covered with this honorable court. Matter is covered, man. Have money matter 5th tarikh.
What is your representation? What are you asking?
Computer RTC.
ಹೆಸರು ಬಂದಿಲ್ಲ.
Manual ಅಲ್ಲಿ ಇದೆ.
Grant
grant.
On the same orders.
3994.
6674 of 2024.
Please.
Same order.
Same.
All right.
Grateful.
Serial number 4, Anil Kumar R, 79 AB.
17.
2020 is the.
So this is January 2020 order. Same part.
All right. Appear before the Assistant Commissioner on 22nd of April.
Serial number 5, Virupakshaya PH.
Back to appear for petitioner. I have filed representation word for grant of land, 10 gunters of land. Annexure A is the acknowledgement for having filed my application. B is the representation. That has not been considered.
Grant of land alla, regularization of unauthorized occupation.
Regularization of land. Application was filed as per annexure A.
Still not considered.
Not yet considered.
ಇದರಲ್ಲಿ ಅವರು ಫಾರಂ 57 ಅಂತ ಹೇಳ್ತಾರೆ, ಬಟ್ they say it has been applied in 1991 ಫಾರಂ 53 ಇತ್ತು.
ಅದಕ್ಕೆ ಕನ್ಸಿಡರ್ ಮಾಡಿ ನೀವು ಅಲ್ಲಿ ವೆರಿಫೈ ಮಾಡಿ. ಅದೇನಾದ್ರು ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ ಅಂತಂದ್ರೆ ಈ ಗಿವ್ ಎನ್ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಆ ಥರದ್ದು ಯಾವ್ದು ಅಪ್ಲಿಕೇಶನ್ ಪೆಂಡಿಂಗ್ ಇಲ್ಲ ನಮ್ಮಲ್ಲಿ.
ಪ್ಲೀಸ್.
ಯಾವ್ದು ರಿಪಿಟೇಷನ್
17659 of 23.
ಇನ್ನೊಂದು ಸೆಂಟೆನ್ಸ್ ಸೇರಿಸ್ಕೊಳ್ಳಿದ್ರು ಅಲ್ಲ ಪ್ರಿವಿಯಸ್ ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ. ಇಫ್ ಆನ್ ವೆರಿಫಿಕೇಶನ್ it is found that no such application filed by the petitioner is pending consideration is found in the register, then the Tahsildar may issue an endorsement accordingly.
Number 6.
I am for petitioner, my lordship. My lordship, the petitioner challenged the order passed by the first respondent in RP number 195/2022 dated 22/1/2024. The respondent number 2 has passed an export order in RRTA G70/14. The said order challenged before the Deputy Commissioner in RP number 195/2022, my lordship. My lordship, one applicant Rangshama has given false application to the revenue entries changed by the petitioner's father without any document. My lordship, the petitioner father has been petitioner grandfather purchased the said land through the registered sale deed document number 3445/1966-67. Thereafter, the revenue entries also mutated in the name of the petitioner grandfather and petitioner father. During the computation of the revenue entries, the revenue officers have been caused some mistakes and again entered the one Rangswamaya name in the revenue entries. When the petitioner's father have been partitioned the said property, they have got mutation entries by error. The ಖಾತೆ have been transferred to Pavati. ಆ ಪವತಿ ಅಂತ ಟ್ರಾನ್ಸ್ಫರ್ ಆದಕ್ಕೆ ಇಲ್ಲಿ ಇವ್ರೇನ್ ಹೇಳ್ತಾರೆ, ನಮ್ಮ ಹೆಸರಿಗೆ 79 ಬಾರು the alleged MR number 79/1991. The said MR has been registered in the name of the Rangaswamaya with respect to the land measuring 4 acre 16 guntas, my lordship. The said land also sold to the petitioners wide registered sale deed document number 2. The said land also sold by the Rangswamaya to the Madaya Rangaya through the registered sale deed dated 2337/1966, sorry 9697, my lordship. The entire Rangswamaya and his father brother land have been sold to the petitioners. Even though they have made the false application, said that the MR number 79 has been got the 2 acres land, that is the misleaded the second respondent and
What was your contention? How did you get the property?
My lordship, entire property have been purchased by the petitioner's father and grandfather. Madaya and Rangaya.
Under which document?
Yes, please, my lordship. One registered sale deed dated 28/11/1966 with respect to the 2 acre 6 kuntas by document number 3445/1966-67.
Where is that document?
Please, my lordship. Annexure C and E, my lord. C and E, my lordship. Annexure C and E. My lordship, C. ಸನ್ 1966 ಇಸ್ವಿ ನವೆಂಬರ್ ತಾರೀಕು 28ರಲ್ಲಿ ಗುಬ್ಬಿ ತಾಲೂಕು ಚೇಳೂರು ಸಮತ್ ಹೂವಿನಕಟ್ಟೆ ಗ್ರಾಮದಲ್ಲಿರುವ ಕುಂಚಿಟಿಗ ಒಕ್ಕಲಿಗ ಮತದ ರಂಗಯ್ಯನವರ ಮಗ ಜೀರಾಯತಿನಿಂದ ಜೀವಿಸುವ ಮದ್ದಯ್ಯನವರಿಗೆ ಇದೇ ಚೇಳೂರು ಸಮತ್ ಹೂವಿನಕಟ್ಟೆ ಗ್ರಾಮದಲ್ಲಿರುವ ಕುಂಚಿಟಿತ ಒಕ್ಕಲಿಗ ಮತದ ಜೀರಾಯತಿನಿಂದ ಜೀವಿಸುವ
Document is executed by one Siddhaya.
That who is the Rangsamaya's father, elder brother, your honor. Each share has been executed. And also ಅದು ಏನಿಲ್ಲಿ ರಂಗಸ್ವಾಮಯ್ಯ ಅಂತ ಇದ್ರೆ ಸುಮ್ಮನೆ ಅವ್ರು ದೊಡ್ಡಪ್ಪ ಅವ್ರು ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಕ್ ಹೋಗಿದ್ರೆ ಮತ್ತೆ ಇಲ್ಲಿ ಏನು ರಂಗಸ್ವಾಮಯ್ಯ ಇದ್ರೆ ಅವ್ರು ಅನಕ್ಷರ ಇ ಇವರ ಅನ್ನೋದು ರಂಗಸ್ವಾಮಯ್ಯ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡೋ ಅನಕ್ಷರ ಇ another side due.
Where are the RTC is showing reflecting the name of
please, your honor. When the all MR please, my lordship, Madhya is the grandfather of the petitioners.
Where is the RTC is reflecting his name?
My lordship,
mutation entry annexure F ಏನದು?
annexure F 79/1991, my lordship. That is the MR MR in the name of the Rangswamaya before sell the land. ಇಲ್ಲಿ ಅನೆಕ್ಷರ್ ಈ ಏನಿದೆ ಸ್ವಾಮಿ, ಅದನ್ನ ಸೇಲ್ ಮಾಡೋದಕ್ಕೆ ಮುಂಚೆ ಆಗಿರೋ MR ಸ್ವಾಮಿ, ಅವ್ರಿಗೆ ಪಾವತಿ ಖಾತೆ. ಆ MR ಆದ್ಮೇಲೆ ನಮಗೆ ಸೇಲ್ ಮಾಡಿದ್ರೆ ಅನೆಕ್ಷರ್ ಈ ಪ್ರಕಾರ.
ಹೆಂಗ್ annexure F is not the mutation entry in favor of Madhya. It is something else.
My vendor MR, my lordship, he is my vendor. 79
Madhya ಅವರು ಪ್ರಾಪರ್ಟಿ ತಗೊಂಡ್ಮೇಲೆ ಅವ್ರ ಹೆಸರು ಯಾಕೆ ಎಂಟ್ರಿ ಮಾಡಿಸ್ಕೊಂಡಿಲ್ಲ?
ಸ್ವಾಮಿ ಅದು ಅವ್ರು ಸ್ವಲ್ಪ ಇಲ್ಲಿಟ್ರೇಟ್ ಹಿಂಗಾಗಿ ರೆವಿನ್ಯೂ ಎಂಟ್ರೀಸ್ ಮಾಡ್ಕೊಂಡು
ಅವರು ಹಂಗೆ ಹೇಳ್ತಾ ಇದಾರೆ, ನೀವು ಹಂಗೆ ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರು ಅಲ್ಲ ಸ್ವಾಮಿ, ಇಲ್ಲಿ 79/19
suit invoice 313 of 2013.
That is dismissed by the court below, Your Honor. That is filed by the Ransamaya LRS.
No. It is filed by Maranna.
How Swami? Ransamaya Magane Maranna.
Shivanna.
How Swami? Ransamaya
Rangaswamanna.
How Swami? Ransamaya Magane file ಮಾಡಿದ್ದು. ಅದು ವಜಾ ಆಗಿದೆ ಸ್ವಾಮಿ. ಅವ್ರ ಪಾರ್ಟಿಷನ್ ಕೇಳಿದ್ರು, ಇಲ್ಲ ಸೇಲ್ ಡೇಟ್ ಆಗಿದೆ ಆಲ್ರೆಡಿ ಅಂತ ವಜಾ ಆಗಿದೆ. ಅದು ಪಿಟಿಷನರ್ ಫೇವರ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
You are not a party in the proceedings.
ಆ ಪಾರ್ಟಿ ಸ್ವಾಮಿ, ನಾವು ಪಾರ್ಟಿನೇ, ನಮ್ಮ ಫೇವರ್ ಅವ್ರ ವಜಾ ಆಗಿದೆ ಸ್ವಾಮಿ. ಅವ್ರ ಸುಟ್ಟು ನಾವು ಪಾರ್ಟಿನೇ ಅದರಲ್ಲಿ.
ಎಲ್ಲಿದೆ? ಏನ್ ಹೆಸರು?
ಪಾಂಡ್ರಂಗಯ್ಯ ಅಂಡ್ ರಂಗಯ್ಯ ಅಂತ ಇದೆ ನೋಡಿ ಸ್ವಾಮಿ. ಮೈ ಫಾದರ್ ನೇಮ್
ರಂಗಯ್ಯ, ಡೆಡ್ ಬೈ ಮದ್ದಪ್ಪ.
ಪ್ಲೀಸ್ ಯುವರ್ ಆನರ್, ಮದ್ದಪ್ಪ is the father of the ರಂಗಯ್ಯ. ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್ಶಿಪ್. ಡಿಫೆಂಡ್ ನಂಬರ್ 3, ರಂಗಯ್ಯ, ಡೆಡ್ ಬೈ LRS ಮದ್ದಪ್ಪ.
ಡಿಕ್ಲರೇಷನ್ ಅಂಡ್ ಪಾರ್ಟಿಷನ್.
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್ಶಿಪ್. ಅದೇ ಅವ್ರು ಮತ್ತೆ ನಮಗೆ ಮಾರಿದ್ಮೇಲೆ ಮತ್ತೆ ಪಾರ್ಟಿಷನ್ ಹಾಕಿದ್ವಿ ಸ್ವಾಮಿ. ಅದು ವಜಾ ಆಗಿದೆ. ನೀವು ಮಾರಿದಿರ ಲ್ಯಾಂಡ್, ಅದರಿಂದ ಪಾರ್ಟಿಷನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಅಂತ ವಜಾ ಆಗಿದೆ ಸ್ವಾಮಿ. ಅವ್ರು ಬೇಕಂತಾನೆ ಫಾಲ್ಸ್ ಈ ತರ ಒಂದೊಂದೇ ಆಗ್ತಾ ಬರ್ತಾರ ಸ್ವಾಮಿ. ಅದ್ ಫಾಲ್ಸ್ ಸೂಟ್ ಹಾಕಿದ್ರು, ಅದು ವಜಾ ಆಯ್ತು. ಇಲ್ಲಿ AC ಮುಂದೆ ಒಂದು ಅರ್ಜಿ ಕೊಡ್ತಾರೆ ಸ್ವಾಮಿ. ನಮ್ದು MR ನಂಬರ್ 79 ಪ್ರಕಾರ ನಮ್ಗೆ 2 ಎಕರೆ ಬಂದಿತ್ತು ಅಂತ ಸುಳ್ಳು ಕೊಡ್ತಾರೆ. ಬಟ್ ಆದ್ರೆ ಬಂದಿರೋ 4 ಎಕರೆ ಸ್ವಾಮಿ. ಅವ್ರಿಗೆ 4 ಎಕರೆ ನಮ್ಗೆ ಮಾರಿದ್ದಾರೆ. ಅಲ್ಲೂ ಮಿಸ್ಲೀಡ್ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ. ಅಲ್ಲೇನೋ AC ಮುಂದೆ ಅಡ್ವೊಕೇಟ್ಗೆ ಕೇಸ್ ಕೊಟ್ಟಿದ್ರು ಸ್ವಾಮಿ. ಅವ್ರೇನೋ ಅಪೇರ್ ಆಗಿಲ್ಲ, ಇವ್ರು ಗೊತ್ತಾಗಿಲ್ಲ, ಕೊಟ್ಟಿದ್ರೆ ಸುಮ್ಮನೆ ಡೈಲಿ ಹೋಗಿ ಬಂದಿದ್ದಾರೆ. ಅದು ಎಕ್ಸ್ಪರ್ಟ್ ಆರ್ಡರ್ ಆಗಿದೆ AC ಮುಂದೆ. ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿ DC ಮುಂದೆ ನಾವು ಅಪೀಲ್ ಹಾಕ್ತಿವಿ. ಎಲ್ಲ ಸೇಲ್ ಡೀಡ್ ಎಲ್ಲ ಹಾಕಿದ್ರು ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಪ್ರೋಚ್ ಆಗಿ ಅಂತ ಹೇಳ್ತೀವಿ. ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲ ಆಲ್ರೆಡಿ ನಮ್ ಫೇವರ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ವಜಾ ಆಗಿದೆ ಅವ್ರ ಕೇಸು 313. ಸೇಮ್ ಪಾರ್ಟೀಸ್ ಹ್ಯಾವ್ ಬೀನ್ ಫೈಲ್ಡ್ ಅಗೇನ್ಸ್ಟ್ ಪಿಟಿಷನರ್ಸ್. ಎಂಟೈರ್ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆಗಿದೆ ಸ್ವಾಮಿ. ಎಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ ಬೋಸ್ ಎವಿಡೆನ್ಸ್ ಆಗಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆಗಿರೋ ಜಡ್ಮೆಂಟ್ ಅದು.
ಎಲ್ಲಿ ವೆರಿ ದಟ್ ರೆಫರೆನ್ಸ್ ದಟ್ ಸೇಲ್ ಡೀಡ್?
Please my lordship. Now, prayed for declaration of the sale deed.
Where is the reference to the sale deed under which you are claiming title?
Please my lordship. Mark ಆಗಿದೆ ಡಾಕ್ಯುಮೆಂಟ್ ನೆಕ್ಸ್ಟ್ ಬೇಕಾದ್ರೆ ಮಾರ್ಕಿಂಗ್ ಡಾಕ್ಯುಮೆಂಟ್ ನಮ್ಮ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀವಿ ಸ್ವಾಮಿ.
66ನೇ ಇಸ್ವಿ 1966.
One day sale deed is 1966. Another sale deed is 1997 my lordship. ಇಲ್ಲಿ ಇವ್ರು ಏನ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಏನಿದ್ರೆ ರಂಗಸ್ವಾಮಯ್ಯ, ಅವರು ಎಲ್ಲ ರಂಗಸ್ವಾಮಿ ಬರ್ಕೊಟ್ಟಿರೋದು 1997 ಸ್ವಾಮಿ. ಇಲ್ಲಿ ಇಬ್ರು ಸ್ವಾಮಿ ಲ್ಯಾಂಡ್. ಅವ್ರದ್ದು ರಂಗಸ್ವಾಮಯ್ಯ ಅವ್ರಿಗೆ ದೊಡ್ಡಪ್ಪನ್ಗೆ ಮಕ್ಳಿರ್ಲಿಲ್ಲ, ಸಿದ್ದಯ್ಯನ್ಗೆ, ಅವರು ಸಪರೇಟ್ ಮಾಡಿದ್ರೆ. ಅದು 1967 ಸೇಲ್ ಡೀಡ್. ಅವ್ರಿಗೆ ಮಕ್ಳಿರ್ಲಿಲ್ಲ. ಇವ್ರು ಏನ್ ರಂಗಸ್ವಾಮಯ್ಯ ಏನ್ ಮಾಡಿದ್ರೆ ಅದು 97 ಸ್ವಾಮಿ. ಅವ್ರು ಎರಡು ಮಿಸ್ಲೀಡ್ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ. 2 ಎಕರೆ ಆಕ್ಚುಲಿ ಸಿದ್ದಯ್ಯ ಅವರ ದೊಡ್ಡಪ್ಪಂದು, ಅವ್ರ ಮಕ್ಳಿರ್ಲಿಲ್ಲ, ಮಾರೋಗಿದ್ದಾರೆ. ಇಲ್ಲಿ AC ಮುಂದೆ ಕೊಡ್ಬೇಕಾದ್ರೆ ಆ 2 ಎಕರೆ ಅಂತ ಮಿಸ್ಗೈಡ್ ಮಾಡ್ಕೊಡ್ತಾರೆ ಸ್ವಾಮಿ. 79 ಅಲ್ಲ, 2 ಎಕರೆ ನಮಗ್ ಬರ್ಬೇಕಾಯ್ತು ಪಾವತಿ ಖಾತೆ, ಇವ್ರು ಮಾಡಿಸ್ಕೊಂಡಿದ್ರು ಅಂತ ಮಿಸ್ಗೈಡ್ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ.
Anyway, what is the use of staying these two orders?
My lordship, they have
do not get any benefit.
No, my lordship, they have given the application for changing the revenue entries before the Tahsildar.
Sir, by staying these 2 orders, what is the benefit you are going to get?
ಅಲ್ಲ ಸ್ವಾಮಿ, ರೆವಿನ್ಯೂ ಎಂಟ್ರೀಸ್ ಅವ್ರು ಮ್ಯೂಟೇಟ್ ಮಾಡಿ ಅಂತ ನಮ್ಮ ಹೆಸರಿಗೆ ಮಾಡಿ 2 ಎಕರೆ ಅರ್ಜಿ ಕೊಡ್ತಾರೆ.
ವಾಟ್ ಇಸ್ ದಿ ಯೂಸ್ ಆಫ್ ಇದು ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಆರ್ಡರ್ ಏನಿದೆ?
ಅದೇ ಸ್ವಾಮಿ, ಖಾತೆ ಮಾಡಿ ಅವ್ರಿಗೆ ಅಂತ ಮಾಡಿದ್ದಾರೆ. 2 ಎಕರೆ ಅವ್ರಿಗೆ ಖಾತೆ ಮಾಡಿ ಅಂತ ಮಾಡಿದ್ದಾರೆ. ನಮ್ಮ ಹೆಸರು ಲ್ಯಾಂಡ್ ಅವ್ರ ಹೆಸರಿಗೆ ಖಾತೆ ಮಾಡಿ ಅಂತ. ಖಾತೆ ಹಾಕ್ಬಿಡುತ್ತೆ ಸ್ವಾಮಿ.
That is by way of inheritance.
ಅಲ್ಲ, ಇನ್ಹೆರಿಟೆನ್ಸ್ ಅವ್ರು ಮಿಸ್ಗೈಡ್ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ. ಅವ್ರು ಏನಾಗಿದೆ, MR number 79 bar 1990.
Earlier, their father's name is standing in the RTC.
Please, my
And
lordship,
after
that is also.
his death, they have filed an application seeking
my
entry
lordship.
by way of inheritance.
No, my lordship. The MR number 79 with respect to the land which sold in the 1997 by the Ransomaya. Our age 79 MR ಹೇಳ್ತಾರೆ. Alleged MR is not stated properly. They are misstated.
1 to 4. Issue notice to response number 4 to.
Please, my lordship, ಅಲ್ಲಿ ಏನಾಗಿದೆ ಖಾತೆಗೆ ಹೋಗಿದೆ ಸುಮ್ಮನೆ kindly stay the orders.
Petitioners is directed to serve a copy of the writ petition along with annexures on the learned HCD. Full stop. Next para. Learned counsel for the petitioner submits that the fourth respondent, Rangasamaya, filed an appeal before the Assistant Commissioner in RRT bracket A bracket G close 70 of 2014. Seeking directions to the Tahsildar to enter his name in the land records. Alleging that the petitioner herein got his name entered in the RTC while giving false information. That the petitioner is no more giving false information that the appellant therein is no more, and on the basis of a false genealogical tree, the petitioner herein has got his name entered in the land records. Full stop. The Assistant Commissioner allowed the appeal while noticing that the petitioner herein remained absent, although notice was issued to him. Full stop. Consequently, a direction has been issued by the Assistant Commissioner to the Tahsildar to enter the name of the fourth respondent on the basis of inheritance, and that he acquired the property under a will. Full stop. Learned counsel submits that the Deputy Commissioner also rejected the revision petition filed by the petitioner, although it was brought to his notice that the petitioner's uncle, bracketally, father's elder brother, had purchased the land in question under a registered sale deed dated 28/11/1966. ಅಲ್ಲ ಮದ್ದಯ್ಯ ಅನ್ನೋದು ಯಾರ್ರಿ? ಮದ್ದಯ್ಯ ಅನ್ನೋದು ಯಾರು?
grandfather of the petition of my lordship.
Grandfather,
Petitioner grandfather, my lordship. Also,
uncle alla. The petitioner's grandfather, Sri Mattaya had purchased the land in question under registered dated, sale deed dated so and so from the uncle bracket ಅಲ್ಲಿ uncle of respondent number 4 herein. However, the deputy commissioner is of the opinion that if the petitioner's grandfather had purchased the land in question under registered sale deed date of the year 1966, nevertheless, his name was never entered in the RTC. And therefore, the claim of the petitioner herein becomes a disputed question of title, and therefore the petitioner has to approach the competent civil court. Full stop. Learned counsel further submits that the fourth respondent's children had filed OS number 313 of 2013. ಅದು ಈ ಪ್ರಾಪರ್ಟಿ ಅಲ್ವೇನ್ರಿ ಅದು?
ಅಲ್ಲ, ಏನಾಗಿದೆ ಸ್ವಾಮಿ, ಅದು 79 ಅಲ್ಲ, ಆಕ್ಚುಲಿ ಇವ್ರ ಶೇರ್ 4 ಎಕರೆ 26 ಗುಂಟೆ ಬರುತ್ತೆ ಸ್ವಾಮಿ. ಅವ್ರು ಮಿಸ್ಗೈಡ್ ಮಾಡ್ತಾರೆ. 79 ಅಲ್ಲಿ ನಮಗೆ ಬಂದಿತ್ತು ಅವ್ರ ದೊಡ್ಡಪ್ಪನ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಮಿಸ್ಗೈಡ್ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ. ಆಕ್ಚುಲಿ 79/1991 MR ಅಲ್ಲಿ ಬಂದಿರೋದು ರಂಗಸ್ವಾಮಯ್ಯ ತಂದೆ ಪ್ರಾಪರ್ಟಿ ರಂಗಸ್ವಾಮಯ್ಯ ಬರುತ್ತೆ. ಅದು ನಮಗೆ ಮಾರಿದ್ದಾರೆ 1997 ಅಲ್ಲಿ. ಅದು ಎಂಟೈರ್ 4 ಎಕರೆ 26 ಗುಂಟ ಮಾರಿದ್ದಾರೆ. ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂಗೆ ಪಾರ್ಟಿಷನ್ ಸೂಟು ಹಾಕ್ತಾರೆ, ಅವ್ರ ಮಕ್ಳು ಹಾಕ್ತಾರೆ. ರಂಗಸ್ವಾಮಯ್ಯ ಇಸ್ ಒನ್ ಆಫ್ ದಿ ಡಿಫೆಂಡೆಂಟ್ ಇನ್ ದಟ್ ಸೂಟು. ವಜಾ ಆಗುತ್ತೆ ಸ್ವಾಮಿ ಮಿನಿಟ್ಸ್ ಮೇಲೆ. ಅವರು MR ನಂಬರ್ 79 ಟ್ಯಾಗ್ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ ಅವ್ರ ದೊಡ್ಡಪ್ಪನ ಜಮೀನ್ಗೆ. ಅವ್ರ ದೊಡ್ಡಪ್ಪನ ಜಮೀನ್ಗೂ MR ನಂಬರ್ 79/1991 ಸಂಬಂಧನೇ ಇಲ್ಲ. MR ನಂಬರ್ 79 ಆಗಿರೋದು 4 ಎಕರೆ 26 ಗುಂಟೆಗೆ ಸ್ವಾಮಿ. 2 ಎಕರೆ 6 ಗುಂಟೆಗೆಲ್ಲ MR ಅದು. ಬಟ್ ಅದು AC ಮುಂದೆ ಮಿಸ್ಲೀಡ್ ಮಾಡ್ತಾರೆ. ಒಂದ್ ಪೇಜ್ ಅಪ್ಲಿಕೇಶನ್ ಬರ್ಬಿಟ್ಟು ಮಿಸ್ಲೀಡ್ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ. ನಾವ್ ಎಲ್ಲಾ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟರು DC ಮುಂದೆ ಕನ್ಸಿಡರ್ ಮಾಡ್ಲಿಲ್ಲ ಸ್ವಾಮಿ.
Seeking declaration and partition while arraigning the petitioner herein as defendant number 3 Rangayya. ಏನ್ರಿ ಈ ತರ ಎಲ್ಲ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಬರೀತಿರಲ್ರಿ ನೀವು? How can you file the petition in the name of Rangayya who is dead? ಏನಾಯ್ತ್ರಿ? For defendants number 4 and 5, arraigning the petitioners herein as defendants number 4 and 5. Full stop. However, the said suit was dismissed by a judgment dated 23rd of December 2021. Full stop. Next para. It is not clear as to whether the contesting respondents have filed any appeal questioning the said judgment. Full stop. No, or Burl.
Preliminary. Serial number 7, party in person. N Murthy.
Respondent ಕೂಡ ಬರಬೇಕು.
ಹಾ?
Respondent ಬರಲ್ಲ, ನಮ್ಮ ಚಿಕ್ಕಪ್ಪ ಅವರು ಬರಬೇಕು.
ಜಾಯಿಂಟ್ ಪರ್ಚೇಸ್ ಪ್ರಾಪರ್ಟೀಸ್.
ಸರ್ ಜಾಯಿಂಟ್ ಪರ್ಚೇಸ್ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಇವಾಗ ಹೇಳ್ತಾರೆ, ತಂದೆ ತಾಯಿ ಖರೀದಿ ಮಾಡಿದ್ದು ಅಂತ ಪತ್ರಗಳಲ್ಲಿ ಬರೀತಾರೆ. ಸುಳ್ಳು ಸರ್, ಪ್ರತಿ ಸಲ ಬಂದಾಗ ಕೋರ್ಟಲ್ಲಿ ಒಂದು ಸುಳ್ಳು ಹೇಳ್ತಾರೆ. ತಂದೆ ತಾಯಿ ಖರೀದಿ ಮಾಡಿದಂತ ಆಸ್ತಿ ಅಂತ ಮೈನ್ ಪಾಯಿಂಟ್ ಆಗ್ತಾರೆ. ಮತ್ತೆ ನೋಡಿದ್ರೆ ಜಾಯಿಂಟ್ ಪ್ರಾಪರ್ಟಿ ಅಂತಾರೆ. ಮತ್ತೆ ಕೇಳ್ಬೇಕಿತ್ತು, ತಂದೆ ತಾಯಿ ಮಾಡಿದ ಪ್ರಾಪರ್ಟಿ ಆಗಿದ್ರೆ 40 ವರ್ಷ ಆದ್ಮೇಲೆ ಬಂದು ಸುಮ್ನೆ ಕೇಸ್ಗಳು ಹಾಕೊಳ್ತಾ ಬರ್ತಾರೆ.
ನಾನ್ ಕೇಸ್ ಹಾಕಿಲ್ಲ.
ಒಂದು ನಿಮಿಷ.
ಜಾಯಿಂಟ್ ಪ್ರಾಪರ್ಟಿ ಸರ್, ಇಟ್ ಇಸ್ ಪೇಜ್ ನಂಬರ್ 7
ಅಲ್ಲಿ ಒಂದ್ ಹೇಳಿ, ಇಲ್ಲಿ ಒಂದ್ ಹೇಳಿ.
of my reply statement. They look into the purchase bill.
ನೋಟಿಸ್ ಆರ್ಡರ್ ಇಲ್ಲ, ಹೆಂಗ್ರಿ ಬಂದು ಇವರು?
ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಸರ್,
ಹಾ?
ಗೊತ್ತಿಲ್ಲ, ಅವರೇ ಬಂದಿದ್ದಾರೆ.
ನಿಮ್ಗೆ ಹೆಂಗ್ ಗೊತ್ತಾಯ್ತು ಇದು ಫೈಲ್ ಮಾಡೋದು ಪಿಟಿಷನ್?
ಇವರು ಹೇಳಿದ್ರು ನನಗೆ.
ಅವರೇ ಹೇಳಿದ್ರಾ?
ಹೌದು ಸರ್. ಅಲ್ಲ, ಈ ಕೇಸ್ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ.
ಮಾಡಿದ್ದೆ ಸರ್.
ಅದಂಗೆ
ಇವರು ಅಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು ಜಮೀನಲ್ಲಿ
ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿಲ್ಲ ಕೋರ್ಟ್ ಇಂದ.
ಜಮೀನಲ್ಲಿ ಕಲ್ಲು ಉಳಿಸ್ತಾ ಇದ್ರು, ಅದಕ್ಕೆ ಇಲ್ಲ ನಾನು ಇದನ್ನ ಕೋರ್ಟ್ ಹಾಕಿದ್ದೀನಿ ಅಂತ ಹೇಳಿ.
ಅಲ್ಲ, ಕೋರ್ಟ್ ಹಾಕಿದ್ರೆ ಕೋರ್ಟ್ ಹಾಕಿದ ಮಾತ್ರಕ್ಕೆ ನೋಡಿ ಸರ್, 11 ಈ ಸ್ಕೆಚಿಂಗ್ ನಾನು ಅಪ್ಲೈ ಮಾಡಿದೆ. ADLR ಕಡೆಯಿಂದ ಈ ಕೇಸ್ ಕೋರ್ಟ್ ಮಾಡ್ಬಿಟ್ಟು ರಿಜೆಕ್ಟ್ ಮಾಡಿಸ್ತಾ ಇದ್ದಾರೆ.
ಒಂದ್ ನಿಮಿಷ.
ನಾನು ಕೋರ್ಟ್ನಲ್ಲಿ ಕೇಸ್ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ, ದಯವಿಟ್ಟು ಇದನ್ನ ಗಮನ ತಗೊಳ್ಳಿ ಅಂತ ನಾನು ಹೇಳಿದ್ದೆ.
ಅದಕ್ಕೆ ನಾನು ರಿಪ್ಲೈ ಸ್ಟೇಟ್ಮೆಂಟ್ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ.
Annexure B.
Annexure B is the DC court order, in which you can see the point number 6, sir. It is contended on behalf of first respondent that the land in question
Against the order dated 7/1/2014. Passed by the Assistant Commissioner, huh?
Yes.
Huh? Where is that order? Assistant Commissioner order ಇದೆ?
Commissioner order.
ನೀವು ರಿವಿಷನ್ ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡಿದ್ದು ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಆರ್ಡರ್ ಕ್ವಶನ್ ಮಾಡಿ.
ಇಲ್ಲ ಸರ್, DC ಅವರ ಆರ್ಡರ್.
ರೀ, ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಮುಂದೆ ಕ್ವಶನ್ ಮಾಡಿದ್ದೇನು? ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ? ಆರ್ಡರ್ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಪಾಸ್ ಮಾಡೋ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ?
That is Annexure B.
ನಂದು ರಿಪ್ಲೈ ಸ್ಟೇಟ್ಮೆಂಟ್.
ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಮುಂದೆ ನೀವು ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಆರ್ಡರ್ ಅವ್ರು ಕ್ವಶನ್ ಮಾಡಿದ್ರಲ್ಲ, ಅದ್ರ ಕಾಪಿ ಎಲ್ಲಿದೆ?
ಬರೀ DC ಅವರ ಆರ್ಡರ್ ಅಷ್ಟೇ ಹಾಕಿದ್ದೀನಿ ಸರ್.
ಯಾಕೆ ನಾವು ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಆರ್ಡರ್ ನೋಡೋದು ಬೇಡವಾ?
ಕಮಿಷನ್ ಆರ್ಡರ್ ಇದ್ದಾರೆ.
ಎಲ್ಲಿ ಅದನ್ನ ಕೇಳ್ತಾ ಇರೋದು?
That is Annexure G.
Annexure G.
Annexure G and Annexure F.
ಏನ್ ಪೇಜ್ ನಂಬರು?
Page number 43 to 45, 46 to 48. ಸ್ವಲ್ಪ ವೇರಿ ಆಗಿದೆ.
ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ Annexure G. ನೀವು ಫೈಲ್ ಮಾಡಿದ ಅಪೀಲ್ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಮುಂದೆ.
ಹೌದು ಸರ್.
ಹಾ?
ಹೌದು ಸರ್.
ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಂಡು?
ಅದೇ
MR ನಂಬರ್ 14/2001.
ಎಸ್ ಸರ್.
ಅದನ್ನ ಕ್ವಶನ್ ಮಾಡ್ಕೊಂಡು 2017 ಇಸ್ವಿಯಲ್ಲಿ ಅಪೀಲ್ ಆಗ್ತೀರಾ?
ಹೌದು ಸರ್.
ಹಾ,
ಅವರು ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರು ಇದು
ಏನು ಕಂಟೆನ್ಷನ್ ನಿಮ್ದು?
ಇದು ಜಾಯಿಂಟ್ ಪರ್ಚೇಸ್ ಡಿಡಿ ಇದು. ಅವರಪ್ಪ ಒಬ್ಬರ ಹೆಸರಿಗೆನೆ
ಬೈಲಪ್ಪ ಅವ್ರ ಹೆಸರಲ್ಲಿ ಖಾತೆ ಆಗಿತ್ತಾ?
ಖಾತೆ ಒಬ್ಬರ ಹೆಸರಿಗೆನೆ
MR ನಂಬರ್ 14/2001 ಪ್ರಕಾರ
ಅದು ಅವರೊಬ್ಬರ ಹೆಸರಿಗೆ ಮಾಡಿಸ್ಕೊಂಡು.
No sir. Property purchase
ಸ್ವಲ್ಪ ಇರ್ರಿ.
ಪ್ರಾಪರ್ಟಿ
ಹಾ,
ಪರ್ಚೇಸ್
ಏನ್ ಕಂಟೆನ್ಷನ್ ನಿಮ್ದು ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಮುಂದೆ?
ಅದು ಜಾಯಿಂಟ್ ಪರ್ಚೇಸ್ ಡೀಡ್ ಆದ್ರಿಂದ ನನಗೂ 50 ಜಾಯಿಂಟ್ ಪರ್ಚೇಸ್ ಡೀಡ್ ಆದ್ರಿಂದ
ಪರ್ಚೇಸ್
ಜಾಯಿಂಟ್ ಪರ್ಚೇಸ್
ಯಾರು?
ಮೀ ಅಂಡ್ ಮೈ ಬ್ರದರ್ ಸರ್.
ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್?
ಡಾಕ್ಯುಮೆಂಟ್ ಮೈ ರಿಪ್ಲೈ ಸ್ಟೇಟ್ಮೆಂಟ್
ಎಲ್ಲ ಈ ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್ ಕೆಳಗಡೆ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ರಿ?
ಅದೇ ಸರ್, ಮೈ ರಿಪ್ಲೈ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆ, ಅದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 7 ಪರ್ಚೇಸ್ ಡೀಡ್.
Annexure A.
Annexure A. Annexure A ನಾ
ಸೇಲ್
ಅವ್ರದ್ದು? ಅವ್ರ ಸೇಲ್ ಡೀಡಾ?
ಅಲ್ಲ,
ಪರ್ಚೇಸ್ ಡೀಡ್.
ಹಾ?
ನನ್ನ ಫೈಲ್
Annexure A 3/6/1980 ಸೇಲ್ ಡೀಡ್. ಹಾ, ಯಾರ್ಯಾರು ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದು?
ಎ ಪುಟ್ಟಬೈಲಯ್ಯ ಅಂಡ್ ಹನುಮಂತರಾಜು ಸರ್.
ಒಂದನೇ ಮಗ ಪುಟ್ಟ ಬೈರಯ್ಯನಿಗೆ ಮತ್ತು ಎರಡನೇ ಮಗ ಮೈನರ್ ಹನುಮಂತರಾಜು.
ಎಸ್ ಸರ್.
ಅಲ್ಲಿ ನಮ್ಮ ತಂದೆಯವ್ರನ್ನ ಇವರು ಮೈನರ್ ಗಾರ್ಡಿಯನ್ ಅಂತ ತಗೊಳ್ತಾರೆ
ಹಾ?
ಪತ್ರದಲ್ಲಿ. ಆದ್ರೆ ತಂದೆ ತಾಯಿ
ಹನುಮಂತರಾಜು.
ಎಸ್ ಸರ್.
ಹನುಮಂತರಾಜು ಯಾರು?
ನಾನು ಸರ್.
ನೀವು.
ಹ್ಮ್.
ಪುಟ್ಟ ಬೈರಯ್ಯ ಯಾರು?
ನಮ್ಮ ತಂದೆ
ನಿಮ್ ತಂದೆ.
ಹೀರೋ
ಇವ್ರೇನಾಗ್ಬೇಕು ನಿಮ್ ತಂದೆಗೆ?
ನಮ್ಮ ತಂದೆಗೆ ಅವ್ರ
ತಮ್ಮ. ಹಾ, ಇಬ್ಬರ ಹೆಸರಲ್ಲೂ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದಾರೆ.
ಮೈನರ್ ಅವ್ರು ಮೈನರ್ ಸರ್. ಮೈನರು ನಮ್ಮ ತಂದೆಯವ್ರನ್ನ ಮೈನರ್ ಗಾರ್ಡಿಯನ್ ಅಂತ ಹಾಕ್ಸ್ಕೊಳ್ತಾರೆ. ನಮ್ಮ ತಂದೆಯವ್ರಿಗೆ ಹೇಗೆ ಮೈನರ್ ಗಾರ್ಡಿಯನ್ ಆಗ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ?
ಅದನ್ನ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಮುಂದೆ ಕ್ವಶನ್ ಮಾಡಕ್ ಆಗಲ್ಲ. ಅವೆಲ್ಲ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಸೈಡ್ ಆಗ್ಬೇಕು. ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಅವ್ರ ಹೆಸರು ಇದೆ, ನಿಮ್ ತಂದೆಯವ್ರ ಹೆಸರು ಇದೆ, ಆದ್ರಿಂದ ಇಬ್ಬರ ಹೆಸರು ಖಾತೆಯಲ್ಲಿ ಇರ್ಬೇಕು. ನಿಮ್ಗೆ ನಿಮ್ ತಂದೆಯವ್ರು ಮಾತ್ರ ಸಪರೇಟ್ ಆಗಿ ಪ್ರಾಪರ್ಟಿ ಬರುತ್ತೆ ಅಂತ ನೀವ್ ಹೇಳಕ್ ಬರೋದಿಲ್ಲ. ಅದನ್ನ ಡಿಸೈಡ್ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಹೋಗ್ಬೇಕು.
ನಮ್ಮ ತಂದೆಯವರೇ
ಈಗ ಆತರ ಆರ್ಡರ್ ಮಾಡಿದಾರಾ ಡೆಪ್ಟಿ ಕಮಿಷನರ್?
ತಹಶೀಲ್ದಾರ್
ಏನಂತ ಮಾಡಿದಾರೆ ಡೆಪ್ಟಿ ಕಮಿಷನರ್?
ಅದನ್ನ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ದಾರೆ. ತಹಶೀಲ್ದಾರ್ ಮಾಡಿ
ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ಇಬ್ಬರ ಹೆಸರು ಇರ್ಲಿ ಅಂತ ಮಾಡಿದಾರಾ?
ಇಬ್ಬರ ಹೆಸರು ಇರ್ಲಿ ಅಂತ
ಹೋಗಿದ್ದಾರೆ.
ಸಿವಿಲ್ ಕೋರ್ಟ್ ಹೋಗಿದ್ದಾರೆ.
94 ಅಲ್ಲಿ ಸಿವಿಲ್ ಕೋರ್ಟ್ಗೆ ಇವರೇ ಅಪೀಲ್ ಮಾಡಿ
2014 ಅಲ್ಲ
94 ಅಲ್ಲಿ ಇವರೇ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಪ್ರೋಚ್ ಮಾಡ್ತಾರೆ ಸರ್. ಆ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಇವರು ಅಪಿಯರೇ ಆಗಲ್ಲ, ಅಲ್ಲಿ ಕೇಸ್ ಕ್ಯಾನ್ಸಲ್ ಆಗುತ್ತೆ,
ಡಿಸ್ಮಿಸ್ ಆಗ್ಬಿಡುತ್ತಾ?
ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಇವ್ರಪ್ಪ ಬಂದು ಅಲ್ಲಿ ಏನೋ ಒಂದು ಲಾಬಿ ಮಾಡ್ಬಿಟ್ರು ಸರ್. ಇವ್ರಪ್ಪ
ಮಾಡಿಲ್ಲ ಸರ್.
ನಮ್ ತಂದೆ ತಾಯಿನ
ಕೋರ್ಟ್ ಕರೆದಿದೆ, ಇವರು ಪ್ರೆಸೆಂಟೇ ಆಗಿದೆ.
ನಮ್ ತಾಯಿನ ಅಪ್ರೋಚ್ ಮಾಡ್ಬಿಟ್ರು ಕೇಸ್.
ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? ಇವಾಗ ಸೂಟ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ, ನೀವ್ ಫೈಲ್ ಮಾಡಿ ಸೂಟು ಡಿಸ್ಮಿಸ್ ಆಯ್ತು. ಆಮೇಲೆ ಮಿಸ್ಲೇನಿಯಸ್ ಪೆಟಿಷನ್ ಹಾಕೊಂಡಿದೀರಾ,
ಪ್ರಾಸಿಕ್ಯೂಷನ್
ಅದು ಡಿಸ್ಮಿಸ್ ಆಯ್ತು.
ಎಲ್ಲಿ ಸರ್?
ಮಿಸ್ಲೇನಿಯಸ್ ಪೆಟಿಷನ್
ಅದನ್ನ ಅದು ಫಾರ್ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಆಗಿದ್ರಿಂದ
ಅದು ಡಿಸ್ಮಿಸ್ ಆಯ್ತು.
ಡಿಲೇಗೋಸ್ಕರ ಡಿಸ್ಮಿಸ್.
ಏನ್ ಮಾಡೋದು?
ಡಿಲೇ ಆಗಿದೆ.
ಸೊ ಅದನ್ನ ಬಂದು ಇಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿದೆ. ಹೈಕೋರ್ಟ್ ಡೈರೆಕ್ಟ್ ಮಾಡ್ತಾರೆ, ನೀವು ಡಿ ಸಿ ಮುಂದೆ ಹಾಕೊಳ್ಳಿ ಅಂತ.
ಸರ್ ಹೈಕೋರ್ಟ್
ಎಲ್ಲಿದೆ ಆರ್ಡರ್? ಎಲ್ಲಿದೆ ಅದು?
ಹೈಕೋರ್ಟ್ ಆರ್ಡರ್ ಇದೆ ಸರ್. ಇದು ನನ್ನ ರಿಪ್ಲೈ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಪೇಜ್ ನಂಬರ್ 17 ನನ್ನ ರಿಪ್ಲೈ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಆರ್ಡರ್.
ಎಲ್ಲಿ ರಿಪ್ಲೈ ಸ್ಟೇಟ್ಮೆಂಟ್? ಇನ್ನು ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿಲ್ಲ ನಿಮ್ಗೆ.
ನಾನು
ರಿಪ್ಲೈ ಸ್ಟೇಟ್ಮೆಂಟ್ ಯಾವಾಗ ಫೈಲ್ ಮಾಡಿದ್ರಿ?
ಇದು 23 ನವೆಂಬರ್ 23rd 23.
ಯಾವ್ದು ಡಾಕ್ಯುಮೆಂಟ್ ನಂಬರ್?
ಹೈಕೋರ್ಟ್ ಅನ್ನೆಕ್ಸ್ಟೆಡ್ ಇ ಪೇಜ್ ನಂಬರ್ 17.
ರಿಟ್ ಪೆಟಿಷನ್ ಅದು.
ಸರ್ ರಿಟ್ ಪಿಟಿಷನ್.
ಹ್ಮ್.
ಸೊ ಅವರು ನೀವು ಡಿ ಸಿ ನ ಇದು ಜಂಪ್ ಮಾಡಿ ಬಂದಿದ್ದೀರಾ, ಅದನ್ನ ಡಿ ಸಿ ಮುಂದೆ ಹಾಕೊಳ್ಳಿ, ಇದು ಜಾಯಿಂಟ್ ಪರ್ಚೇಸ್ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಡೈರೆಕ್ಟ್ ಮಾಡ್ತು ನನಗೆ ಹೈಕೋರ್ಟ್.
ಸರ್ ಎರಡನೇ ಬಾರಿ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೇಸ್ ಆಗಿದಾಗ 19 ವರ್ಷ ಡಿಲೇ ಆಗಿದೆ. ಮತ್ತೆ ಇವರು ಅದೇ ವಾದನ ಹೇಳ್ತಾರೆ. ಅದನ್ನ ದಯವಿಟ್ಟು
ನೀವೇ ಅನ್ಯಾಯ ಮಾಡ್ಕೊಂಡಿದೀರ, ನಾವ್ ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
ಅಲ್ಲ ಸರ್, ಈಗ
ಸೂಟ್ ಫೈಲ್ ಮಾಡ್ಬಿಟ್ಟು ಡಿಸ್ಮಿಸ್ ಮಾಡಿಸ್ಕೊಂಡಿದೀರಾ.
ಅದಾಯ್ತಲ್ಲ ಸರ್. ಈಗ ಹೈಕೋರ್ಟ್ ಡೈರೆಕ್ಟ್
ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಏನು ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. ಸಿವಿಲ್ ಕೋರ್ಟ್ ಒಂದ್ಸರಿ ನಿಮ್ ಸೂಟ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ಮೇಲೆ
ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ನಾಟ್ ಆನ್ ಮೆರಿಟ್ಸ್
ಅದನ್ನ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಏನ್ ಮಾಡಕ್ ಬರುತ್ತೆ?
ಮಾಡಿದಾರಲ್ಲ ಸರ್. ಈಗ
ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
ಇಬ್ರೆಸ್ಗೂ ರಿಜಿಸ್ಟ್ರೇಟ್ ಮಾಡಿದಾರಲ್ಲ.
ಪ್ರಶ್ನೆ ಮಾಡಿದ್ದೀನಿ.
ಇಬ್ರೆಸ್ಗೂ ರಿಜಿಸ್ಟ್ರೇಟ್ ಮಾಡಿದ್ದಾರೆ ಸರ್.
ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
ಇಲ್ಲ ಸರ್, ಜಾಯಿಂಟ್ ಪ್ರಾಪರ್ಟಿ ಇದೆ. ಜಾಯಿಂಟ್ ಪರ್ಚೇಸ್ ಪ್ರಾಪರ್ಟಿ ಹೆಂಗೆ?
ಆ ಡಿಕ್ಲರೇಷನ್ ನೀವು ತಗೊಳ್ಳೋದ್ರಲ್ಲಿ ನೀವು ಸೋತಿದ್ದೀರಾ. ಅದ್ರ ಮೇಲೆ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಏನು ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
ಈಗ ನಾನು ಹೇಗೆ ಕ್ಲೈಮ್ ಮಾಡ್ಬೇಕು ಸರ್? ಅದೇ ಎಲ್ಲಿ ಮತ್ತೆ ನಾನು ಸಿವಿಲ್ ಕೋರ್ಟ್
ನೀವು ಅದೇ ಮ್ಯಾಟರ್ನ ನೀವು ಹೆಂಗಾದ್ರೂ ಮಾಡಿ ನೀವು ಒಂದು ಅಪೀಲ್ ಆದ್ರೂ ಹಾಕಿ ಅಥವಾ ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಆದ್ರೂ ಹಾಕಿ ಏನಾದ್ರೂ ಮಾಡಿ ಆ ಜಡ್ಜ್ಮೆಂಟ್ ನ ನೀವು ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿಸ್ಕೊಂಡು ಒಂದು ಎಂಟ್ರಿ ಮಾಡೋರು ತಗೋಬೇಕು. ಡೆಪ್ಟಿ ಕಮಿಷನರು ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಏನು ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
ಸರ್ ಹೈಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ ಒಂದ್ ಸೆಕೆಂಡ್ ಸರ್.
ಅದು ನೀವು ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಮುಂದೆ ಹೋಗೋ ಬದಲು ಡೈರೆಕ್ಟ್ ಆಗಿ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಮುಂದೆ ಹೋಗಿದ್ದೀರಾ ಅನ್ಬಿಟ್ಟು ಅದನ್ನ ಡಿಸ್ಮಿಸ್ ಮಾಡಿ ಮತ್ತೆ ವಾಪಸ್ ನಿಮ್ಮನ್ನ ಕಳ್ಸಿದಾರ ಅಲ್ಲಿಗೆ. ಅದರಿಂದ ಏನು ಪ್ರಯೋಜನ ಇಲ್ಲ. First respondent,
Sir, please,
Mr.
sir.
Hanumantaraju L is present before the court.
Sir.
Learned HCGP takes notice for respondent number 2.
Reports 20.
Next para. The petitioners are aggrieved of
Sir, please.
the
Sir.
impugned order dated
Sir.
21st of February 2022, passed by the Deputy Commissioner, Bangalore Rural District.
Sir, please. Sir, I Court order page number 4, sir. B, that it may be, fact remains that petitioner herein is claiming mutation entry effect in respect of subject land in the strength of sale deed 3680, which could disclose that under the said sale deed, petitioner and his brother, that is first respondent, have purchased the subject property. If it were to be so, entries under the registered sale deed would prevail and authorities are required to act upon it. It is in this ground, petitioner had filed an appeal 31/23 as already observed here in Supra, and same came to dismiss on 7/1/14. Thus, petitioner herein not to have challenged the same, and instead of taking said step, has filed one more appeal, which was rightly dismissed as not maintainable as already observed herein above. Hence, this court is of the considered view that ends of justice would be met if liberty is reserved to the petitioner to challenge the order passed in RA 31 before the jurisdictional deputy commissioner in the manner known to be. Accordingly, disposed by the granting liberty to the file before the RA in all RA 31 of 12/13. All contentions are kept open and no opinion is expressed. And so when the High Court itself has directed me to apply before the DC, I have applied. I have applied.
It is the contention of the petitioners that a suit for declaration filed at the hands of respondent number 1 herein in OS number 51 of 1994 came to be dismissed. Since the plaintiff failed to furnish a copy of the plaint to the defendants. Full stop. A miscellaneous petition filed in miscellaneous number 26 of 2014 was also dismissed
For non-prosecutions, for delay.
on the ground of delay and laches.
Yes,
For 19 years.
delay.
Full stop. However, the first respondent filed an appeal in RA 384 of 2017 challenging mutation entry made in MR number 14 of 2000-2001. Which was already a subject matter of an appeal in RA 31 of 2012-13. Full stop. RA, this court noticed the fact that RA 384 of 2017 was also dismissed by an order dated 15/9/2018 on the ground that the appeal filed earlier in RA 31 of 2012-13 had attained finality, and on the ground of principles of res judicata being applicable, one more appeal under section 136(2) of the Act cannot be filed, and rightly so, and it was therefore held that the orders were rightly passed. Full stop. This court, although did not find any infirmity in the orders passed by the Assistant Commissioner, nevertheless, this court, in order to meet the ends of justice, granted liberty to respond number 1 herein to challenge the order passed in RA 31 of 2012-13 before the jurisdictional deputy commissioner. And consequently, the impugned order has been passed by the deputy commissioner. Full stop. The petitioner party in person, however, submits that when a suit for declaration filed at the hands of respondent number 1 was dismissed, it was impermissible for the deputy commissioner to get into disputed questions of title. Full stop. It is the claim of the first respondent that his elder brother, Shri Puttabailaya, had purchased the land in question under a registered sale deed dated 3/6/1980, along with the second respondent herein, who was then a minor. Full stop.
First respondent.
Along with the first respondent, who was then a minor. Full stop. Next para. Having regard to the undisputed facts narrated herein above, this court is of the considered opinion that the deputy commissioner could not have gone into disputed questions of title. Full stop. A suit for declaration filed at the hands of respondent number 1 herein has been dismissed by the competent civil court. Full stop.
For non-prosecutions.
ಏನೇ ಆಗಿರ್ಬೋದು, ನೀವು ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಂಡು ಹೆಂಗಾದ್ರೂ ನೀವು ಅದನ್ನ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿಸ್ಕೊಂಡು unless you get a declaration at the hands of the civil court, deputy commissioner and assistant commissioner cannot do anything in this matter.
Sir, without issuing the notice to me, Tahsildar has passed this MR 14, sir.
ಅದನ್ನ ಕ್ವಶನ್ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಸರ್, ದಯವಿಟ್ಟು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ. ಫುಲ್ ಬೆಂಚು, ನಮ್ಮ ಫುಲ್ ಬೆಂಚು ಜಯಮ್ಮ ಕೇಸಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ, ಏನಾದ್ರು ಡಿಸ್ಪ್ಯೂಟ್ ಇದ್ರೆ ಟೈಟಲ್ ವಿಚಾರದಲ್ಲಿ ಸಿವಿಲ್ ಕೋರ್ಟ್ ತೀರ್ಮಾನ ಮಾಡಬೇಕು, ಅದನ್ನ ರೆವಿನ್ಯೂ ಅಥಾರಿಟೀಸ್ ತೀರ್ಮಾನ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಅಂತ.
ಸರ್, ಇಟ್ ಇಸ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ ಸರ್, ಜಾಯಿಂಟ್ ಇಬ್ರು ಹೆಸರಲ್ಲೂ ಇದೆ ಅದು, ಇದು ಪರ್ಚೇಸ್ ಡೀಡ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ, ಆದ್ರೂನು ಒಬ್ಬರ ಹೆಸರಿಗೆನೆ.
Decision of the full bench of this court in the case of Jayamma versus State of Karnataka, reported in ILR 2020, Karnataka 1449. Settles the long-standing principle that revenue authorities cannot get into disputed questions of title. Full stop. Therefore, unless and until the first respondent is able to get a declaration at the hands of the competent civil court, the revenue entries shall continue as it was in terms of the earlier mutation order in MR number 14 of 2000-2001. Full stop. Next para. Consequently, the writ petition is allowed. The impugned order dated 21st of February 2022, passed by the deputy commissioner, is hereby quashed and set aside.
If this court was, if this court directed me to go to civil court again to get the declaration, I would have got it by now. But now it should not be stayed, sir. Please, sir. It should not be stayed, please.
I have taken note of the fact that a direction was issued by this court. And that is why the deputy commissioner passed the order.
Yeah.
I have taken note of that.
So if,
Yes.
if this court had directed me to go to the civil court. and
Anbaradilla.
get the
ಹಂಗ್
declaration.
ಬರೋದಿಲ್ಲ. Yes,
ಈಗ ನಾನು ಮತ್ತೆ.
please take legal advice and go do it in accordance with law. Yes.
Serial number 8, Virupakshaya PM.
Like to appear for petitioner, my lord. Petitioner was granted, my lord. And as per Annexure A, by issuing validity.
Huh?
Mutation was also granted. After grant was made in my favor, mutation was also granted and the entry was made. Subsequently, that entry is not reflected in
Computerized article.
computerized art.
Same thing, ಯಾವ್ದಪ್ಪ?
Writ petition 3994 of 22, my lord. 3994 of 22,
Yes.
disposed on 22/2/2022.
Disposed of.
Period, may request for. Period may find.
ಹೇಳಿದೆ.
Serial number 9, Chetan B, 79 AB.
Appearing for petitioners.
ಅದು ಬರ್ಕೊಂಡೇನಮ್ಮ, ಅದು ರಿಟ್ ಪಿಟಿಷನ್ ಅವ್ರು ಹೇಳಿದ್ದು.
Serial number 9,
29 AB.
79 AB.
ಹಾ.
Order of the AC is of 2008.
2008. All right. You appear before the deputy assistant commissioner on 23rd of April.
23rd of March.
serial number 10, Victor Manoharan S.
My lords, petitioner, my lords, had filed the original suit, my lords, seeking specific performance, my lords. And the suit was decreed, my lords. And later, my lords, execution petition was filed. In that execution petition, my lords,
Who filed the suit?
petitioner, my lords.
Ah,
And for specific performance.
Ah.
The suit was decreed, my lords.
ah,
And he did not come forward to execute the sale deed. Therefore, my lords, Annexure A, sale deed in an execution proceedings, my lords, court had executed the sale deed. After that, my lords, he made a representation to the Tahsildar to transfer Khata in his name.
ah.
And that was rejected, my lords. And he had filed a appeal before the Assistant Commissioner, my lords. Page number 20 is the order. And the order portion is at page number 22. He, my lords, again directed the Tahsildar, my lords, to conduct survey of the land and to pass appropriate orders. Page number 22, my lords.
Ah.
And after this, my lords, again, Tahsildar, my lords, now has stated that there is no Khata standing in the name of Kempegowda, and therefore he cannot do anything. And again, it has to go before the competent civil court to adjudicate them. Page number 19, my lords.
The Khata is standing in whose name?
As per this report, my lords, it is not, it's standing in Kempegowda's father's name.
Kempegowda's father's name.
And Kempegowda had executed the agreement to sale, my lords.
Annexure 3, the order of the Assistant Commissioner. Remanded back to the Tahsildar, now Tahsildar has passed the order.
ಅದೇನು? ಈಗಾಗಲೇ ಕೆಂಪೇಗೌಡ ಉರುಫ್ ಶಿವಣ್ಣನವರಿಂದ 1 ಎಕರೆ 35 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣದ ಪೈಕಿ ನಮೀಸಿಯಾ ರೋಡ್ರಿಗಸ್ ಹೋಮ್ ಲೂಯಿಸ್ ರೋಡ್ರಿಗಸ್ ರವರಿಗೆ 28 ಗುಂಟೆ,
Different.
ಎಕೆ ಸೂರ್ಯನಾರಾಯಣ
Different.
21 ಗುಂಟೆ
Different.
ಮತ್ತು ಬಿ.ಕೆ. ರಾಜು 17 ಗುಂಟೆ ನೋಂದಣಿ ಕ್ರಯಪತ್ರದ ವಹಿವಾಟು ನಡೆದು ಖಾತೆ ಪಹಣಿ ದಾಖಲಾಗಿದ್ದು ಪ್ರಸ್ತುತ ಅರ್ಜಿದಾರರ ಹೆಸರಿಗೆ ಖಾತೆ ಮಾಡಲು ಕೆಂಪೇಗೌಡ ಹೆಸರಿನಲ್ಲಿ 20 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣ ಖಾತೆ ಇಲ್ಲವಾದ್ದರಿಂದ ವಾಟ್ ಕ್ಯಾನ್ ಯು ಡು?
My lords, as per Tahsildar, as per Assistant Commissioner order, my lords, he has to make inquiry and then pass an order, my lord. Only.
That is the inquiry is conducted. There is no property standing in the name of your vendor.
Please.
Then What can be done?
Yes, decrease the millers and in an execution proceeding millers, sale deed has been executed.
Yes. But there is no land standing in the name of your vendor to be transferred in your favor. Learned AGA takes notice for all the respondents. Learned counsel for petitioner is directed to serve a copy of the writ petition along with annexures from the learned AGA. Full stop. Next para. The grievance of the petitioner is that in spite of a sale deed executed by the second additional senior civil judge and CJM, Mysore, in terms of the judgment and decree passed in OS number 316 of 2007 and execution case number 973 of 2009, the respondent revenue authorities are not entering the name of the petitioner in the land records. Full stop. In the impugned endorsement, the Tahsildar, Mysore Taluk has stated that the vendor of the petitioner, Sri Kempegoda, has disposed of the entire extent of 1 acre and 35 guntas of land in survey number 24/2.
24/2 millers.
24/2 of Jattihundi village, Ilavala Hobli, to 3 different persons, namely Mrs. Rodriguez, bracketly, (28 guntas), semicolon, to Sri A.K. Surya Narayana, bracketly 21 guntas, and Sri B.K. Raju, 17 guntas, under 3 separate sale deeds, and the name of the purchasers have been entered in the land records. Full stop. Next para. Prima facie, it appears that the Tahsildar has rightly pointed out to the difficulty in entering the name of the petitioner in the land records. Full stop. Next para. The respondent revenue authorities are directed to file statement of objections within a period of 2 weeks from today. You just think over.
Yes.
I don't find any infirmity in the order.
No, because millers, even after selling to this 3% millers, 20 guntas.
So therefore, what should the Tahsildar do now? Unless there is a direction by the court,
Please.
he cannot do anything. He has entered the name of those persons in terms of the registered sale deeds.
Please.
He cannot take a decision that since there is a judgment and decree obtained by you, their name should be removed. He cannot take such a decision.
I'm not asking their name to be removed, my lords. Even after selling to those 3 persons, my lords, 20 guntas still what petitioner
No,
has
no.
purchased is there.
He has given the details. Completing 1 acre 35 guntas. So therefore, if you are able to point out,
Please,
even after the sale deed executed in favor of that 3 persons, there are still 20 guntas left,
please, my lords.
then you will have to substantiate.
Please,
They will file the statement of objection.
please.
Yes.
Till number 11, we have Kumar, declared for petition. The first petitioner's father was granted land in old survey number 67 of Cardigan. Now the question, my lord, is that in earlier round of litigation, that the respondents have approached this honorable court challenging the order.
Anjinappa is your father.
Father, Anjanappa is my father.
3 acres and 20
He
guntas.
acres 20 guntas.
And Srimati Bhagyamma,
Bhagyamma is the mother of the
2
second
acres, 20
petitioner,
gunta.
2 acres, 20
Yenidu?
gunta, second petition.
both of them were granted land.
Both of them are granted lands.
Ah,
The respondent number 3 hearing, the 4 hearing claims that he acquired the property in survey number 23/23 of the series, same village. And later it was changed to survey number 67 and 100/1 and 100/2. That our case is also the survey number is 100/1 and 100/2. They questioned the grants itself. That earlier round of litigation, as per annexure K, my lord, that the assistant commissioner held that the grants are made in favor of my father and Bhagyam. And accordingly, the mutation is to be effected in our names.
ah,
That annexure K at page 62, your lord.
Hmm.
And thereafter, the said order was challenged by the respondent number 4 and another person, my lord.
before the division bench.
Before this honorable court in the learned, before the single judge
Hmm.
at annexure P,
Ah,
that the learned single judge held that our grant certificates itself are fake. So therefore, he has cancelled our mutation entries, against which the writ appeal is filed. That the writ appeal, my lord, that annexure Q, that 131, in the last paragraph, my lord, that page 18, the page 147,
yes.
that however, liberty is reserved to the respondents. to
Therefore, it is
assess-
evident that the learned single judge travelled beyond the
travel
scope of the
beyond the
petition.
scope of so and so.
Ah, and examined questions of title,
Title.
which was not even challenged by respondent number 1
One,
and 2.
in respect
in the
of the
petition.
grants. Therefore, that liberty is given that if he is so aggrieved, so he can challenge the grants also. That at the concluding paragraph, that page 147.
Yes,
Then it is, however, liberty is reserved to the respondents to assail the order of grant, if so advised, in accordance with law. Needless to state that the revenue entries made in favor of the appellants in respect of land in question shall be subject to outcome of dispute, if any, pending between the parties.
1 second. Innonsari ಓದಿ last paragraph 147 ಅಲ್ಲಿ.
Please, however, liberty is
ಅಲ್ಲಲ್ಲ.
reserved.
The entire paragraph,
That, yes,
the order of grant made in favor of.
one minute.
Type page number 17. ಅಲ್ಲಿ 2 ಪ್ಯಾರಾಗ್ರಾಫ್ 14 ಅಂತ ಹಾಕಿದ್ದಾರೆ. ನೀವು ಇವಾಗ ತಾನೇ ಓದಿದ್ರಲ್ಲ,
Please, no.
ಅದೇನೆ ಪೇಜ್ ನಂಬರ್ 147.
147 ಅಲ್ಲಿ stay.
ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಓದಿ.
However, liberty is reserved on the state.
I think there's.
The order of grant made in favor of ಓದಿ. ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್.
Thus, it is evident.
Page number 147, sir. You type page number 17.
Type to page number 17, now that it's missing.
ಇವಾಗ ತಾನೇ ಓದಿದ್ರಲ್ಲ.
The last
One para.
last para is only there, subsequently I have produced, it is not there. Yes. Therefore,
ಅಲ್ಲ ಅದ್ರ ಕೆಳಗಡೆ. ಹಾ.
the order of grant made in favor of the appellant stands as on today and has not been assailed by anyone. Therefore, the special deputy commissioner was justified in directing mutations of names of the appellants in the revenue records, void order dated 31/8/2016. The impugned order passed by the learned single judge therefore cannot be sustained in the eye of law. It is accordingly set aside. That the next paragraph, my lord, that however liberty.
You were the appellant.
I am the appellant before the
Division
division
bench.
bench. However, liberty is reserved
Ah.
the respondents to assail the order of grant, if so advised, in accordance with law. Needless to state that the revenue entries made in favor of the appellants in respect of the land in question shall be subject to outcome of dispute,
Yes.
if any.
Yes.
So now, my lord, that subsequent to file the order passed by the
Yes.
division bench,
Yes.
again he filed an appeal
Ah.
challenging the very same MR of 14 of 2015, which is at annexure R, my lord, that now it is entertained. So that according to him that he has already approached the civil court and civil suit 880 of 2015 is pending according to him. So despite of that, he is again challenging the very same mutation entries before the court.
So you were challenging the proceedings
The proceedings itself,
before the assistant commissioner.
before the estimate, because it is the against the order of the division bench of this honorable.
Barkala. Learned AGA takes notice for respondents number 1 to 3. Issue notice to respondent number 4. Learned counsel for petitioner is directed to serve a copy of the writ petition along with annexures on the learned AGA. Full stop. Next paragraph. Learned counsel for the petitioner draws the attention of this court to order dated 20th of February 2023, passed by the division bench in writ appeal number 338 of 2020, which was filed by the
first petitioner and the mother of the second petitioner.
the first petitioner herein, along with his wife,
No, along with the mother of the second petitioner.
They're two different people. They're not related.
Very. Bhagyamma, who is granted 2 acres 20 guntas, that Ramakrishna's father Ranjanappa granted 3 acres 20 guntas.
along with the second petitioner's mother,
Mother,
Srimati Bhagyamma.
Bhagyamma.
Stop. Learned counsel submits that it is clear from the said order that the division bench found that the orders passed by the learned single judge traveled beyond the scope of the writ petition and he examined the question of title which cannot be done in a proceedings under section 136 of the Karnataka Land Revenue Act of 1964. Full stop. The order of the learned single judge was therefore set aside and liberty was granted to the contesting respondent herein to assail the original order of grant made in the year
1978.
if so advised. Full stop. It was also directed that the revenue entries made in favor of the appellants therein shall be subject to the outcome of the dispute. Full stop. Learned counsel submits that although liberty was granted to the contesting respondent to raise a challenge to the grant order, the respondent has once again filed an appeal invoking section 136(2) of the Act before the Assistant Commissioner. Full stop. The prayer in this writ petition is therefore to quash and set aside the said proceedings. Full stop. Next paragraph. Consequently, there shall be an ad interim order of stay of all further proceedings in RA 304 of 2023, pending consideration before the Assistant Commissioner, Bangalore North Subdivision, till the next date of it.
Okay. So number 12. Imana.
Only pass over. Clerk council is in total 24.
Pass over.
Zero number 13.
But based on will,
Remove
the revenue entries are sought to be changed. The first petitioner is the wife of Venkatramaya, and second petitioner is the son of Venkatramaya. The property was standing in the name of Venkatramaya. Subsequently, it came to be changed in the name of the second petitioner. Now, the fifth respondent, that is Srimati Sharadamma, she claims to have obtained a will from the first wife of Venkatramaya, and based on that, she wants to change the RTC entries in respect of the non-property. Now, I am relying upon one judgment. What happened? It is changed. Andre AC had passed an order to change the revenue records in respect in the name of fifth respondent. Against that, the petitioners approached the DC. DC had stayed the proceedings, stayed the change of revenue records, but the DC has confirmed the order of the AC. As against that, time before this, Your Lordship.
The DC's finding is that the matter is of civil nature, and it has to be adjudicated, complicated questions of facts and. ಇದರಲ್ಲಿ DC or
ಅಲ್ಲ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಆರ್ಡರ್ ಏನ್ ಮಾಡಿದ್ರು?
ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಚೇಂಜ್ ಮಾಡಬೇಕು
Change ಮಾಡಿದ್ರು.
ಫಿಫ್ತ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಹೆಸರಿಗೆ.
Petition entry change ಮಾಡಿದ್ರು. ಇವ್ರ ಸರಸ್ವತಮ್ಮ ಅವ್ರ ಹೆಸರಿಗೆ. The fifth respondent ಹೆಸರಿಗೆ entry
ಅದೇ, so the deputy commissioner, if he is of the opinion that a civil suit has to be filed, how did he allow the order of the assistant commissioner to stand?
that has to be settled.
Alva? Yes.
I am relying upon.
Learned AGA takes notice for response number 1 to 4. Issue notice to respond number 5.
Head note last time.
Learned counsel for petitioners is directed to serve a copy of the petition along with annexures on the learned AGA. Full stop. Next para. Learned counsel for the petitioners submits that when the fifth respondent approached the assistant commissioner by filing an appeal under section 136(2) of the Karnataka Land Revenue Act of 1964 to seeking directions to mutate her name in the land records on the strength of a will said to have been left behind by
Wife of Venkataraman.
Kamalamma.
Srimati Kamalamma, who is said to be
The second wife.
the second wife of
Venkata.
late Sri Venkataramaya, the assistant commissioner, instead of dismissing the appeal while directing the appellant to seek a declaration since objections have been raised by the other legal heirs of late Sri Venkataramaya, he allowed the appeal while directing the Tahsildar to enter the name of the appellant therein on the strength of the will. Full stop. The deputy commissioner, although held that if a dispute is raised in respect of a will, the parties should approach a competent civil court. Nevertheless, he failed to set aside the order of the assistant commissioner. Full stop. Learned counsel seeks to place reliance on a judgment of a full bench of this court in the case of CN Nagendra Singh versus Special Deputy Commissioner, Bangalore. ಯಾವ್ದ್ರಲ್ಲಿ ರಿಪೋರ್ಟ್ ಆಗಿದೆ ಇದು?
ILR 2002 ಅದು citation.
ILR
ILR
reported in ILR
2002.
Karnataka,
Page number I'll provide later.
wherein it was held that the revenue authorities cannot consider genuineness of will or question title of property.
Page number 2750.
Huh?
Page number 2750.
ಬರ್ಕೋಣಮ್ಮ.
Paragraph 9 ಅಲ್ಲಿ ಇದೆ sir.
It was held that if the will is disputed, strict proof of will as required under section 63 and 64 of the Indian Succession Act is to be provided. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned orders passed by the Assistant Commissioner as well as the Deputy Commissioner, till the next date of hearing.
Much okay.
Non-compliance of officer petition for first time, serial number 14, unit C, 79AB.
That's 29 AB.
29 AB matter. Same person, 2018 order,
2018. All right.
3271.
Appear before the Assistant Commissioner on 23rd of April.
Please.
Office objections are overruled. Yes.
Serial number 15.
Millard, this is also 79 AB proceedings, Millard. The order of the year 1990, it's against the dead person. It's again, order is against the dead person, please.
On 1990.
1990.
1990.
Copy ilva?
The copy.
Huh?
Copy.
It is served. I was the owner way back in the year 1985. Proceedings is initiated in the year
Please give a
1990.
copy. ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಟ್ಬಿಡಿ.
Next year, he has sailed it, please. To the date of 1985 itself, please, Millard, Ramaya was a dead person. His wife and his children had sold the property in the favor of the petitioner hearing.
Huh?
Wife of
Proceedings were initiated against A. Ramaya.
A. Ramaya.
Ah.
His wife and son executed sale deed in favor of the petitioner. He was dead.
Not that, sir. ಅವ್ರು ತಗೊಂಡಿದ್ ಸೇಲ್ ಡೀಡು. That is in question.
Out tagondru sale, that is also not in question. The order says that 1911, 1985, please, Millard.
Huh?
The order annexed D.
1985 sale deed.
85 ಸೇಲ್ ಡೀಡ್ ರೀ.
1980.
ಅವ್ರು ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದು.
ಅಲ್ಲ, ನಾನ್ ಪರ್ಚೇಸ್ ಮಾಡಿರೋದು annexure A, 1985 ನಲ್ಲಿ.
1911, 1985.
ನನ್ ಸೇಲ್ ಡೀಡ್ ಅದು.
ಎಲ್ಲಿದೆ?
annexure A, please, Millard.
Page 18, 1985 ಇಸ್ವಿ ನವೆಂಬರ್ ತಿಂಗಳು ತಾರೀಕು 19ರಲ್ಲಿ ಹೊಸಕೋಟೆ ತಾಲೂಕು ನಂದಗುಡಿ
Based on the sale deed, mutation is also affected in my name.
ಮುನಿಯಪ್ಪನವರಿಗೆ ನಂದಗುಡಿ ಹೋಬಳಿ ಲೇಟ್ ರಾಮಯ್ಯ ಅವರ ಹೆಂಡತಿ ಶ್ರೀಮತಿ ಕಮಲಮ್ಮ ಮತ್ತು ಲೇಟ್ ರಾಮಯ್ಯನವರ ಮಗ ಕೆ ಕುಮಾರ್.
1911,
1985.
1985.
Based on sale deed, mutation is also affected, please.
ಮುನಿಯಪ್ಪನವರಿಗೆ
Please, Millard. Petitioner hearing.
ಲೇಟ್ ರಾಮಯ್ಯನವರ ಹೆಂಡತಿ ಶ್ರೀಮತಿ ಕಮಲಮ್ಮ ಮತ್ತು ಲೇಟ್ ರಾಮಯ್ಯನವರ ಮಗ ಕೆ ಕುಮಾರ್ ಆದ ನಾವುಗಳು ಸೇರಿ ಬರೆಸಿಕೊಟ್ಟ ಜಮೀನಿನ ಶುದ್ಧ ಕ್ರಯಪತ್ರ.
ಈಗ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆರ್ ಅಗೇನ್ಸ್ಟ್ ರಾಮಯ್ಯ.
ಏನ್ ಮಿಸ್ಟೇಕ್ ಆಗಿರ್ಬೇಕು. ಅವರು ಹೆಸರು ತೋರಿಸುವಾಗ ತಪ್ಪಾಗಿ ತೋರಿಸಿದ್ದಾರೆ. ಇಟ್ ಮೀನ್ಸ್ notice is not issued to the
petitioner
purchaser.
ಮುನಿಯಪ್ಪ ಅವರು
ಒಂದು ಪ್ಯಾರಾಗ್ರಾಫ್ ಸೇರಿಸ್ಕೊಳ್ಳಿ. Learned counsel for the petitioners has drawn the attention of this court to the impugned order which has been initiated against proceedings were initiated against Sri A. Ramaya, son of Muniswamy, in respect of a registered sale deed dated 19/11/1985. Full stop. The learned counsel once again draws the attention of this court to Annexure A, which is the sale deed dated 19/11/1985, and submits that it is the petitioners herein
Who had acquired the property.
it is the petitioner herein who purchased the land in question
In terms of
from the legal heirs of late Sri Ramaya. That is Sri Ramaya's wife,
and son.
Srimati Kamalamma, and Sri Ramaya's son, Sri K. Kumar. Full stop. The learned counsel would therefore submit that the initiation of the proceedings in the name of Sri Ramaya clearly shows that notice was not issued to the purchasers, and therefore the petitioners were not aware of such an order being passed by the Assistant Commissioner. Full stop. Next para. This court has held in several such petitions where the orders of the competent authority were questioned before this court long after the amendment was brought to the said provisions contained in the Karnataka Land Reforms Act, and held that even if the orders were passed by the competent authority in accordance with law, nevertheless, having regard to the saving clause provided in the amended act, 2020, what remains to be seen is whether the lands still remained in with the government or was disposed of in accordance with law. Full stop. Next para. In the present context, since this court is convinced that the impugned order passed by the Assistant Commissioner cannot be sustained, having regard to the fact that proceedings were initiated in the name of Sri A. Ramaya, and not in the name of the petitioners, who are the purchasers, nevertheless, if the lands have been disposed of consequent to the orders passed on 7/8/1995, nothing much can be done to help the petitioner. Full stop. If on the other hand, the land is not disposed of consequent to the impugned order, the revenue entries are required to be restored in the name of the petitioner. Full stop. Next para. For that purpose, the matter stands remitted back to the Assistant Commissioner although the impugned order has been set aside, comma, only to find out as to whether the lands have been disposed of or not. Full stop. If the lands have not been disposed of consequent to the impugned order, comma, the Assistant Commissioner shall restore the name of the petitioner in the land records while removing the name of government. Full stop. Next para. The petitioner is directed to appear before the Assistant Commissioner on 23rd of April 2024 for that purpose. Yes.
Just for time limit, please.
Huh?
Time limit, if I may request.
The entire exercise shall be completed as expeditiously as possible and at any rate within a period of 4 weeks from
Date of appearance.
23rd of April 24.
Please.
Yes.
Orders. Serial number 16, A. Narasimhan, withdrawal in respect of P 2 to P5.
Hearing the respondent number 5, Anu Kanya.
Withdrawing the petition, my lord, in view of property has been sold in favor of Mohan.
Huh?
Property has been sold, my lord, in favor of one Mohan Shankaran. So in view of that, we are withdrawing the petition.
The petitioners and the learned counsel for petitioners have filed a memo dated 18/1/2024 stating that the land in question have been sold in favor of one Sri Mohanan Shankaran Putti. And therefore, the petitioners do not press the writ petition. Full stop. Next para. The memo is taken on record subject to all just exceptions. Full stop. Accordingly, the writ petition stands dismissed as not pressed.
Serial number 17, Somsekhar HM, recalling order dated.
ಒಂದೇ ನಿಮ್ ಕಾಪಿ ಬಂದಿದ್ಯಾನ್ರಿ IA 1 and 2 of 2023 ಲಾಸ್ಟ್ ಟೈಮ್ ಡೈರೆಕ್ಟ್ ಮಾಡಿದ್ವಿ. ಹಾ in spite of specific directions being given to the learned counsel for the petitioner to serve copies of IAS number 1 and 2 of 2023 on the learned counsel for the contesting respondents and the learned HCGP. Learned HCGP submits that he has not received the copy of the IAS. Full stop. There is no representation for the petitioners. Full stop. Next para. Release this matter on 27th of March 2024 for complaints of the orders passed by this court.
Serial number 18, Marilinge Gowda.
I appeal for this matter. This is the matter where he has sought for the copy of the grant certificate. This is the same matter where the Principal Secretary Revenue Department was present.
Huh?
This is the same matter where the Principal Secretary Revenue Department was present on last date of hearing and he has apprised the court. What has happened is after this, your lordship, the specific meeting was called in the presence of the Advocate General also, for which I was assigned to represent on behalf of the government. I was present in the meeting. Now, what they have done is they have asked, your lordship asked certain questions. So the tender was floated on 30/8/2008 itself. But that was a specific tender only to scan the documents, reprint it and hard bound it.
Correct.
So that it is available whenever we want to derive.
ಅದನ್ನೇ ಕೇಳ್ತಾ ಇರೋದು ನಾನು.
ಅದೇ. So
Yes.
ಈಗ comprehensive research has been done and after instructions of the
ಅದಲ್ಲಪ್ಪ ನೀವು ಅರ್ಥನೇ ಮಾಡ್ಕೊಂತ ಇಲ್ಲ. If that is the correct position,
yes,
then I am asking you for the scanned copy.
yes, yes. We will provide the scan copy. What had happened was totally in that tender. What was issued was totally at that point of time, physical 30 lakh sheets of revenue department grant and other register papers were there, which was scanned, which however was not completed in certain talukas, in certain places it has been completed. Now what had happened was they did not complete the process of reprinting it, hard bounding it. So all the data that was available was in the hard disks. Now they have started, but what has happened is it was mere scanning. Manually, what they were doing was they're just scanning the documents and keeping it. And at that point of time, there were no software in such a manner where it could automatically folio the files. Ega, they have evolved a thing in the Bhumi. There's a separate revenue commissionerate now to look into the record.
I wanted the principal secretary to file an affidavit
Yes, yes, that affidavit
as to when the first circular was
Yes.
issued.
yes,
What has happened after that?
yes, yes.
Idana, whatever you are saying, it should have been put in
Hello,
black and white.
Hello, everything is in black and white. You know. In fact, yesterday also they had a meeting. That is why I could not prepare the affidavit today. So they have given all the details today. You know. I have it.
And more specifically in respect of ಯಾವ್ದು ತಾಲೂಕು ಇದು?
ಇದು Tipsandra village, Uttaralli, ಇದು Bangalore South. Tipsandra,
Bangalore?
Bangalore South Taluk. Bangalore
So
South.
therefore you will have to
Yes.
more specifically say what happened to the scanned copies of
The South Taluk.
Bangalore South Taluk.
Kindly have it on Monday, Your Lordship. I'll file the affidavit. We have a principal secretary affidavit is file month.
I am sure it should, the scanned copy at least should be available now.
Yes, sir. The only thing is what has happened is like I mentioned last time also.
Scan ಮಾಡಿ ಇಟ್ಟಿದ್ರೆ
ಅದರಲ್ಲಿ search
I really can't understand. ಅಷ್ಟೆಲ್ಲ ಮಾಡಿ ಒಂದು ಕಾಪಿ ತೆಗೆದು ಇಟ್ಕೊಂಡಿಲ್ಲ ಅಂದ್ರೆ ಅರ್ಥ ಏನು? What purpose the entire exercise was done?
I was present in the meeting. What they said was, if we start reprinting all the sheets, they were telling that they are creating a parallel duplicate.
Yes, it was
record room.
necessary.
Record room.
It was necessary because every time the courts were calling for the original records, the same explanation was sought to be given that it's in a fragile condition. It is not possible to get it. So therefore, courts directed, at least if a scanned copy is brought before this court, the court can verify. It is for that purpose the entire exercise was done.
Yes, sir.
ಮತ್ತೆ ಕಾಪಿ ಮಾಡಿ ಇಟ್ಕೊಳ್ಳೋದು ಅಂದ್ರೆ ಅರ್ಥ ಏನ್ ಮತ್ತೆ?
ಅಲ್ಲ ಅದು ರೀಪ್ರಿಂಟ್ ಮತ್ತೆ ಅದ್ರಲ್ಲಿ ಇಡೋದ್ ಬದಲು instead whenever they apply, they should retrieve a copy and immediately give it. Like how it is for the Pani in the Bhumi thing. But at that point of time, the tender was only for scanning. So physically ಅವ್ರು ಏನ್ ಮಾಡಿದ್ದಾರೆ ಸ್ಕ್ಯಾನರ್ ಅಲ್ಲಿ ಸ್ಕ್ಯಾನ್ ಮಾಡಿ ಹಾಗೆ ಒಂದು ಹಾರ್ಡ್ ಡಿಸ್ಕ್ ಹಾಕಿ ಇಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. So if they reproduce it, what happens is
ಏನಾಗುತ್ತೆ?
equal number of papers will be there in the printed format also.
So what? With the available technology, they could have made a proper book.
Yes.
Even if it is duplicate. But it would have been more easier for you to bring the document before the court. ಅದನ್ನ ಅರ್ಧಕ್ಕೆ ಚಾನ್ಸ್ ಇರ್ಲಿಲ್ಲ ಅವಾಗ.
2009 in a lot of development has happened in the technology also and things have evolved. Now there is a specific
ಇವಾಗ ನೀವು ಮತ್ತೆ ಮಾಡ್ತಾ ಇರ್ಬೋದು ಎಕ್ಸೈಸ್. ಬಟ್ ಈಗಾಗ್ಲೇ ಈ 30 ವರ್ಷದಲ್ಲಿ many things are lost. ಅದು ಆಗ್ಬಾರ್ದು ಅನ್ನೋ ಕಾರಣಕ್ಕೇನೆ we directed that it has to be scanned and kept.
But 2014 ನಲ್ಲಿ after the Bhumi cell was started, other documents also have been.
We are not concerned of other documents, sir. We are concerned of the original
grant register
and Sagoli chit.
That the only thing is manually they will have to set them. According to them, they have scanned each and every piece of paper that was available in 2009.
Then get us a copy then.
I will.
I am not going to take this kind of an explanation.
I
That though the copies were scanned in the year 2008, but you are not able to give a copy to the court. What is the use then?
We are not telling we cannot give the copy to it. What we are telling is now that after the meeting and the presence of the.
ನಮ್ಗೆ ಅದು ಬೇಕಿಲ್ಲ. 2008 ಅಲ್ಲಿ ಸ್ಕ್ಯಾನ್ ಆಗಿದ್ರೆ at that point of time whatever is scanned, I want a copy of that.
I will also file the affidavit which is ready. Kindly have it on Monday.
Learned AGA submits that a preliminary discussion has taken place in the presence of the Principal Secretary, Revenue Department, the learned Advocate General, and the learned AGA for compliance of the orders passed by this court, and
AG was not
more
present.
particularly to file an affidavit of the Principal Secretary in the matter of scanning of the original grant registers and Sagoli chit issue registers in the entire state of Karnataka. Full stop. However, an affidavit in that regard will be filed on the next date of hearing. Full stop. Release this matter on, when do you want?
Monday, 25th. Monday.
25th, on 25th of March.
Number 19. Argo G.
Your Lordship's petitioner is the owner of land in survey number 187, 188 and 190, 189. And right beside his property, there runs a public road, Your Lordships. And that has been encroached by some of the villagers in the village. And previously we
You
had.
have now come on record.
I've come on record, yes, Your Lordship.
Since learned counsel Sri Bhargav G has come on record for the petitioners, the name of learned counsel Sri Pulakeshi AP may be removed from the cause list. Yes.
Your Lordship, this issue has been going back and forth for 8 years, Your Lordship. He's given several representation also. Previously, this honorable court had directed the respondents to remove the encroachment on the land. And the government also made a submission saying that that encroachment has been removed. And based on the submission made.
Encroachment made by whom?
By some villagers in the village, Your Lordship, by name Bhima Raju and Krishnamurthy.
And you not made them parties?
Previously, in other writ petitions, I had made them parties and.
Why not now? How can orders be passed which would affect the rights of some other person?
No, there's no.
Although you have named them in the writ petition earlier.
Yes, Your Lord.
And you have failed to name them now.
Previously, we had filed contempt petition also, and there's no dispute with respect to
That is
encroachment.
all the more reason why they have to be impleaded here. You can't obtain an order without notice to them. Agadilla.
Previously, they were directed, Your Lordship, and.
Then contempt aste. We can't pass
Contempt-
one more order
Contempt
without
was-
even issuing notice to them. Madak barala.
I'll include them in this petition. Permit me to include them.
ಎಲ್ಲಿದ್ದಾರೆ ಅದ previous matter ಅಲ್ಲೂ ಇಲ್ಲ.
Contempt, they were part of this, Your Lordship. Bhima Raju, son of Lingappa Gowda.
ಎಲ್ಲಿದೆ?
No, it is not part of the record. I'll place it on the
Contempt
next page.
petition, contempt part.
In the meantime, I'll file an impleading application.
Next para, learned AGA submits that the petitioners are seeking directions to remove unauthorized encroachment said to have been made by certain persons, but such persons have not been impleaded as party respondents to these proceedings. Full stop. Next para, learned counsel for the petitioners seeks leave of this court to implead such persons against whom specific allegations have been made by the petitioners. Full stop. Leave is granted. Learned counsel for the petitioner shall carry out the amendment in the cause title. Full stop. Issue notice to the newly impleaded respondents.
Number 20. Prakash MH,
For the petitioner.
lots of deceased P1.
Yeah, we filed the application to bring the LRs of petitioner number 1 on record in that. We also filed Wakalath in that for the LRs.
Respond number 7.
My lords, I am for the respond number.
This memo for dispensation.
You know,
For respondent number 7, we have memo for dispensation. Apologies, my lord, there is small printing. Malfunction.
ಯಾಕೆ ಪಾರ್ಟಿ ಮಾಡಿದಿರ ಅವ್ರನ್ನ?
Milord, wife Milord, father and mother Milord of the petitioner Milord. There are no issues for the
Huh?
wife of the deceased Milord and father and mother of the deceased Milord.
No, no, if respondent number 7 was not a necessary party. Why did
There is
you-
no relief.
Huh?
There was no relief sought against.
What is your prayer in the writ petition? Watch the proceedings. At annexure? M. ಏನದು?
What is the relief?
ಅಲ್ಲಿ ಒಂದ್ ಪಬ್ಲಿಕ್ ರೋಡ್ಗೆ ಜಾಗ ಬಿಡ್ಬೇಕು ಅಂತ
For the assistant commissioner bypassing his competency and jurisdiction has passed an order.
ರಸ್ತೆ ಜಾಗವನ್ನು ಅಡ್ಡಗಟ್ಟಿ ತೊಂದರೆ ನೀಡುತ್ತಿರುವ ಬಗ್ಗೆ. It's a
154
communication made by the Tahsildar to the assistant commissioner.
ಲಾಸ್ಟ್ ಒಂದು ಹ್ಯಾಂಡ್ ರಿಟರ್ನ್ ಇದೆ ನೋಡಿ. ಸಾರ್ವಜನಿಕ ರಸ್ತೆ ಎಂದು ದಾಖಲಿಸಲು ಆದೇಶಿಸಿದೆ ಇಷ್ಟೇ. This is the request dated 27/2022, which was already turned down by an order, the previous order, annexurial page 149. And still the Tahsildar has, at the instance of the respondent.
The last time I think I noticed this one.
Yes.
No, now you are asking for dispensation of notice to respond number 7.
Respondent number 7 is the co-respondent and no relief is sought there. In fact, whatever the relief that to accrued, it will be equal insofar as the petitioners and the respondent number 7 as well. So Hagagi, it may not be necessary party to, so that's why I am seeking dispensation.
Who are the, what is the relief against the private respondents here?
You know, we have not sought any relief against the private respondent. It is against the government only. If at the instance of.
ಅವ್ರನ್ನ ಯಾಕೆ ಪಾರ್ಟಿ ಮಾಡಿದ್ರೆ?
Our, at the first instance, the Tahsildar has made him, he is also one of the co-owner. One of the owner of the property, and may not kindly come to page 149. Anulekha Anta, 4th respondent. And she is the 7th respondent herein. Anulekha Shankar. And Praveen is the first petitioner who is died. Yashoda is the second petitioner. Despite having suffered before the civil court, wherein the suit for declaration was filed. Lord, the matter is now seized before this honorable court. There is a direction against the Tahsildar as well, that he should not interfere. Lord, still he has made an attempt to pursue the case and placing a request before the assistant commissioner. Well, looking into the trivialities and the.
If respondents number 5, 6 and 7.
Please.
Are all seeking certain relief against you. And the impugned order, some observation has been made. How can you now seek dispensation of one of the respondents?
I can take process, lords. In fact, this is the prosecuted by the Tahsildar.
ಇದ್ರ ಮೇಲೆ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗ್ಬೇಕಾ? IA number
ಇಲ್ಲ IA
1, 3 and 4. 1, 3 and 4 of 2024.
In fact, I have filed Wakalath representing the incumbent petitioners. Are petitioner number 1A, B and C. That may be taken on record. The legal representatives of the first petitioner. A1, B1.
ಶ್ರೀಮತಿ ಸಹನಾ, CR Lakshman Gowda, Bhagya are the legal representatives of deceased petitioner number 1.
Yes.
Well, also we have sought for vacating the interim order that is there.
Hey, do you have any objections for allowing the application?
Completing application.
Implead, we don't have any objection.
ಎಲ್ಲರಿಗೂ. ಇಲ್ಲ ಐತೆ.
orders on IA number 123 of 2024. These applications are filed to bring on record the legal representatives of deceased petitioner number 1, please. Shri CL Praveen. 238. While seeking condonation of delay of 169 days in filing the application and to set aside abatement. Full stop. This court is satisfied with the explanation offered for condonation of delay. Full stop. Accordingly, the applications are allowed while condoning delay and setting aside abatement. Full stop. Learned counsel for the petitioners shall carry out the amendment in the cost title, please, and furnish amended cost title within a period of 1 week from today. Please. Full stop. Next para. In the meanwhile, steps shall be taken for service of notice on respond number 7. Please.
Lords, I appear for.
IA 234 agar. IA 234.
Early hearing as well as.
IA 1 is for early
vacating
hearing.
stage. This can be taken at
2,
the
3 and
same
4.
stage.
2, 3 and 4.
IAS 2, 3 and 4 of 2020.
My lords, I appear for respondent number 5, my lords. I have filed an IA for vacating stay also and also for early hearing, my lords. Last time on the same pretext, it has come before this court, my lords. My lords, in the lower court judgment, my lords, in page number 63, my lords, they had given me a liberty to go before competent authority to address my grievance, that there was a road.
Lower court andre?
My lords, in the OS number 414 of 2006, my lords, which we had filed. Adralli,
What was the suit for?
Permanent injunction.
suit for permanent injunction, my lords. There was a road, my lords. A road na you obstruct madi, it's a private road, public road alla anta, that's what was their contention. They had filed the OS and they had got permanent injunction.
You had filed a suit.
Later, we also filed a suit stating that permanent injunction kottid sari alla, it is a public road, namge madake id madbekanta. Then there was one Keravu Patra anta which I have filed in vacating application, my lords. Avaga Keravu Patra now we are not furnished before the lower court.
Yen patra?
My lords, my lords, R4, my lords, which I have filed with statement of objections dated 23/11/2022. That is copy of Ketwaru Patra of the year 1922-23.
R4.
Annexure R4, my lords, of statement of objections filed on 23/11/2022. Adralli, it is written, my lords, 1925-26 ara Botaya
Bagaitu.
Baga ettu. What Baga admele, there has to be a road in that in between the two properties, there has to be a road and
ಅಳತೆಯಂತೆ ಈ ಜಮೀನಿನಲ್ಲಿರುವ ನೀರು ಕಾಲುವೆ ಹಾಗೂ 25
ಗಜ ಗಜದಷ್ಟು ರಸ್ತೆಗೆ
ಅಳವಡಿಸಿ
ಕಾಫಿ ಸಾಗುವಳಿಗೆ ಕೊಟ್ಟಿದೆ. It states that there has to be a road.
Yes.
It states
Suit
that
for declaration seeking easementary right that was rejected. In fact, suit for injunction filed by the father of the first deceased petitioner and the present suit, what my learned friend is contending, both are clubbed together. I mean, more than a couple of times, surveyors were, the court commissioners were appointed, and our suit was decreed. So as the suit for filed seeking declaration insofar as easementary right across private land, which is land belongs to us, was dismissed. Appellate court has also, concurred this
judgment.
Please. Note this is
If a competent civil court has
that's the content.
passed a
At
judgment,
page
then what more remains?
My
Nothing
lords,
can-
41 annexure E.
my lords, page number 63, my lords, in the judgment passed by the civil court in the OS filed by us, my lords.
Yes.
Adralli, they have given us a liberty to go before the competent authority.
In accordance with law.
In
Suppose
accordance
if any
with
other
law.
road is available, not bypassing and
Bypass anta ನಾವು
Circumvent.
ಹೇಳೋದೇ ಇಲ್ಲ.
circumvent this judgment.
Read the relevant portion.
It 62, page 62.
Hmm.
The suit of the plaintiff OS 414 of 2006 hereby dismissed with cast. This is for declaration. The suit of the plaintiff in 327 of 2006 is hereby declared with cast. And accordingly, the the defendants, their men, agents, or anybody claiming through them in OS 327 of 2006 are hereby restrained from, by way of permanent injunction from causing interference for possession of the plaintiffs. However, it made it clear that the defendants in OS 327 of 6 are at liberty to approach the concerned authority to get form a road in accordance with law.
So in accordance with law, we have gone before the.
Get it formed.
It formed.
ಇರೋದನ್ನೇ declaration ಕೇಳಿದ್ದು it is dismissed. Liberty was only given that if any new road can be formed for your purpose, approach the authorities and. So your claim in respect of this portion that you have a easementary right and therefore it has to be left for a road anbuttu, that has been dismissed.
My lords, then we had approached the authority, my lords. The authority gives idonde road iradu, baki ellu road illa anta there is a finding, my lord.
ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. If there is a judgment and decree of a competent civil court, the revenue authorities cannot do anything further.
My lords, one short date I'll.
In fact, the state commissioner by the order dated 35/2022 has rejected the claim made by the Tahsildar. And subsequently on the same representation, my lord, which I have pointed out to my lords, the handwritten 4-word sentence. So this is the order. In fact, the state commissioner has taken note of the previous civil suits which are decreed and the persuasion of the appeal by the contesting respondent therein. The matter is seized before this honorable court in second appeal. No interim order is granted.
So the matter is still pending consideration.
Please. And in that scenario, my lord, I don't know how Tahsildar, even against Tahsildar also there is an injunction operating. He is also a defendant in our suit.
If it is a claim that it is a public road, was the state made a party respondent to the proceedings?
Yes, ma'am. State was the party.
And what is the stand that the state took?
If I had to bring to the notice of my lord, sir, page 25, at the earliest itself, way back in 15/5/2007, an endorsement was issued by the Tahsildar.
What was the stand taken in the suit? ಅಪಿಯರೇ ಆಗಿಲ್ಲ ಅಂತ ಕಾಣುತ್ತೆ, ಬರೋದಿಲ್ಲ ಅವರು.
ಯಾಕೆಂತಂದ್ರೆ ಒಂದು ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ತಾವು ಗಮನಿಸಿದ್ರೆ ಇಲ್ಲಿ annexure B, page 25. Tahsildar himself has given this endorsement to the contesting respondents. Since it is a private land, there is no permissibility for forming.
Have you read that judgment?
Well, it's one short date, my lords. I'll
please see if the revenue authorities have taken any stand.
Yes, my lords.
If they have taken a stand that it is a public road,
then we have no case. That's one short date, my lords. I'll look into the matter and.
Next para. It is the contention of the petitioners that the claim of the private respondents herein in OS number 414 of 2006, seeking easementary rights of the road in question have been dismissed by the civil court, while decreeing the suit of the petitioners herein in OS number 327 of 2006, which is a common judgment. Full stop. although a regular appeal, first appeal or regular appeal?
First.
Regular
RA.
first appeal.
RA.
RA na, RFA na?
RA filed.
A regular
that was
appeal filed by the private respondents herein is still pending consideration.
No. That was also dismissed on 14 January 2015, challenging both findings. Now
The RSA.
second appeal is pending.
Although the regular second appeal filed by the private respondents herein is still pending consideration before this court.
Other parties, but the private respondent number 5 is not the party who is.
I'm not a
pursuing this
party
appeal.
to those proceedings.
Because they have set up this person.
Allah, but if the claim is that it's a
Original-
public road, it may not be only by one person.
Of course.
Those 14 families use ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂತ in annexure H, it is given by the.
ಏನ್ ಹೇಳ್ದೆ? Filed by some of the aggrieved persons.
For the original plaintiffs.
Is still pending consideration before this court.
Yes.
Come on, nevertheless, the impugned order could not have been passed by the Tahsildar.
Assistant Commissioner.
Huh?
Assistant Commissioner, the respondent.
It's only a communication by the Tahsildar to
ಇಲ್ಲ,
the.
ಆ ತಹಶೀಲ್ದಾರ್ ಅದಕ್ಕೆ ನಾನು ತಮ್ಮ ಗಮನಕ್ಕೆ ತಂದದ್ದು ಅವ್ರ ಆದೇಶ ನೋಡಿ ಇದು ಮಾಡಿರೋದು ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಕೆಳಗೆ
ಯಾವುದು?
ಅನೆಕ್ಷರ್ ಎಂ ಪೇಜ್ 152, 153 ಇದೆಯಲ್ಲ. This is the application, a replica of the previous one, and in the last portion, ಸಾರ್ವಜನಿಕ ರಸ್ತೆ ಎಂದು ದಾಖಲಿಸಲು ಆದೇಶಿಸಿದೆ. This is signed by the assistant commissioner. Lord, the
Impugned order for endorsement made by the assistant commissioner in a communication made by the Tahsildar at annexure M would be contrary to the judgment and decree passed by the competent civil court, which was also upheld by the regular appellate court. Full stop. Next para. Learned counsel for the contesting respondent seeks for a short accommodation to go through the judgment and state as to whether the state of Karnataka and the revenue authorities have taken any stand in the suit. Yes. Yes. Release this matter on 27th of March.
I need to take process. Can it be on first week of April?
Also, probably one ವಾರ time ಕೊಟ್ಟಿದ್ದೀರಿ.
I will file, but it has to go.
No. Time for taking steps ಅಷ್ಟೇ ಅದು. Yes.
Number 21. Non-funding report.
Prepared for the petition. ಕೋಡಿ ರೆಕಾರ್ಡ್ಸ್ ಅವೈಲೇಬಲ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಇದನ್ನ ಹೇಳಿದ್ರು. ಅವರಿಗೆ ರಿಪೋರ್ಟ್ ಹಾಕೋದಕ್ಕೆ ದೇರ್ ವಾಸ್ ಎ ಡೈರೆಕ್ಷನ್. ಐ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ಅಮೆಂಡ್ಮೆಂಟ್. ಅಮೆಂಡ್ಮೆಂಟ್ ಅಂದ್ರೆ ನಾನು ಮೆಮೊ ಜೊತೆಗೆ ಏನ್ ರೆಕಾರ್ಡ್ಸ್ ಅನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೆ ಅದನ್ನ ಐ ಆಮ್ ಪುಟಿಂಗ್ ದೆಮ್ along with an amendment application so that they come on record properly.
Be permitted to file objection. Yesterday, they have served a copy on amendment application. The completely new pleadings has come on record than the original pleadings, whatever before the assistant commissioner. I may be permitted to file, but the amendment application has not been put up before the court.
Amendment application.
File ಮಾಡಿದ್ದಾರೆ. That has not been put up before the court.
Huh?
This is filed on 19th.
Yes.
Lord, with regard to there was a direction by this honorable court for deputy commissioner and the committee.
That may take some time.
Yes, my lord. With
The
regard
last
to-
portion of the order.
Last portion, I am filing a memo along with the report.
A memo-ದಲ್ಲಿ last serial number 6 may be seen.
Yes.
For that, my lord, subject to, Lord may consider, during the pendency of the petition, if the government were to take up that proceeding, all of us will go there and get the things
There.
sorted out.
The earlier direction. In the second last paragraph last time.
ಅದಕ್ಕೆ
For
ಈಗ
building
ಅವರು
up the
ಸೀರಿಯಲ್
records.
ನಂಬರ್ 6 ಏನ್ ಹೇಳಿದಾರಲ್ಲ, ಹೊಸದಾಗಿ ಮಾಡೋದಕ್ಕೆ ನೋಡ್ತೇವೆ ಅಂತ, ಹಾಗೇನಾದ್ರು ಮಾಡೋದಿದ್ರೆ ಬಟ್ ಲೆಟ್ ದಿ ಪೆಟಿಷನ್ ಬಿ ಪೆಂಡಿಂಗ್.
Yes, yes.
ಹಾಗೇನಾದ್ರು ಮಾಡೋದಿದ್ರೆ we will go there, submit all our records.
Yes.
I'll make short accommodation may be given, madam. I'll make my submission on this.
ನಿಮ್ಗೂ ಆಪರ್ಚುನಿಟಿ ಕೊಡ್ತಾರೆ, ಎಲ್ಲರಿಗೂ ಆಪರ್ಚುನಿಟಿ ಸಿಗುತ್ತೆ. You can't claim exclusive rights.
No, no, I'm not claiming exclusive right.
Therefore, if an exercise is to be undertaken by these survey authorities,
Yes, ma'am.
notice will be given to all of you
Yes,
to
ma'am.
appear and furnish your documents. They will find out how exactly it has to be marked. Boundaries have to be fixed.
Correct.
If the total extent of land is 137 acres.
Yes, ma'am.
Therefore, if the lands granted or purchased by the parties is still available, there should not be any difficulty for any of you.
It might be to the benefit of the contesting respondent also, because
Yes.
now according to this report, even his claim that his survey number is 77 is also taken away.
Yes, ma'am. Now, so far as grant records is concerned, the petitioner grant records itself is not available.
ನೀವ್ ಹೆಂಗ್ರಿ ಹೇಳ್ತೀರಾ ಅದು? Who are you
Not
to say
available.
all this?
I'm not
Please,
telling my lord.
please understand where you stand.
Yes, ma'am.
You can only say about your documents and your claim to the land in terms of the document under which you claim title.
Correct.
You can't say our grant ಮಾಡಿರ್ಲಿಲ್ಲ. Who are you to say? Who are you to say that?
He's
If you please
claiming
read
my
the
land.
last,
Only.
if you please read the last paragraph.
Yes, my lord.
It says they will verify, and if it is possible to amalgamate and mark the boundaries.
Maybe short
They will do it
accommodation,
in
my lord.
accordance with
Maybe
law.
Tuesday it may be taken. Only short accommodation.
For what?
To make a submission.
I am not closing the writ petition, sir. I am not disposing of the writ petition.
Yes, ma'am.
So if the authorities want to conduct the exercise, all of you will participate in the exercise. Let us see what is the outcome. They are not going to finally settle the matter without the orders being passed by this court. But in the meanwhile, if they want to verify the records, get the information from all the persons who are claiming, and try to identify the individual properties, let them do it. It may be in your interest also, who knows?
He had engaged the senior counsel, is not been
A
there,
Burkle
it may be short
This is not
accommodation.
This is not tried.
ಅಷ್ಟೇ ಅದಕ್ಕೋಸ್ಕರ
ಹಂಗಿದ್ರೆ ಬರ್ಬೇಕಾಗಿತ್ತು. Every hearing you should come then.
ಇಲ್ಲ. But today was having.
You know what were the orders that
I
were
know.
passed by this court last
I
time?
know.
Then, in terms of the directions issued by this court on 21/2/2024, the learned HCDP has filed a memo along with a communication made by the commissioner, survey settlement and land records, Bengaluru, and a short report of the status of the survey records pertaining to survey number 35 of Meesaganahalli village, Jala Hobli, Yalanka Taluk. Full stop. A copy of the same is served on the learned counsels for the petitioners as well as the contesting respondents. Full stop. Next para. On going through the status report, it is clear that the commissioner is of the opinion that
body of body other than 74 are all not integrated, may have to be
but
taken.
it says after due orders from deputy commissioner.
ಹೌದು, ಅಂದ್ರೆ ಅವರು ಪರ್ಮಿಷನ್
ಅಂದ್ರೆ
ಮಾಡ್ತಾರೆ.
that exercise has to be undertaken first.
Please, ಆ ಮಿಸ್ಸಿಂಗ್ ಕಮಿಟಿ
ಅಲ್ಲ, ಅವರು ಮಿಸ್ಸಿಂಗ್ ಕಮಿಟಿ ಅವರು ಯಾರಾದ್ರೂ ಪರ್ಮಿಟ್ ಮಾಡಿದ್ರೆ ದಿಸ್ ಕ್ಯಾನ್ ಬಿ.
ಇಲ್ಲ, they cannot say anything now unless the records are built. So we will once again direct the deputy commissioner. ಇವಾಗ election time. ಏನ್ ಮಾಡೋದು?
ಅಲ್ಲ, ಅಷ್ಟೊಂದು ಇದ್ ಮಾಡಿ ಇರ್ಲಿ, ಅಕಸ್ಮಾತ್ ಆದ್ರೆ ಆಗ್ಲಿ, ಆಗದೆ ಹೋದ್ರೆ ಇಟ್ ವಿಲ್ ಬಿ ಮತ್ ಸ್ವಲ್ಪ ಟೈಮ್ ಕೊಡ್ಬೋದು.
That after due orders are passed by the deputy commissioner, in terms of the directions issued by this court for building up the records, the survey settlement authorities may proceed, conduct re-podi and amalgamate the RTCs with the new survey numbers 75 to 89. We'll stop. Next para. In that view of the matter, the deputy commissioner is once again requested to proceed for building up the missing records, as was directed by this court in the previous order dated 21/2/2024. Full stop.
This
A
report
copy of this order shall be placed before the deputy commissioner for further action.
ಈ ರಿಪೋರ್ಟ್ ಲೆಟ್ ಇಟ್ ಬಿ ಸೆಂಟ್ ಟು ಡೆಪ್ಯೂಟಿ.
The deputy commissioner shall also take note of the report submitted by the commissioner of survey settlement and land record. Release this matter on 22nd of April.
Number 22, P. Mahesha, non-filing affidavit.
Appearing for R5, I was directed to file affidavit of the land action officer to indicate certain directions. I could not get informations. Sort, sent a copy of this order and sought information, could not finalize the information for want of instructions.
Then how can they take so much of time to even make a statement?
It's my, this is the first time I'm facing such a difficulty in my career. Some confusion is overlapping and something they're telling, and almost all know the posted for election duty, something there.
Alala, see, he was first of all required to say.
They say it will pass within the acquired area.
Allah, first, whether the name of the petitioner is found in the notification, extent of land is shown or not, one. ಎರಡನೇದು, without showing the name of the petitioner.
Compensation.
But the land has been acquired, notified, acquired, and it falls within the notified area. ಎರಡನೇದು. Then what is the future course of action? Ishte more information.
If it is passed within their entitled compensation, that's all.
How much time do they require for this? Learned Counsel Sri P.V. Chandrasekhar, appearing on behalf of the fifth respondent KADP, seeks for some more time to comply with the directions issued by this court on 15/2/2024. Full stop. ಯಾವಾಗ ಬೇಕು?
10 days or 10 days.
Release this matter on 2nd of April.
Lordship also say, my lord, if suppose no affidavit is filed, let them appear personally, otherwise buyer.
If the SLAO does not give the requisite information to the
Affidavit is not filed on our particular date, then we have to appear.
or does not file any affidavit, the SLAO, fifth respondent SLAO shall be present before this court on the next date of hearing.
Number 23.
Yes.
I have filed my
Rectification of office objections.
In view of the liberty given to me, my lord, I have filed for Wakalath yesterday, my lord, because both the petitioners were.
Fresh Wakalath.
Yes, yes.
Learned counsel Srimati Rajeshwari M. submits that she has filed fresh Wakalath
Please, my lord.
on behalf of the petitioner.
Petitioners on the.
Full stop. Office to verify. Full stop. If the Wakalath filed by learned counsel Srimati Rajeshwari is accepted, the name of learned counsel Sri Siddhamallappa PM may be removed from the cause list.
Please.
Yes.
Number 24. Pawan Kumar Ji. Acknowledgement.
Serve the papers, my lord. Serve the papers. Mandamus.
It is not.
ಏನಕ್ಕೆ ಡೇಟ್ ಕೊಡ್ಬೇಕು?
Previous matter ಅಲ್ಲಿ.
ಏನಕ್ಕೆ ಡೇಟ್ ಕೊಡ್ಬೇಕು?
It is a compromise recorded before the competent civil court. ಅವರು ವಕಾಲತ್ ಹಾಕ್ಲಿಕ್ಕೆ ಅಂತ ಹೇಳಿ last date of hearing they took time. I think they have filed the wakalat. It has to be disposed of since the revenue records are mutated in the name of the petitioner herein.
ಏನು ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಕೊಟ್ಟಿದೀವಿ ಅವ್ರು?
ಕೊಟ್ಟಿದೆ.
ಏನಂತ?
Entry order is granted stay of the orders passed by the deputy commissioner.
Let us see. Yes.
Director of land record had directed some corrections, my lord, at annexure A, sought for implementation of annexure A.
ಏನ್ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ? Initials.
ಕೆಲವು ಕೋಡಿಗಳಾಗಿಲ್ಲ ಮತ್ತೆ ಹೆಸರು ತಪ್ಪಾಗಿದೆ. ಪೇಜ್ ನಂಬರ್ 12 ಲಾಸ್ಟ್ ಪ್ಯಾರಾ.
ಅವ್ರ ಇನಿಷಿಯಲ್ ತಪ್ಪಿದೆ.
ಇನಿಷಿಯಲ್ ತಪ್ಪಾಗಿದೆ, ಹೆಸರುಗಳು ತಪ್ಪಾಗಿದೆ, ಮತ್ತೆ ಕೋಡಿ ಸರಿಯಾಗಿ.
ಅದೇ AN ನಂಜುಂಡಪ್ಪ.
ಹೌದು sir.
ಹಾ.
ಮತ್ತೆ ಕೆಲವು ಸರಿಯಾಗಿ ಕೋಡಿ ಆಗಿಲ್ಲ, ಅವೆಲ್ಲ ಡೈರೆಕ್ಟ್ ಆಫ್ ಲ್ಯಾಂಡ್ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ನಾವು ಪ್ರೊಸೀಡಿಂಗ್ ಇನಿಷಿಯೇಟ್ ಮಾಡಿದ್ವಿ. ಅದರಲ್ಲಿ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದೀವಿ.
Yes.
Lord, what has happened is, the said, subsequent to the said direction given by the said officer, Tahsildar has made a representation to the technical director, deputy director of technical assistance. ಈ ತರ ತಾವು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದೀರಿ. ಇದನ್ನ ಮಾಡೋದಕ್ಕೆ ILO ಮತ್ತೆ RR ಇಲ್ಲ ರೆಕಾರ್ಡ್ಸ್. ಅದಕ್ಕೆ ಯಾವ ತರ ಮಾಡಬೇಕು ಅಂತ. Subsequently what has happened is, ಇದು ಜೋಡಿ ಗ್ರಾಮ ಅಂತ ಹೇಳಿ the entire village there is no IL and RR. And the petitioner who is before the court, our ಹೆಸರಲ್ಲಿ ಇವತ್ತಿನ ತನಕ RTCನೇ ಇಲ್ಲ. It doesn't stand in his name for the list whatever is shown in the said order. ಯಾವ ಸರ್ವೆ ನಂಬರ್ಗೂ ಅವ್ರ ಹೆಸರಲ್ಲಿ RTC ಇಲ್ಲ. ಅವ್ರು ಏನ್ ಕೇಳ್ತಿದಾರೆ, ಈ ಹೆಸರು ನಂದು ತಪ್ಪಿದೆ, ಅದನ್ನ ನೀವು ಮಾಡೋ ಟೈಮಲ್ಲಿ ನಂದು ತಿದ್ದುಪಡಿ ಮಾಡ್ಕೊಡಿ ಅಂತ ಕೇಳ್ತಾ ಇದಾರೆ. ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ದಟ್, ಈಗ ಇದು ಹೊಸದಾಗಿ ಕೋರ್ ರಿಲೇಷನ್ ರಿಜಿಸ್ಟರ್ ಅಂತ ಹೇಳಿ ILA ಮತ್ತೆ RR ಇಲ್ದಿರೋ ಕಾರಣಕ್ಕೆ, this is the original IL and ಇದು co-relation register ಅಂತ ಹೇಳಿ with regard to the entire village. So it has to be, it cannot be done only to him. His request is, ಬೇರೆಯವ್ರು ನೀವು ಆಮೇಲೆ ಮಾಡ್ಕೊಳ್ಳಿ, ನಂದನ್ ಫಸ್ಟ್ ಮಾಡ್ಬಿಡಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಮಾಡ್ಬೇಕಾದ್ರೆ ಇವ್ರೊಬ್ರದ್ದು IL RR ಇದ್ರೆ ಇವ್ರೊಬ್ರದ್ದು ಮಾಡ್ಬೋದು. Because IL and RR is not there, I have summoned the original co-relation register, my lord. I have just made highlighted ಪಾರ್ಟಿ ಹೆಸರು ಪೆನ್ಸಿಲ್ ಮಾರ್ಕ್ ಅಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿದೆ. ಇದು ಅವ್ರ ಹೆಸರಲ್ಲಿ ಸರ್ವೆ ಇಲ್ದಿರೋದಕ್ಕೆ ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಡನ್ ಫಾರ್ ದ ಎಂಟೈರ್ ವಿಲೇಜ್ ಅಂಡ್ ಇಟ್ ಪ್ರೋಸೆಸ್ ಇಸ್ ಆಲ್ರೆಡಿ ಆನ್. ಇಟ್ ವಿಲ್ ಟೇಕ್ ಸಮ್ ಟೈಮ್. ಎಲ್ಲರಿಗೂ ಆಗೋ ಟೈಮ್ಗೆ ಇವ್ರಿಗೂ ಆಗತ್ತೆ ಅಂತ.
ಎಷ್ಟು ಟೈಮ್
ಆಗುತ್ತೆ ಅಷ್ಟೇ.
ಎಂಟೈರ್ ವಿಲೇಜ್ ಮಾಡಬೇಕು. ಪ್ಲಸ್ ಇವಾಗ ಎಲೆಕ್ಷನ್ ಇದೆ.
ನೀವು ಹೇಳಿದ್ರೆ ಇಷ್ಟು ಟೈಮ್ ಆಗುತ್ತೆ ಅಂತ ವಿ ವಿಲ್ ರೆಕಾರ್ಡ್ ಇಟ್ ಅಂಡ್ ವಿ ವಿಲ್ ಲೀವ್ ಇಟ್.
ಈಗ ಎಲೆಕ್ಷನ್ ಇರೋದ್ ಕಾರಣಕ್ಕೆ ಒಂದು 4 months ಟೈಮ್ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ. ಇಲ್ಲಾಂದ್ರೆ 2 months ಅಲ್ಲಿ ಮಾಡ್ಬೋದು. ಬಟ್ ಈಗ ಎಲೆಕ್ಷನ್ ಮುಗಿದಿ ವಿತಿನ್ 4 months ಅನ್ಸುತ್ತೆ.
ಬರ್ಕೊಳ್ಳಿ. Okay, 13/3/2024 ಅಲ್ಲಿ paragraph number 3, the grievance of the petitioner is ಅಂತ ಇದೆ. ಆ entire paragraph ಹಾಕೊಂಡು. Next para. Accordingly, this court had directed the learned HCGP to secure instructions from the second respondent Tahsildar as to why the corrections have not been carried out in spite of a communication made by the Deputy Director of Land Records on 9/10/2023. Full stop. Next para. Today, the learned HCGP submits on instructions that Pannampalli village where the land in question is situated is a Jodi Inam village, and since it is a Jodi Inam village, survey settlement had not taken place, and the IL and RR are not available for the entire village. Full stop. Nevertheless, action has already been taken to survey the entire village and
as per core
survey the entire village as per the correlation document that is available with the authorities. Full stop. Learned HCGP further submits that it would not be possible to conduct the survey only in respect of the lands claimed by the petitioner. Full stop. The grievance of the petitioner will be redressed while the authorities complete the survey settlement exercise in respect of the entire village. Full stop. Next para. To a pointed question posed by this court as to what is the time required for the authorities to complete the entire exercise. The learned HCGP submits that normally the exercise exercise can be completed within a period of 2 or 3 months. However, having regard to the code of conduct announced and the staff from the department being drawn for election duty, a little more time may be required beyond what is required in the normal circumstances. Full stop. Next para. Consequently, the writ petition stands disposed of with the direction to the respondent, Tahsildar, Bagyapalli Taluk, and the Deputy Director of Land Records Chikbalapura district to complete the exercise of surveying the village in question and settling the survey and land records as expeditiously as possible and at any rate within a period of 4 months from the date of receipt of a copy of this order, ordered accordingly.
Grateful. 25, Sharath S. Gowda.
The prayer was to remove the RRT proceedings in column. Have been completed.
Illustration, paragraph number 3 ಅಲ್ಲಿ the grievance of the petitioner ಅಂತಿದೆ. ಅದು ಪೂರ್ತಿ ಹಾಕೊಂಡು next para. In terms of the directions issued by this court, the learned HCGP submits that the grievance of the petitioner has been redressed. ಏನ್ ಮಾಡಿದಿರಾ?
By removing case reflecting RRT proceedings from column number 11 of the RTC.
Deleting the endorsement made in column number 11 of the article. That is the words RRT bracket 2 bracket S CR 14/2022-23 have been removed from column number 11. Full stop. Next para. Learned counsel for the petitioner submits that the needful has been done and the petitioner is satisfied with the action taken by the respondent Tahsildar. Full stop. Accordingly, the writ petition stands disposed of.
Here number 26.
For the petition.
Nataraja HT.
Despite the suit for declaration came to be dismissed, even then without looking into it, the learned, deputy commissioner.
Non-complaints of office subject.
ಏನಂದ್ರೆ while filing the
Chaitanya
ಅವರು she is not well. And she has been admitted in psychiatric patient ಆಗಿ admit ಆಗಿದ್ದಾರೆ. ಅದಕ್ಕೆ ನಾನು make a necessary application. No. Factual matrix of the case is concerned, measure, my lord. The deputy commissioner, my lord, in spite of passing a, judgment and decree, that is a dismissal of the suit. And he passes an order by overlooking into the written argument as well as the, he specifically notes that there is a case pending, even then he did not observe in the order, my lord. I take your lordship and attention to the.
ಅಲ್ಲ ಇವಾಗ ಏನು, have you put up a note or what are you doing? Do you have to do something about this?
ಅಲ್ಲ ಅದೇನೆ ಅವ್ರು ಹುಷಾರಿಲ್ಲ ಅಂತೆ, ಅದಕ್ಕೆ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಇದಾರಂತೆ. Is unable to sign. That's the reason there is a certificate. Psychiatric.
ಒಂದು ಮೆಮೊ ಫೈಲ್ ಮಾಡಿ ಅದ್ರ ಜೊತೆಗೆ
ಹಾಕ್ತೀನಿ. ಹಾಕ್ತೀನಿ. ಮೆಮೊ ಹಾಕ್ತೀನಿ.
ಕೊಡಿ, please give that one. Regarding office objections, that petitioner number 9, P. N.S. Chaitanya, son of late G. Srinivasa, before the Special Deputy Commissioner in RP number 39 of 2017, he is not a party to these proceedings. Come on, learned counsel for the petitioner has filed a memo along with a discharge summary from the Department of Psychiatry, Nimhans, Bengaluru, and submits that the said Sri Chaitanya is not in a position to join the petitioners in this writ petition. Please, full stop. Next para. The submission of the learned counsel for petitioners is accepted. Office objection is overruled. The
My lord, the deputy commissioner confirms the order passed by the assistant commissioner, my lord. 1946, my lord, one Dasappa died intestate, my lord, leaving behind 2 children. And 2 children, they enter into a partnership, registered partition deed, my lord.
The contesting respondents approach the assistant commissioner.
Please, my lord. Please, my lord. The petitioners before the court, they file a
challenging a mutation entry in MR number 28 of 1984-85.
The respondents before the assistant commissioner challenges the MR number, and the assistant commissioner cancels the MR number. And
on what ground?
On the ground that there is a registered partition deed ಇದೆ ಅಂತ ground.
ನೀವು appear ಆಗಿರಲಿಲ್ಲ.
Appear next ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿ DC ಮುಂದೆ ಇವರು petitioners appears before the DC special deputy. In meanwhile, people who have gone to the assistant commissioner files a suit for declaration to declare that they are the absolute owner by virtue of the registered partition deeds dated so and also they are in possession of the property. They also seek for injunction suit. That came to be dismissed on a trial. And which fact has been narrated before the deputy commissioner. In spite of all these aspects, the deputy commissioner, by overlooking all these documents.
There is that judgment.
May I take your lordship and attention to Annexure L, my lord. Annexure L, Implead number 47. OS number 1210 of 2009. May I take your Implead number 49. Partition and separate possession in respect of property and also declaration, which came to be dismissed by a judgment and decree dated 29th June 2022. These facts, again, the challenge before the Rural District Session Court in RA, which also came to be dismissed because they withdrew it. The lordship would find it in Annexure N. Annexure N, appellant 2 and his counsel present, appellant's counsel submit, the appellants are not interested to prosecuting the appeal, and the appeal memo so and so in view of submission, the appeal is dismissed.
Specific admission regarding the earlier partition.
Please,
between the father of the plaintiff and his brother long back in the year 1946 itself, prior to the birth of petitioner, plaintiff number 2 and 3. So the question of partition again between the plaintiffs and defendants does not arise. ಬರ್ಕೊಳ್ಳಿ. ಏನಾಯ್ತು? ಆರೇ ಹಾಕಿದ್ರ?
ಆರೇ ಇದರಲ್ಲಿ ನಮ್ಮ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಏನ್ ಮಾಡ್ತಾರೆ? ರಿವಿಷನ್ ಪಿಟಿಷನ್ ಅಲೋ ಮಾಡ್ತಾರೆ. ಕನ್ಫರ್ಮಿಂಗ್ ದಿ ಆರ್ಡರ್ ಪಾಸ್ ಬೈ ದಿ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್.
ಅಲ್ಲಲ್ಲ, ದಿಸ್
ಆರೇ ಹಾಕಿದ್ರೆ ಇವರೇ ವಿಡ್ರಾ ಮಾಡ್ತಾರೆ. ರೆಸ್ಪಾಂಡೆಂಟ್ ಅವರೇ ವಿಡ್ರಾ ಮಾಡ್ತಾರೆ ಆರ್ಯನ. Your lordship would find it in ink page number 86, my lord. Annexure N 86. Annexure 80.
That is after they obtain the order at the hands of the deputy commissioner.
Please, my lord.
Huh? Learned, it's AGA takes notice for response number 1 to 3. Issue notice to response number 4 to 7. Learned counsel for petitioners is directed to serve a copy of the petition along with annexures on the learned AGA. Full stop. Next para. Learned counsel for the petitioners submits that although it was brought to the notice of the deputy commissioner that a suit for partition filed at the hands of the contesting respondents herein in OS number 1210 of 2009 was dismissed by the second additional senior civil judge at Nelamangala. Nevertheless, the deputy commissioner has passed the impugned order.
Annexure A, my lord. Revision petition 39 of 2007.
Upholding the orders passed by the assistant commissioner while directing the Tahsildar to remove the names of the petitioners herein from the RTC. Learned counsel would further submit that no sooner such an order was passed by the deputy commissioner, the contesting respondents have withdrawn the regular appeal filed in
RA
81 of 2022, on 30/11/2022. ಇಲ್ಲ ರೀ, ಅದು ಮುಂಚೆನೆ ಆಗಿದೆ.
ಒಂದು ನಿಮಿಷ ಅದು. Deputy Commissioner says he passed an order not on the date which is mentioned.
Last sentence ತೆಗೆದ್ಬಿಡಿ. Learned counsel further submits that the private respondents herein have withdrawn the regular appeal filed by them in RA so and so on
30/11/2022.
30/11/2022. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned orders at annexures A and B till the next date of hearing. Please.
Passed over matter. Serial number 1, Virama Takka Mahadevi.
Election laws only not one prayer, my lords, is to direct the respondents to survey the scale, measure the land and fix the adverse.
You know?
The petitioner has got the property in the partition, my lords. Now, my lords, he is only requesting this honorable court, my lords, to direct the respondents to measure the land and to fix the boundaries, that's all, my lords.
Partition in the year 1994.
Yes.
Ah.
That is, there is no dispute regarding all this. Only this adjacent lands are there. He gave a request letter to the second respondent to measure the land.
This is Podi and Durast.
That's only to measure and.
Now they have come before the court for only for adverse to Milord.
Adene.
But our prakara, they say it is a Podi has already been done. New survey number has been allocated anta heltar avaru. But my information, Milord, I have just taken the latest. RTC.
Boundaries are not.
Adralli Podine agilla inna. It is still in old 176 number. ಅಷ್ಟು ಜನಕ್ಕೂ ಸೆಕೆಂಡ್ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ ಅವ್ರ ಹೆಸರು ಮಂಜುನಾಥ್ 176 ಅಂತ ಅಷ್ಟೇ ಇದೆ ನಂಬರ್. ಇವ್ರು ಹೇಳತಾರ 176/44 ಅಂತ ಎಲ್ಲೂ ಆಗಿಲ್ಲ ಇನ್ನ. ಸೊ ನೌ ದೇ ಹ್ಯಾವ್ ಟು ಫಸ್ಟ್ ಗೆಟ್ ಪೋಡಿ ಡನ್, ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ದೇ ಕ್ಯಾನ್ ಫೈಲ್ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ಅದ್ಬಸ್.
ಅದೇ ಪೋಡಿ ಅಂಡ್ ದುರಸ್ತ್ಗೆ ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡಬೇಕು ಆನ್ಲೈನ್
ಫಾರ್ ಪೋಡಿ ಅಂಡ್ ದುರಸ್ತ್. ಅದ್ಬಸ್ತಿಗೆ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
We'll have to file an online application for Podi and Durast.
Yes, my lords.
It will be done in 2 months' time. Same model.
In fact, my lords, 176/24 is a number given that is there in annexure B, my lords, at page number 56.
Yes, please file an online application. They will consider.
My lords, time may be fixed, my lords.
Ide fix ಮಾಡಿದೆ 2 months' time.
Oh, yes.
Yes.
Number 12. Imana.
Petition. Petition is challenging the impugned order dated 10/10/2023 passed by the first respondent deputy commissioner. On the ground that, my lord, the deputy commissioner, see, without giving an opportunity to the petition number 2 herein, who has acquired the title by virtue of gift deed and mutation was effected in her name, wide MR number 5/2122, my lord. So without giving an opportunity to the petition number 2, and the same has not been challenged before the first respondent. In spite of that,
who approached the assistant commissioner?
My brother, mine. That is respondent number 4.
Private respondent.
Respondent number 4 approached. And yes.
Seeking what?
So the outcome of that.
The MR number challenging MR number 11 of 1996-97.
97. So in 1997, it is affected based on the statement given by my father. My originally the property is my self-property of my father, my lord. And my father, taking into consideration my service rendered by me towards family as well as health issues, and he himself has given a statement before the assistant revenue. Please, Allah, health is
ಆಗಲ್ಲ ಹಂಗ
ಅಲ್ಲ ಸುಮ್ಮನೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಡು ಸುಮ್ಮನೆ
ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
ಅದು ಹಾಗಲ್ಲ ಸ್ವಾಮಿ ಅದು ಆಗಲ್ಲ.
96-97 ಅಲ್ಲೂ ಮಾಡಕ್ ಬರಲ್ಲ ಹಂಗೆ.
ಮಾಡಕ್ ಬರಲ್ಲ ಸ್ವಾಮಿ. See, I am not claiming rights on that. Please, my lord, I am not claiming rights on that. See, next ಏನಾಗುತ್ತೆ ಸ್ವಾಮಿ, thereafter, see, in 2009, my father has executed a will, and my father died in the year 2013. And all these facts which the revenue record students in the name of me is well within the knowledge of all my family members. And the will, my father died in the 2013. And my uncle, who is having the will, who is the executor of that will.
ಏನಾಗಿದೆ ಇಂಪ್ಲಿಮೆಂಟ್ ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ?
So implead orders ಅಲ್ಲಿ ಏನಂದ್ರೆ without giving implead order set aside and order to restore the RTC in the name of my father.
Correct.
So ಇಲ್ಲಿ ಪ್ರಾಬ್ಲಮ್ ಏನಾಗ್ತಾ ಇದೆ ಅಂದ್ರೆ see, in the meanwhile, in the sense, even from 1997 ಆದ್ಮೇಲೆ ನಮ್ಮ ತಂದೆ ಬದುಕಿರುವವರೆಗೂ see, ನೀವು ಇದನ್ನೆಲ್ಲ ಮಾಡ್ಕೊಂಡು ನಮ್ಮ ತಂದೆ at the instruction of my father. Thereafter, see, I have borrowed the loan, I have developed the land like anything.
ಏನೇ ಮಾಡಿರ್ಬೋದು ಕಾನೂನು ರೀತಿಯಲ್ಲಿ ಅದು ಊರ್ಜಿತ ಆಗಲ್ಲ. So the orders are correct. It's in accordance with law. The moment there is a will, there is a dispute. That has to be resolved only by the civil court. Therefore, the orders are that go get a declaration at the hands of the civil court. Till then, the kata will be restored in the name of your father.
My brother has filed a OS number. See, only in respect of this property, not including the other family properties, ancestral properties. That is OS number 211/2016, my lord. I have produced at Implead number, my lord. Sorry, 114 annexure R also, our suit file ಮಾಡ್ತಾರೆ ನಮ್ಮ brothers. Only making me and my brothers, not there, he has not included my all other sisters. And he has only filed this suit against only in respect of this suit property only, not other properties, ancestral properties. So idralli I have appeared that petition number 1 appeared before the honorable court, and he has filed an statement, detailed statement. He has produced the will through executor, that is my uncle. The will has been examined and it is thoroughly cross-examined, and the will has been proved. Now the matter is set down for the argument. This is the stage.
Declaration aad takshana you will be entitled to have the name.
Swami, ನನ್ನ problem ಏನಪ್ಪ ಇದೆ ಅಂದ್ರೆ, in the meanwhile, when we have borrowed the loan from the banks, my lord,
Learned Swami, AGA takes notice for response number 1 to 3. Issue notice to respond number 4. Learned counsel for petitioner is directed to serve a copy of the writ petition along with annexures on the learned AGA. ಬರ್ಲಿ ಅವರು ನೋಡೋಣ.
Swami, it's my only request. Swami, ಏನಂದ್ರೆ, Swami, ನಾವು ಲೋನ್ ತಗೊಂಡು ಬ್ಯಾಂಕ್ ಲೋನ್ ತಗೊಂಡಿದೀವಿ, because the RTC change. The bank people are they are initiating the criminal proceedings against me.
Yes.
Please, Swami. Interim order.
No, sir.
Yes, Sridhar. Including proposed R8.
Appear for the petition. Lord, the petitioner Penchava, Lord, respondent number 3 Ambava, respondent number 4 Siddhava, all are sisters, madam.
Who has filed this application for impleading?
ನಾನೇ ಹಾಕಿದೆ. ಅವರು that respondent number 3 is trying to alienate the property during.
Proposed respondent number 8.
8 ಅಂತ.
ನೋಟಿಸ್ ಹೋಗಿದ್ಯಾ?
ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಹೋಗಿದೆ, ಯಾರು ಅಪಿಯರ್ ಆಗಿಲ್ಲ. R3 ಮಾತ್ರ ಒಬ್ರು ಲಾಯರ್ ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ, ಬಟ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿಲ್ಲ.
So ಇದು order has not been passed. Impleading.
ಅಲ್ಲ, ನೋಟಿಸ್ ಅಂತ ಆರ್ಡರ್ ಆಯ್ತು.
ಅಲ್ಲಲ್ಲ, orders have not been passed on that IA.
IA ಮೇಲೆ ಆರ್ಡರ್ಸ್ ಆಗ್ಲಿಲ್ಲ.
Today it has come up for the orders on that IA.
13/9/22 ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು ಆನ್ IA 2 of 22 ಅಂತ ಆರ್ಡರ್ ಆಯ್ತು. ನಾ ಪ್ರೋಸೆಸ್ ಕೊಟ್ಟೆ, ಜಾರಿ ಆಯ್ತು. R3ಗೆ ಜಾರಿ ಆಗಿ ಇದು ಹಾಜರಾಗಿದ್ದಾರೆ, ಬಟ್ ಯಾರು ಬಂದಿಲ್ಲ. R3 ಮತ್ತು ಅವ್ರ ಮಗ ಅದನ್ನ ಮಾರ್ಬೇಕು ಅಂತ ಹೇಳಿ.
Orders on IA number 2 of 2022. ರಘು ಪುಟ್ಟಾಜಿಯವರು.
ಇನ್ನವರು ಪರ್ಚೇಸ್. ಇದು ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟಿ.
ಎಲ್ಲಿ ಬಂದಿದೆ? ಅವ್ರದ್ದು ನೋಟಿಸ್ ವಾಪಸ್ ಬಂದಿದೇನ್ರಿ? ನೋಡ್ರಿ, ರಘು ಪುಟ್ಟಾಜಿ ಅವರು ಅಂದ್ಬಿಟ್ಟು
ನೋಡಿ ಜಾರಿ ಆಗಿದೆ. ಕಾರ್ ಲಿಸ್ಟ್ ಪ್ರಕಾರ
ಇಲ್ಲ, ಅದು ತಪ್ಪಾಗಿ ಬರ್ದಿದ್ದಾರೆ. ಪ್ರಪೋಸ್ಡ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 8 ಶೋನ್ ಸ್ಟೇಟ್ ಆಫ್ ಕರ್ನಾಟಕ. ನೋಡಿ,
ಇಲ್ಲ, ನಾನ್ ರಘು ಪುಟ್ಟೇಜಿ ಅವರಿಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೆ. State first respondent.
When was it ordered? Notice?
Notice was ordered on 13/9/22.
Issue emergent notice on IA 2 of 2022. That was on 13/9/2022. ಬಂದಿದೆ ನೋಡು. ರಘು ಪುಟ್ಟಾಜಿ ಅವರು
ಅವರಿಗೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು.
ಇದ್ರಲ್ಲಿ ಎಲ್ಲಿರ್ತದೆ ನೋಟಿಸ್ ಹೋಗಿರೋದ್ರಿ? ಇಲ್ಲ,
next week
office is directed to put up the B file to verify as to whether notice on IA number 2 of 2022 has been served on the proposed respondent. Release this matter on 27th of March.
Number 28.
On behalf of respondent number 4, I filed this early hearing.
You have filed application for early hearing?
Yes, yes.
What is the matter about?
Regarding
163, 136(3), Lord, order has been challenged before the South Court, at the Deputy Commissioner. Lord, annexure A, my Lord, here what had happened?
Suit has been filed.
Suit, yes.
61 of 2018.
That was decreed, my Lord.
Who has filed the suit?
My Lord, I have filed the suit. Petitioner hearing.
Suit for declaration.
Declaration filed by them, my Lord, respondent number 4. Initially, my Lord, annexure B.
61 of 2018
Please, that
is
is
filed by
respondent number 4.
Shiriyara Muddanna Shetty.
Yes,
Respondent
my client.
That is only against the Deputy Commissioner.
Yes, yes.
For declaration.
Actually, my Lord, that earlier what had happened, my Lord, Deputy Commissioner, my Lord, passed an order, Lord, directing the entry my name in the mutation register. That was challenged by a suit, my Lord, by him earlier.
Without impleading you?
Without impleading me, that was dismissed. Only Deputy Commissioner was a party. Later, my Lord, he filed a review petition. Your Lordship may kindly see annexure, my Lord, G.
That suit was dismissed.
Please. Before that, my Lord, annexure G, my Lord, order dated 16/2/2017. Annexure G, may kindly.
Page number?
Page number 85. Lord, the petitioner herein, Lord, has entered into an agreement with one Padma Hegde in the year 2009. Insofar as, my Lord, 1 acre 88 cents of land in survey number 148. Lord, later, my Lord, she has not executed a sale deed. I filed a suit for specific performance in the year 2012. But that suit was decreed.
You are agreement holder.
Agreement holder. That suit was decreed in.
No, my Lord.
But though there is a court order, there was a prohibitory order. But again, she sold the property to GP holder to him in the year 2015. Already some suit decree agreed specific performance. Even she was a party to the specific performance suit. Later what had happened, my Lord?
Yavagadu decree agiddu?
Decree annexure B, my Lord, 2015, 15 July 2015. Decree agid. After
in the meanwhile, she has sold it.
Sold the property him. He filed an application before the Tahsildar to change the mutation in his name. Tahsildar.
Nimdu suit decree admele execution case was filed?
No, my Lord, she filed an appeal. RA was filed by the.
That RA is still pending.
It's still pending.
Still pending, but my Lord, she filed an affidavit before High Court stating that I will withdraw that RA. Later, I filed a criminal case against him. Lord, that auto copy also I produced in this petition. He appeared in the criminal petition and later the joint memo was filed. She undertook to withdraw that RA.
Withdraw?
That RA filed by her before the challenging.
Or entering the name in the land record.
No, and specific performance decree. My decree has to execute it.
The total.
As against my decree, the owner preferred an RA. RA was pending. Not,
so that has been withdrawn.
That has been not, that information I did not because I filed a NOC Wakalath. Earlier advocate was expired, Chandrasekhar Achar. Recently I filed Wakalath.
So Lordship may kindly fix a date. I will.
No,
detailed arguments are to be filed. No, there is a discrepancy between.
Sir, we are only concerned with revenue entries.
One minute, sir, my Lord. Today I am not on the merits of the matter. Kindly fix a short date and I will argue the matter.
One more aspect, my Lord.
Kindly fix a short date and.
Deputy Commissioner himself reviewed his order. The Lordship annexure G was earlier order.
There is a discrepancy between the land which is shown in the agreement of sale and the sale deed. So therefore, my Lord, there is a kindly fix a short date and I will argue the matter.
Allah, but of course, because the RA was pending, you are not able to proceed for execution.
Please, execution.
And no sale deed has been executed in your favor.
No sale deed has been executed till today. But however, my Lord, the advocate who has represented my Lord Padma Hegde before the trial, he only purchased the property. The respondent number 4 here is an advocate, practicing advocate. He only purchased the property from us.
Nodi,
Short date, I will, there is a substantial thing to be submitted, my Lord. Substantial thing to be submitted. Kindly give a short date and we will argue the matter.
Please understand.
Yes,
that there is a decree that he has obtained by at the hands of the civil court. In
I
the
agree with-
meanwhile,
Yes,
if the advocate himself has purchased the property, then it is very difficult.
no, what is in the,
Please understand.
yes, I have understood, my lord. Kindly have it.
Next, on 27th, please come prepared.
Yes, yes,
List this matter for final disposal
yes.
on 27th of March 2024 at 2:30 PM.
Please, apply.
Serial number 29. Jaikirti MC.
Petition. I filed this application for earlier. This matter, madam. The land endowed to the temples, village temples, madam, have been granted in favor of the respondent number 3, 6 and 9, madam.
ನೀವೇ contesting respondent
ಹೌದು.
purchasers.
Purchaser.
ಬೇರೆ respondents?
Two ಇದಾರೆ ಅವ್ರುನು.
They have sold the property.
2 and 9.
After obtaining the grant, madam, the lands have been sold in favor of the respondents number 10 and 11. Boregowda and Vanraj.
This matter for final disposal on 27th of March.
Serial number 30.
Serial number 30. I represent.
Respondents for 3, 4 and 6.
Second R6.
This
R6
case,
have already filed the Wakalath.
it have been filed. Now during the pendency,
IA number 1 of 2023.
now during the pendency,
Including proposed applicant
the
as respondent number 6.
sold the land in question in favor of respondent number 6.
We have not, no objection to allow the IA application. We have
Fine.
already filed the Wakalath for R6, my lord. On rule 10 application, my lord.
Application.
Petitioner has filed 1 rule 10 application. Petitioner has filed 1 rule 10 application, my lord, to bring the proposed respondent number 6.
Advocate for petitioner.
Yes, my lord.
I am for petitioner.
You have filed IA number 1 of 2023.
Now during the pendency of this writ petition, the respondent.
You have filed IA number 1 of 2023 for impleading.
Impleading ಹಾಕಿದ್ದೀನಿ. Respondent number 6 ಗೆ ಮಾಡ್ಬಿಡಿದಾರೆ ಈಗ.
Learned counsel says it can be allowed.
Okay, okay. Sale date is dated 9/3/2023.
There are any other private respondents?
Yes, ma'am. 3 and 4. We are appearing for 3, 4 and 6, my lord.
ಅವ್ರಿಗೂ ನೀವೇ
Yes, my lord.
Order on IA number 1 of 2023. This application is filed by the petitioners to implead the proposed respondent as a party respondent to these proceedings. Full stop. Learned counsel for the other contesting respondents.
Yes, ma'am. R5 we are not appearing, my lord. R3, 4.
Other contesting respondent number
3, 4.
3, 4.
And this proposed respondent, R6, my lord.
Response number 3 and 4 submits that the learned counsel has also filed Wakalath on behalf of the proposed respondent number 6.
Yes, ma'am.
Full stop. The learned counsel further submits that the application may be allowed.
Allowed.
Full stop. Next part. Accordingly, the application is allowed. Full stop. The proposed respondent, namely Shri H.P. Boregowda, is permitted to be impleaded as a party respondent to these proceedings.
Yes, ma'am.
Full stop. Learned counsel for the petitioner shall carry out the amendment in the cost title and furnish amended cost title within a period of 1 week from today.
Yes, Lord. Okay.
Yes.
2 weeks. 2 weeks.
ಇದಕ್ಕೆಲ್ಲ ಏನಕ್ಕೆ 2 weeks?
ಸ್ವಲ್ಪ ನನಗೆ ಉಪಯೋಗ ಇರ್ಲಿಲ್ಲ, ಅದರಿಂದ ಬರೋಕ್ಕಾಗ್ಲಿಲ್ಲ, ಮಾಡ್ಬಿಡ್ತಿದ್ದೆ.
ಆಯ್ತು, 2 weeks. Early hearing.
Petition.
Early hearing.
Land reforms.
Huh?
Land reforms. Some report.
ಅಲ್ಲಿ ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದೀವಲ್ಲ, IAS ಅಕಾರ್ಡಿಂಗ್ ಟು ಡಿಸ್ಪೋಸ್. List this matter for final disposal on 2nd of April 2024. IA number 1 of 2024 is accordingly disposed of.
My lord, on submission. My lord, serial number 37, my lord. I am for respondent number 4 and 5, my lord. I have given NOC to the clients, my lord. My name may kindly be deleted, my lord.
Not now, sir. Please wait. Okay. We'll continue at 2:30. No adjournments now. We'll take it up.
Serial number 39.
ಎರಡರಲ್ಲಿ ಒಂದು ಮೆಮೊ ಹಾಕಿದ್ದೇನೆ, ಪುಟಪ್ ಆಗಿದೆ. ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟ್ರ್.
ಏನ್ ಮೆಮೊ ಸರ್?
ಮೆಮೊ 2.
ಏನ್ ಮೆಮೊ?
ಅದು ಮೆಮೊ ಫಾರ್ ಡಿಸ್ಪೋಸಲ್. ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಬರ್ಲಿಲ್ಲ ಅದಕ್ಕೆ.
ಎರಡೂವರೆದು 2:30 ಇದೆ.
2:30 ಇದೆ.
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಆಯ್ತಾ? M30 ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ M30
ಇದೆ ಇಲ್ಲೇ ಇವಾಗ ಅದು ಬರ್ಬೇಕಲ್ಲ ಸರ್ ಗೌರ್ಮೆಂಟ್
ಯಾರು ಕಾಣಲಿಲ್ಲ, ಅದಕ್ಕೆ ಬೆಳಿಗ್ಗೆ ಎಲ್ಲಿ ಎಲೆಕ್ಷನ್
ಒಂದು ಆರ್ಡರ್ ಆಯ್ತಲ್ಲ ಅದ್ರ ಮೇಲೆ ಮಾಡ್ಬೋದು ಅಷ್ಟೇ.
ಯಾವುದು?
ಲಾಸ್ಟ್ ಟೈಮ್ ಒಂದು ಆರ್ಡರ್ ಆಯ್ತು.
ನಮ್ದಾ? ಹಾ, ಇದು ಬೇರೆ ಇದು ಆ ಥರನೇ ಆಗುತ್ತೆ. ಅದು ನಮ್ದು ಟಿಲ್ ವೇಟ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಅದೇ ನಿಮ್ದು ಇದು ಹ್ಯಾಂಡ್ ಕೊಡಿ.
ಅಲ್ಲ, ಲ್ಯಾಂಡ್ ಕೊಟ್ಟಿದ್ರೆ RTC ನಲ್ಲಿ DC ಆರ್ಡರ್ ಇದೆ, ಅದರಿಂದ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ಅಂತ ಹಾಕಿದ್ದು.
DC ಆರ್ಡರ್ ಅಂದ್ರೆ ಗೌರ್ಮೆಂಟ್ ಅಂತ
DC ಜನರಲ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ. ಎಲ್ಲಿ ಚೇಂಜ್ ಮಾಡಬೇಡಿ RTC ನಲ್ಲಿ ಅಂದ್ರೆ. ನಾನು ಲೋನ್ ತೊಗೊಳಕ್ ಹೋದ್ರೆ ಕಾಲಮ್ 12 ನಲ್ಲಿ ಇದೆ, ಅದರಿಂದ ಎಲ್ಲಿ ಲೋನ್ ಕೊಡೋದಿಲ್ಲ.
ಕಾಲಮ್ 4 ಅಲ್ಲಿ ಸರ್ಕಾರಿ ಅಂತಾನೆ ಇರುತ್ತೆ. ಅದಕ್ಕೆ
ಸರ್ಕಾರದಿಲ್ಲ, ಸ್ಟೇಟ್ ಅಂತ ಹೇಳಿದ್ರು.
ಸ್ಟೇ ಅಂತ ಇದೆ. ಅಂದ್ರೆ ಇವಾಗ ಪಾಣಿ
ಯಾರ ಹೆಸರಿದೆ ಅಲ್ಲಿ ಇಲ್ಲಿ ಇದೆ.
ಗೌರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್ ತಗೊಂಡಿದೆ.
ಗೌರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್ ತಗೊಂಡಿಲ್ಲ, ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ದಾರೆ. ಲ್ಯಾಂಡ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ದಾರೆ. ಇದು ತೀರ್ಮಾನ ಉಂಟು, ಯಾವುದು ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಬೇಡಿ ಅಂತ DC ಜನರಲ್ ಆರ್ಡರ್ ಮಾಡಿ. ಇದು ಎಂಕ್ವೈರಿ ನಡೀತಿತ್ತಲ್ಲ, ಆಮೇಲೆ ನಾವು ಬೇರೆ ಕೇಸ್ ಹಾಕಿದೀವಲ್ಲ. ಆ ಕೇಸ್ ಹಾಕಿದ್ಮೇಲೆ ಅಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ, ಯಾವುದು ಇದ್ರು ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಯಾವ್ದು ಮಾಡಬೇಡಿ ಅಂತ.
ಹೇಮಾವತಿ ರಿಸರ್ವ್ಗೆ ಲ್ಯಾಂಡ್ ತಗೊಂಡಿರೋದು, ತಗೊಂಡಿರೋರಿಗೆ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೊಟ್ಟು ಇದು ಕಾಂಪನ್ಸೇಟಿವ್ ಇದು ಕೊಟ್ಟಿರೋದು ಲ್ಯಾಂಡ್.
ಕಾಂಪನ್ಸೇಷನ್ ಕೊಟ್ಟು ಮತ್ತೆ
ಲ್ಯಾಂಡ್
ಕೊಟ್ಟಿರೋದು. ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ
ಮಿಸ್ಅಪ್ರೂವೇಷನ್ ನಡೆದಿದೆ ಅಂತ ಅಂದ್ರೆ ಅಕ್ವೈರೇ ಆಗಿಲ್ಲ, ಲ್ಯಾಂಡೇ ಇಲ್ಲ, ಲ್ಯಾಂಡ್ ಅಕ್ವೈರೇ ಆಗಿಲ್ಲ. ಅಂತರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಲ್ಯಾಂಡ್ ಮಾಡ್ಸ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಎಲ್ಲ. ಅವ್ರು ಮಾಡಿಸ್ಕೊಂಡಿರೋದು ಮುಂದಿರೋರು
ಆ ಥರನ ಮಧ್ಯಾಹ್ನ ಇವಾಗ ಕೂತ್ಕೊಳ್ಳಿ.
ಆ ಥರ ಆಗಿರೋದು ಇಲ್ಲ, ಅವ್ರು ಲ್ಯಾಂಡ್ ಮಾಡ್ಕೊಂಡು
ಆಲ್ಟರ್ನೇಟಿವ್ ಲ್ಯಾಂಡ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
ಅದೇನೈತೆ ಎನ್ಕ್ವೈರಿ ಮಾಡಿದ್ರೆ ಎಲ್ಲ ಸೇರ್ಕೊಂಡು ಅಲ್ಲಿ ಕೆಲವರು ಫಾರಂ 53 ಇಲ್ವೇ ಇಲ್ಲ, ಇಲ್ಲದೇ ಲ್ಯಾಂಡ್ ಮಾಡಿದ್ದಾರೆ. ಭಾರಿ ಗೋಲ್ಮಾಲ್ ಆಗಿದೆ ಅದರಲ್ಲಿ.
ಆರ್ಡರ್ಲೇ ಮೆನ್ಷನ್ ಮಾಡಿ ಪರ್ಸನ್ ಅಷ್ಟು ಅಪ್ಲಿಕೇಶನ್
ಆಮೇಲೆ 1 ಎಕರೆ ಅಕ್ವೈರಿ ಮುಳುಗಡೆ ಇದೆ, 4 ಎಕರೆ 5 ಎಕರೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ನಮ್ದು ಯಾವುದೋ ಒಂದು
ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇದ್ರಲ್ಲೂ ಜಾಸ್ತಿ ಆಗಿದೆ.
ಮೊನ್ನೆ ಹೇಳಿದ್ರಲ್ಲ 2 ಎಕರೆ 1 ಎಕರೆ ಕೇಳಿದಕ್ಕೆ 4 ಎಕರೆ.
ಇದೆಲ್ಲ ಎನ್ಕ್ವೈರಿ ಆಗ್ಬಿಟ್ಟು ಅಷ್ಟೇ, ಪ್ರಾಪರ್ ಎನ್ಕ್ವೈರಿ ಆಗಿದೆ.
ಗೀತಾ ಅದಿಲ್ಲ.
ಸರ್ 230 ಲಿಸ್ಟ್ ತಗೋತೀರಾ?
ಮೂವತ್ತನೇ ಮ್ಯಾಟ್ರ್ ಏನಾಯ್ತು? ಮೂವತ್ತು. 1 week time.
Case number 2. Preliminary serial number 1. RB Sadashivappa.
M reserve ಆಯ್ತಾ? This interim order.
Second time list ಆಗಿದೆ.
ಓ ಅದಾ?
ಹೇಮಾವತಿ
I have sought 2 prayers. If
The other matters also are listed?
ಎಲ್ಲ ಲಿಸ್ಟ್ ಆಗಿದೆ ಆಲ್ಮೋಸ್ಟ್
ಇದೆಲ್ಲ ಅದೇ matters ಆ?
ಎಲ್ಲ ಅದೇ ಮ್ಯಾಟರ್ಸ್ ಆಲ್ 20
ಕೊಡ್ರಿ ಇನ್ನೊಂದು ಕೊಡ್ರಿ. ಅದು ಲಾಸ್ಟ್ ಟೈಮ್ ಯಾವ್ದೊಂದು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ನಲ್ಲ ಯಾವ್ದ್ರಲ್ಲಿ?
Not challenge the order. Challenge the number 11. Of the general order was passed.
What is the prayer? In all these writ petitions?
ಅದು
Your names are not entered in the land record.
No, Deputy Commissioner cancelled the grant.
Huh?
Deputy Commissioner has cancelled the grant.
Cancel the grant.
In some cases, my lord, there are purchasers from the original grantee. Without making purchase as a parties, grants have been cancelled. Though, my lord, our name reflects in the RTC.
ಅಲ್ಲ ಇದು my lord, there is a case that was registered. Special land acquisition officer has passed this order saying that some of the people grantees are not the original grantees. They have not lost the lands by fake documents.
So noticing all those aspects, I passed this order. I thought all these matters are the same nature.
Same.
But in some cases, my lord, in few cases, my lord, the grant is cancelled on the ground that this value of trees has not been paid. That is also in some of the cases.
The reasons may be many.
Please, my lord.
In each case, the reason may be different.
Please, my lord.
But ultimately, what has happened is,
Without any notice and without
without
holding proper inquiry, the impugned order came to pass.
Case is different, my lord. Challenge is that all about 11 in the RTC. The Deputy Commissioner is a general order. ಅದು ನಾನು ರಿಮೂವ್ ಮಾಡೋದಕ್ಕೆ ಕಾಲಮ್ 11 ನಲ್ಲಿ ಕೇಳಿದ್ದೆ.
ಕ್ಯಾನ್ಸಲ್ ಆಗಿದೆ.
ಇಲ್ಲಿ ಏನಾಗಿದೆ, in that other matter where we disposed of, we recorded the submission of the learned additional advocate general appearing on behalf of the respondent state submits that alternative lands have been granted to the displaced persons in large number, but it has been found that in many of the cases, the grants were obtained by furnishing concocted documents.
Yes.
Or the grant orders themselves have been fabricated. Consequently, many such grant orders have been cancelled. A decision has been taken by the state authorities that proper investigation has to be done in respect of all the grantees to find out the genuinity of the grants, and thereafter, till such inquiry is conducted and decision is taken in respect of each and every grant order, the revenue entries should be maintained as it was, and therefore the impugned official memorandum has been issued. It is true that many such persons who are aggrieved of the fact that the grant orders have been subsequently cancelled have knocked at the doors of this court. Having regard to the fact that huge number of grants have been cancelled on the ground that grant orders were either obtained fraudulently or by furnishing concocted or fabricated documents, sufficient time will be required for the state and its authorities to go into each and every case. This court is therefore of the considered opinion that the petitioner will have to wait for some time till the inquiry is conducted by the state government and decision is taken on each and every grant. Alli, the prayer was that my name is not entered in the land records. But in many, in these cases,
ಆರ್ಟಿಸಿನ ಕೆಲವರಲ್ಲಿ ಎಂಟ್ರಿ ಆಗಿದೆ
ಆಗೋಗಿದೆ.
ಎಂಟ್ರಿ
ಆಗಿದೆ subsequent purchases
ಆಗಿರೋದನ್ನ
ಅಲ್ಲ
after cancellation of the grant, it has been removed from the land records.
Yes. ಅಲ್ಲ but some of them are subsequent purchasers, some of them are
In some cases, there are subsequent purchasers also.
the original
His
grant.
grantee is,
Or in line with the same decision,
My case stands on a different footing.
we will have to set aside all these cancellation orders. Because no opportunity is given to each one of them to substantiate.
The last time, the additional advocate general also made a submission that the matter was discussed with the revenue department. ಅವರು special committee constitute ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ to look into all the matters. In fact, the letter was written and they are in the process of calling for a meeting. So now that the matter was listed today, we may require another 4 weeks time now ensuing this election also. So they will form a special committee to hear all the matters. Because not only these, there are about 600 to 650 grantees whose orders were cancelled.
Therefore, in these cases where the grant orders have already been cancelled, how will you hear them without the order being set aside?
Yes, but for that, once when the committee is constituted.
You ಮಾಡಿ. That is what we have noticed here in this order also.
Yes.
But unless the order impugned is set aside,
yes, they cannot be provided.
they will have one more opportunity after the committee is constituted. Each one of them will be given an opportunity. Based on the information now given by the parties, a fresh decision will have to be taken.
But now what would be?
But ಅದಕ್ಕೆ unless the impugned orders are set aside.
Yes.
How can we ask them to go before the committee?
The committee itself is not constituted right now. That is the discussion.
Madli. Madli, that is what we have noticed.
ಅದಕ್ಕೆ what I require.
All these orders which have been passed without giving opportunity of hearing to them.
Anyway, on the
are required to be set aside.
Yes. Anyway,
with a condition that they will not alienate the properties.
No third party interest will be created.
No third party rights will be created till the committee is constituted and each of the cases are reheard once again.
But in such cases, my lord, at least time limits has to be fixed. Otherwise, there are uncertainties.
Again, what I request is this matter will be reposted after 3 weeks, your lordship. Because now that they are also free to.
New committee constitute ಮಾಡಿ. What I am trying to say is that unless these orders are set aside.
Yes.
Now how will you give them opportunity to go before the committee?
Once we discuss with the government, we ourselves will come and give an undertaking that this people may be, this orders will be set aside and ಇವತ್ತು but ಅಲ್ಲ 2 weeks at least minimum 2 weeks time ಕೊಟ್ರೆ because it's in the procedure. We ourselves will come and submit to the court.
ಏನಂತ?
ಅಲ್ಲ that if the committee is constituted, these orders have to go.
ನಾನು ಆಲ್ರೆಡಿ ನೋಟಿಸ್ ಮಾಡಿದ್ದೀನಲ್ಲ ಈ ಆರ್ಡರ್ ಅಲ್ಲಿ.
ಹೌದು.
It has already been noticed in this order. So unless the impugned orders are set aside, with the same observation that only for this reason the impugned orders are set aside, but the government is going to constitute a committee and it will go into each and every case once again. So till that is done and an order is passed, they will also be prevented from transacting with the property.
The difficulty was, your lordship, the learned SLO who had passed the orders is now transferred in view of the elections. The incumbent who has come is not aware of the entire proceedings to discuss the matter with the.
ಅವರೆಲ್ಲ ಮಾಡೋದು.
ಅಲ್ಲಲ್ಲ ಅವರು to give the input.
SLO also will be one of the parties.
One of the parties. He has to also be.
To appear before the committee.
Yes. He has to.
He'll come.
But in some cases, my lord, the grant is cancelled on the premise that the value of the tree has not been.
Everything has to be gone into, sir.
Because my lord,
individual case ನಿಮ್ದು ತಗೊಂಡು separate ಆಗಿ ಮಾಡಕ್ ಬರಲ್ಲ ಈಗ.
No, my submission is.
You may have a good case.
Please, my lord.
But that has to be considered by the committee again.
Please.
This matter will be called on Monday, Your Lordship. I will keep the AAG present. In presence
Yes.
of the AAG, we'll take it.
Relist all these matters on 25th of March to enable the learned additional advocate general to have his say.
Yes. The connected matter also may not. Direct office to post the other connected matters.
ಈ ಬ್ಯಾಚ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ಮೇಲೆ ವಿಲ್ ಹ್ಯಾವ್ ಆಲ್ ಆಫ್ ದಮ್ ಅಂಡ್ ವಿಲ್ ಡಿಸ್ಪೋಸ್ ಆಫ್ ಇನ್ ದಿ ಸೇಮ್ ಲೈನ್. Yes. Interim orders wherever granted stand extended till the next date.
One submission, serial number 11.2 Manoj is not connected. 11.2 Manoj. That's 11.2 I have sought Manoj, challenging the endorsement, whereby Manoj, the request of the petitioner association Manoj for grant of land has been rejected.
Not connected to Hemavati.
It is not connected to Hemavati.
Not connected. Dealing. WP number 703 of 2023 from this matter.
I think for any date Manoj, on the last occasion Lordship had heard this matter Manoj. Manoj had directed me to furnish a judgment. Manoj had furnished that judgment Manoj along with the copy to the learned counsel for the government.
I think the first,
Number 11.
the first matter, model, first matter is also.
ನಿಮ್ದೇನು?
First matter nalli, ours is not cancelled, my lord. My grant is not cancelled.
You are asking for your entry in the revenue record?
No, we are asking for khata in our name.
Adene. So this order, same order will be passed. Serial number 1 nalli, same as 25973 of 2023. Same order.
Grant is not cancelled, my lord.
Adene, idrallu cancel agilla. The request was aggrieved of the fact that official memorandum dated so and so issued by the deputy commissioner is coming in the way of the petitioner getting her name entered in the land records.
ನಮ್ದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ they affirm that the grant is made in my favor.
Adhe sir.
But it is allotted.
But now they are saying you'll have to wait because the committee has been constituted. So I have recorded that one and I have said, please wait till the committee is constituted and appropriate decision will be taken. Once everything is clear, all the persons who are genuinely granted lands, their names will be entered in the land record.
The endorsement that is given to us, one first matter.
Endorsement?
That is issued to us, which is under challenge.
What is the first petition?
My lord finds it on page 20.
2027.
First matter, 230. Serial number 1. Page 29, my lord. The endorsement is dated 21/9/2022, about 4-5 months ago. ಪರಿಶೀಲಿಸಲಾಗಿ ಮೂಲೆ ಕಾಲೇನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 49 ಬ್ಲಾಕ್ 2ರಲ್ಲಿ 4 ಎಕರೆ ವಿಸ್ತೀರ್ಣ ಮಾನ್ಯ ತಹಶೀಲ್ದಾರ್ ಅವರ ಆದೇಶ ಸಂಖ್ಯೆ ಸೊ 15/12/77ರಂತೆ ಎ.ವಿ. ಗುಂಡಪ್ಪ, ದಟ್ ಈಸ್ ಮೈ ಫಾದರ್, ಉರುಫ್ ರಾಜಪ್ಪ ಬಿನ್ ಪುಟ್ಟೇಗೌಡರವರಿಗೆ ಮಂಜೂರಾಗಿರುತ್ತದೆ. ಆದರೆ ಖಾತೆಯಾಗಿರುವುದಿಲ್ಲ.
ಕರೆಕ್ಟ್.
ಸದರಿ ಸರ್ವೆ ನಂಬರ್ ಈಗಾಗಲೇ 49/1ರಿಂದ 49/13ರವರೆಗೆ ಕೋಡಿ ದುರಸ್ತಾಗಿದ್ದು ಹಲವಾರು ವಹಿವಾಟು ಪ್ರಕ್ರಿಯೆಗಳು ನಡೆದಿರುತ್ತವೆ. ಸರ್ವೆ ನಂಬರ್ 42/2ರಲ್ಲಿ ಕರೆಪತ್ರ ಸಂಖ್ಯೆ ಸೊ ಆಗಿರುತ್ತದೆ. ಮಕ್ಕಳಾದ ಚಂದ್ರೇಗೌಡ, ಕುಸುಮ, ರವಿ ಮತ್ತು ದಯಾನಂದರವರು ಚೆನ್ನಮ್ಮ, ಶಿವಣ್ಣಗೌಡರವರಿಗೆ ಕರೆಯವಾಗಿದ್ದು MR 14/99/2000 ಅಂತೆ ಖಾತೆ ಅಂಗೀಕಾರವಾಗಿರುತ್ತದೆ. ಸದರಿ ಮುಟೇಶನ್ ರದ್ದುಪಡಿಸಲು ಈ ಕಚೇರಿ ಹಂತದಲ್ಲಿ ಅವಕಾಶವಿರುವುದಿಲ್ಲ.
You are seeking cancellation.
I have sought, if this land is not available, if it is given to somebody else, kindly grant at least alternative land is my prayer. Grant is not in question, they admit it. And the sketch is also prepared, my lord finds it on page 11.
19, page 19, 18 or 19.
So ಅದೊಂದು ಇನ್ನೊಂದು ಪ್ಯಾರಾಗ್ರಾಫ್ ಸೇರಿಸ್ಬೇಕು. However, in the present case, the petitioner is aggrieved of the impugned endorsement dated 21/9/2022 at Annexure H issued by the Tahsildar, Holenarsippura Taluk. ಅಲ್ಲ, what was the grievance with which you went before the Tahsildar?
Grant is there,
ಹೌದು.
land is there, mutation is not made in my favor.
ಅದೇ, he is saying there are several other transactions which have been now incorporated in the RTC in respect of the same land. And therefore it is not possible to enter your name at this stage.
ಅಲ್ಲ, ಅದನ್ನ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಕ್ ಆಗೋಲ್ಲ, ನಮಗೆ ಅಧಿಕಾರ ಇಲ್ಲ ಅಂತ ಅವ್ರು.
ಅದೇ,
Column 11.
see, under 136, it will not be possible for the Tahsildar to do any such thing. Now again, in view of the larger action that is sought to be taken by the government, that an inquiry has to be conducted. Many such grants may be cancelled for various reasons, and many may be confirmed.
Quite possible.
Yours also may be confirmed. So therefore, unless that exercise is undertaken by the government, nothing can be done. So you'll have to wait for some more time, and that is the order.
I leave it.
Alva.
Because I felt that it is not a.
And I will notice this, that endorsement given. ಏನ್ ಹೇಳ್ದೆ?
We are not concerned with your area, not our family.
Wherein it is stated that although from the records it is clear that 4 acres of land in block 2 of survey number 49 of Mule Kalenahalli village, Kasaba Hobli, Valenarsupura Taluk, was granted in favor of the petitioner's father, Sri A.V. Gundappa, alias Rajappa, son of Puttegowda.
In fact, it is
In terms of order bearing number LND HRP SR 61 of 7778 dated 15/12/1977. Nevertheless, there are many other transactions that have been recorded in the RTC having regard to several other sale deeds, including MR number 14 of 1999-2000. 2000. Full stop. Therefore, the Tahsildar has directed the petitioner to approach the competent authority to redress its grievance. Full stop. ಇಷ್ಟು ಬರ್ಕೊಂಡು ಅದನ್ನ ಆಮೇಲೆ ಅದನ್ನ ಕರೆಕ್ಷನ್ ಮಾಡಿ ಸೇಮ್ ಆರ್ಡರ್ಸ್. Yes.
We are not concerned with the transaction. Because with our land, my lord, no transactions have taken place. No transaction in our case.
ಅದೇ, so it may be true that ಬೇರೆ ಏನು ಆಗಿಲ್ಲ, it is everything is clear, the same land can be registered in your ಖಾತೆ can be registered ಅಂತಂದ್ರೆ they'll proceed.
She is granted to us in lieu of our own land because it was
ಎಲ್ಲಾರ್ದು ಅಷ್ಟೇನೆ. These are granted to project displaced persons.
Yes.
There are several hundreds of them before this court. Now the government is in a piquant situation where it has to conduct an inquiry in each and every case to ascertain whether the grant was, whether the person had lost lands, whether the grant orders were passed. ಇದನ್ನೆಲ್ಲ ascertain ಮಾಡ್ಕೊಂಡು then they will come to a conclusion. These are the cases where it is genuine and the orders can be confirmed. ಆಮೇಲೆ they can proceed. Yes.
It will take its own sweet time. It will take its own sweet time to do all this.
ಆಗುತ್ತೆ, because there are large numbers. It may take another 1 year at least. Yes.
Number 1.
11.2 minutes.
11.2. 11.2.
11.
Shriram Bhatwa.
11.2 ಹೇಳಿದ್ರು. 11 point. My lord's directed to take up 11.2.
11.2 ತೆಗಿರಿ. ಆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ. ನೋಡ್ರಿ 11.2 serial number 11.2 second list.
Yes, sir. Virupaksha PH.
Let's please. That's the
Land
petitioner.
is-
My lord, the petitioner is challenging the endorsement, my lord, annexure M, my lord, page 49, my lord, whereby the request of the petitioner, my lords, for grant of land, my lord. The petitioner, my lords, is an association, my lords. It is Karnataka State Government D Group Employees Central Association. It is registered, my lords, under the Societies Registration Act, my lord. Only on the ground, my lords, that the provisions of land grant rules, my lord, do not provide, my lords, for grant of land in favor of the association, my lord. The impugned endorsement at page 49, my lords, is issued.
ಯಾವ್ದು judgment? S. Nagaraj and others.
Please, my lords, a copy is given, my lords. ILR 1999, Karnataka 1102, my lord.
ಇದೆ.
My lords, if your lordship kindly peruses, my lord, lords, page 1109, my lord, para 16, my lord.
ಇದು ಯಾವ್ದ್ರಿ? This is under the religious and charitable Inam
My lords, the provisions of land grant rules, my lords, is interpreted, my lords. My lords, provisions of land grant rules, my lords, rule 20 of land grant rules, my lord. If your lordship kindly peruse page para 17, my lords, page 1110, my lord. My lord, rule 17, 18, 19 and 20 deal with different types of grant to, this is the land grant rules, my lord. Deals with different types of grant to different persons. That is grant of agriculture lands for the purpose of agriculture use and also for the purpose of plantation, etc. Therefore, the rule governing the particular grant has to be read to consider whether the grant is proper or not. The land is defined in section 214 of the Karnataka Land Revenue Act, and it does not say that there is no distinction between agriculture and non-agriculture land in the definition, and the agriculture land and non-agriculture land both covered under the definition of the land of the above provision. By reading the entire rules concerning the grants, it is manifest that the grant of land to the society and other statutory bodies and other organizations is covered by Rule 20 of the rules. By reading Rule 20 of the rules, it is manifest that the state has got power to grant land for house sites to Housing Board, Mandal Panchayat, Jilla Parishad, cooperative societies and other statutory board. Learned Counsel for the appellant contended that the respond number 3 society is not registered under the Cooperative Societies Act, and it is registered under the Societies Registration Act. Therefore, it is not an organization to be granted land in terms of Rule 20 of the land grant rules. By reading Rule 20, it is manifest that it is only illustrative and not exhaustive. The power is vested in the state for grant, and it is specifically stated that the state has got power to grant land for house sites to Housing Board, Mandal Panchayat, Jilla Parishad, cooperative societies and other statutory board. It is settled principles of law that in a legislation or in a rule, every body or organization need not be referred. If it is to be referred, it has become a rule which we have covered based on book as different organizations now exist in the state rather than hundreds. Therefore, the rule has to be read in the context in which rule is made. So the rule itself is manifest that the state has power to grant land to respond number 3. My lords, Rule 20, my lords.
Last time it was brought to your notice.
Yes, sir.
You had sought for time to get clarification.
Now there was confusion because the matter got listed with the batch here.
It was wrongly listed, my lords, along with the other matters.
That is, Rule 20 is with the prior approval of the government. Not as a matter of right, he cannot file an application like how an agriculturist or an unauthorized occupant can file. The lordship could read Rule 20. Grant of land to Housing Board, Gram Panchayat, Taluk Panchayat, Jilla Panchayat and other statutory board. Land will be granted by the Deputy Commissioner with the prior approval of the state government under these rules. So if there is a scheme, they have to get the scheme approved by the government for housing and other purposes.
For what purpose are you asking this?
My lords, the
Housing.
association, my lords, association consists of several B group employees, my lord.
For forming a layout,
For formation, my lords,
ಸಾಧ್ಯನೇ ಇಲ್ಲ.
my lords,
It is impossible.
lords,
Not under these provisions. This land grant rules is not meant for this one.
lords, in fact, if your lordship kindly peruses, my lord, Annexure C, my lords, it is the recommendation of the deputy commissioner, my lord.
No. You file your statement of objection. 2 weeks are granted to the respondents to file statement of objections.
It has to be dealing to your lordship.
I thought
The dealing.
that order has been passed. Yes, wait.
2:30 PM matter. Bill number 45. Page number 10. Manmohan PN.
My lord, the last date, my lord, I directed to submit on order rule 17 of clause 6, my lord. This is, my lord, I am challenging the order of land tribunal, my lord. In respect of please, my lord, it may be clubbed and it may be considered together, my lord. Only in respect of survey number 60/7, my lord, it may be considered. my lord.
Yes, Your Lordship. I brought judgments in that regard, Your Lordship.
Yes, my lord, I had filed another writ petition, my lord, that is 53019 of 2013. In that writ petition, my lord, I had sought to quash the endorsement issued by the Tahsildar.
I know the writ petition got connected.
Prayer, my lord, at page 8, my lord. Seeking to quash the endorsement, my lord. To quash the endorsement dated 25/4 and writ of mandamus directing these second respondent, that is Tahsildar, to issue Form 10 is in respect of agriculture lands, my lord. ಇದರಲ್ಲಿ ಅವರು we have sought for same survey number ಸ್ವಾಮಿ, same grant ಆಗಿರೋದು ನಮ್ಗೆ, ಅದ್ರಲ್ಲಿ ನಮ್ಗೆ Form 10 ಕೊಡಿ ಅಂತ ಕೇಳ್ತೀವಿ. Issued an representation. ಅದಕ್ಕೆ ರಿಪ್ಲೈ ಮಾಡ್ತಾರೆ, ರಿಪ್ಲೈ at page number 15. So Annexure E, page 20, Annexure E, page number 20. May I read, my lord? Of para is 5th line, my lord. ಈ ಬಗ್ಗೆ ಮೊದಲಿಂದ ಓದ್ತೀನಿ ಸ್ವಾಮಿ. ಮಂಗಳೂರು ತಾಲೂಕು ಕಚ್ಚನಾಡಿ ಗ್ರಾಮದ ಭೂ ನ್ಯಾಯಾಲಯ ಮಂಡಳಿ TRL so ಆದೇಶ ಪ್ರಕಾರ so 60/2 ರಲ್ಲಿ 12 ಎಕರೆ ಹಾಗೂ ಇತರ ಸರ್ವೆ ನಂಬರ್ಗಳಿಗೆ ಮಂಜೂರು ನೀಡಲಾಗಿದೆ. ಮಂಜೂರಾತಿ ನೀಡಿರುವ ಸರ್ವೆ ನಂಬರ್ಗಳಿಗೆ ನಮೂನೆ 10 ಕೋರಿ ಉಲ್ಲೇಖದ ಪತ್ರದಲ್ಲಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುತ್ತೀರಿ. ಈ ಬಗ್ಗೆ ಕಡತ ಪರಿಶೀಲಿಸದಾಗಿ ಹಾಗೂ ಕಂದಾಯ ನಿರೀಕ್ಷಕರು ಗುರುಪುರ ಇವರ ವರದಿ ಪರಿಶೀಲಿಸಲಾಗಿ ಸರ್ವೆ ನಂಬರ್ 60/7 ರಲ್ಲಿ 4 ಎಕರೆ 113/1 ರಲ್ಲಿ 50 ಎಕರೆ 50 ಎಕರೆ ಜಮೀನು ಮಂಜೂರಾಗಿದ್ದು, ಈ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಲಾಗಿ 60/1 ರಲ್ಲಿ 0.14 ಎಕರೆ ಫೈಲ್ ಮಂತೋರೋ ಹಾಗೂ ಇತರ ಹೆಸರಿನಲ್ಲಿ ದಾಖಲು ಇರುತ್ತದೆ. ಸರ್ವೆ ನಂಬರ್ 113/1 ರಲ್ಲಿ ಪಹಣಿಯಲ್ಲಿ 0.50 ಎಕರೆ ಸೆಲೆಸ್ಟಿನ್ ವಿರಾಂದ ಹಾಗೂ ಇತರ ಹೆಸರಿನಲ್ಲಿ ಭೂ ನ್ಯಾಯಾಲಯ ಮಂಡಳಿಯ ಆದೇಶದಂತೆ ದಾಖಲಾಗಿರುವುದರಿಂದ ಈ ಬಗ್ಗೆ ಭೂ ನ್ಯಾಯಾಲಯ ಮಂಡಳಿಯಲ್ಲಿ ಮರು ತನಿಖೆಯಿಂದ ಸರ್ವೆ ನಂಬರ್ ಸರಿಪಡಿಸಿ ತಿದ್ದುಪಡಿ ಆದೇಶ ಮಾಡಿಸಿದ ನಂತರ ನಮೂನೆ 10 ನೀಡಿರುವ ಬಗ್ಗೆ ಕ್ರಮ ಕೈಗೊಳ್ಳುವುದಾಗಿ ತಿಳಿಸಿರುತ್ತಾರೆ. ಇದರಲ್ಲಿ ನಮ್ಗೆ ಸ್ವಾಮಿ
ಸರ್ವೆ ನಂಬರ್ 113/1 ಅದು ನಮಗೆ ಆಕ್ಯುಪೆನ್ಸಿ ರೈಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ವಿ ಆರ್ ಕನ್ಸರ್ನ್ ವಿತ್ ಓನ್ಲಿ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಸರ್ವೆ ನಂಬರ್ 113. ಐ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಎ ಮೆಮೋ ಮೈ ಲಾರ್ಡ್. ಅದ್ರ ಮುಂಚೆನೆ ಫೈಲ್ ಆಗಿದೆ ಒಂದು ಮೆಮೋ. ಅದರಲ್ಲಿ ಸರ್ ಮೆಮೋ ಇದೊಂದು ಕಾಪಿ ಆಫ್ ಆರ್ಡರ್, ಒಂದು ಟ್ರಿಬ್ಯುನಲ್ ಆರ್ಡರ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀವಿ. ಟ್ರಿಬ್ಯುನಲ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಸ್ವಾಮಿ, ಅಂಡ್ ವಿ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ ದಿ RTC ವಿಚ್ ದೇ ಆರ್ ರೆಫರಿಂಗ್ ಟು. RTC ಅಂಡ್ ದಿ ಟ್ರಿಬ್ಯುನಲ್ ಆರ್ಡರ್. ಅದರಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 1111/3 ಬಗ್ಗೆ ಏನು ಕೂಡ ಡಿಸ್ಕಸ್ ಇಲ್ಲ ಸ್ವಾಮಿ. ಅದ್ರ ಬಗ್ಗೆ ಏನು ಆರ್ಡರ್ ಆಗಿಲ್ಲ ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್ ಆರ್ಡರ್ ಅಲ್ಲಿ.
ಮತ್ತೆ ನಿಮ್ಗೆ ಯಾವ್ದು ಗ್ರಾಂಟ್ ಆಗಿರೋದು?
ಗ್ರಾಂಟ್ ನಮಗೆ 113 ಆಗಿದೆ ಸ್ವಾಮಿ. ನಮಗೆ ಕೈಂಡ್ಲಿ ಮೈ ಲಾರ್ಡ್ ಕಮ್ ಟು ಪೇಜ್ ನಂಬರ್ 21 ಅಲ್ಲಿ ಸ್ವಾಮಿ 60/2, 60/2, 60/6, 60/7.
What?
21 of writ petition, page number 21.
20 ಗೆ ಲಾಸ್ಟ್ ಇದೆ ಇಲ್ಲಿ.
ಇಲ್ಲ ಸ್ವಾಮಿ 21 ಎಸ್ annexure B. annexure B ಸ್ವಾಮಿ.
B for Bangalore.
ಹೌದು ಸ್ವಾಮಿ.
ಹೆಂಗ್ರಿ annexure E
B
page number 20.
Writ petition number
in the writ petition number 2024. Please my lord. ಅದಲ್ಲ
ಕನೆಕ್ಟೆಡ್ ರಿಟ್ ಪಿಟಿಷನ್ ಬಿಟ್ಟು ಇವಾಗ ಮತ್ತೆ ಹಳೆದಕ್ಕೆ ಹೋಗ್ತಾ
ಆಯ್ತು ಸ್ವಾಮಿ, ಅದರಲ್ಲೇ ತೋರಿಸ್ತೀನಿ. ಸಾರಿ ಪೇಜ್ ನಂಬರ್ 11 11.
ಹಾ
60/2, 60/6, 60/7, 60/4B, 60/4A, 61/3, 113/1. ಆ ರಿಟ್ ಅಲ್ಲಿ ಸ್ವಾಮಿ 60/7 they are disputing that. ನಾವು ನಮ್ಗೆ ಇದು ಗೊತ್ತಿರ್ಲಿಲ್ಲ ಸ್ವಾಮಿ ಅವರದ್ದು. ನಾವ್ ಎಲ್ಲದಕ್ಕೂ ಫಾರ್ಮ್ 10 ಕೊಡಿ ಅಂತ ಕೇಳಿದ್ವಿ. ಆಗ ಇದೊಂದು ಎಂಡೋಸ್ಮೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ.
ಆಯ್ತು.
ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ 113 ಈ ತರ ಬೇರೆಯವ್ರ ಹೆಸರಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಯು ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ ದಿ RTC ಅಂಡ್ ದಿ ಆರ್ಡರ್ ಆಫ್ ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್. ಆರ್ಡರ್ ಆಫ್ ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್ ಬೇರೆಯವ್ರು ಯಾರ್ದು RTC ಹೆಸರು ತೋರಿಸ್ತಾ ಇದೆ ಅಂತ ಹೇಳ್ತಾರಲ್ವಾ. ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್ ಸ್ವಾಮಿ 113 ಕನ್ಸಿಡರ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ. ಇದ್ರ ಗ್ರಾಂಟೇ ಆಗಿಲ್ಲ ಅವ್ರಿಗೆ. ರಾಂಗ್ಲಿ ದೇ ಹ್ಯಾವ್ ಮೆನ್ಷನ್ಡ್ ಇನ್ RTC ಸ್ವಾಮಿ. ನಮ್ ಸರ್ವೆ ನಂಬರ್ನ ಬೇರೆಯವ್ರ ಹೆಸರು ತೋರಿಸಿದ್ದಾರೆ RTC ನಲ್ಲಿ.
How can this court simply issue a direction by going through this order? We should not hear the other side, is it? ಯಾರ ಹೆಸರು ಅಲ್ಲಿ ದಾಖಲೆ ಮಾಡಿದ್ದಾರೆ ಅವ್ರಿಗೇನ್ ಕೇಳೋದ್ ಬೇಡವಾ? We do not know why their name has been entered there.
ಅದಕ್ಕೆ ಅವರದ್ದು
unless they are heard, opportunity is given to them. How can this court pass an order directing the Tahsildar, no enter your name ಅಂದ್ಬಿಟ್ಟು?
ಅವ್ರು ಯಾರು ಅಂತಾನೆ ಗೊತ್ತಿಲ್ಲ ಸ್ವಾಮಿ.
So therefore you will have to find out and raise a challenge to the entry in a manner known to law.
Please ma'am. So we have challenged the endorsements.
Endorsement challenge ಮಾಡಿದ್ರೆ ಏನ್ ಬಂತು? He has simply stated that these names are entered in the RTC.
Please ma'am.
And therefore form number 10 cannot be issued. ಏನ್ ಮಾಡ್ಬೇಕು ನೀವು?
Please ma'am.
ಸುಮ್ನೆ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ ಏನ್ ಬರುತ್ತೆ?
They may be reconsidered and
so you'll have to find out how their names were entered.
Please. They may be reconsidered and form 10 may be issued, my lord. If ಅದೇನೋ ಇದಾಗಿದ್ರೆ
ಆಗುತ್ತೆ. When such an endorsement has been given stating the name of some other persons have been entered there, it is for you to take action in accordance with law.
Please my lord. Please ಸ್ವಾಮಿ, ಈ ಸರ್ವೆ ನಂಬರ್
ಅವ್ರ ಹೆಸರು ಎಂಟರ್ ಆಗಿದ್ರೆ you will have to take information. ಹೆಂಗೆ ಎಂಟರ್ ಆಯ್ತು ಅವ್ರ ಹೆಸರು, then you will have to raise a challenge before the assistant commissioner.
Please my lord. Okay, please my lord. In respect
ಪಾರ್ಟಿ ಮಾಡಿ ಅವ್ರಿಗೊಂದು ಆಪರ್ಚುನಿಟಿ ಕೊಟ್ಟು
ಆಯ್ತು ಸ್ವಾಮಿ.
then an action can be taken.
In respect to other survey numbers, my lord, form 10 may be issued, my lord. ಈ ಸರ್ವೆ ನಂಬರ್ 113 ಬಿಟ್ಟು ಬೇರೆ ಸರ್ವೆ ನಂಬರ್ಗೆ ಫಾರ್ಮ್ 10 may be issued, my lord. They may be directed to issue form 10, my lord. I am relying on one judgment, my lord, of this court. ಅದರಲ್ಲಿ ಅಂದ್ರೆ ಫಾರ್ಮ್ 10 is bound to be ಅಂದ್ರೆ ಅವರು bound
provision itself says so.
Please my lord. Respect of other survey numbers, my lord, they may be, please kindly direct them to issue form 10.
Sixty per 7 and 113 per 1. ಎರಡು ಸರ್ವೆ ನಂಬರ್
ಪ್ಲೀಸ್
60/7 ಯಾವ್ದು ಒಂದು ಹೇಳಿದ್ದಾರೆ, 113/1 ಯಾವ್ದು ಹೇಳಿದ್ದಾರೆ.
ಹೌದು ಸರ್. 60/7 ಅಲ್ಲಿ ಅವರು ಆಕ್ಯುಪೆನ್ಸಿ ರೈಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಬರ್ಕೊಳ್ಳಿ. ಈ ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಪ್ಲೀಸ್ ಗಿವ್ ಮಿ ದ ಸ್ಟೇಟ್ಮೆಂಟ್.
The 1979 judgment, Your Lordship, it's a landmark judgment, para 11.
There is a reference to the provision, isn't it?
They talk about 48A.
Yeah. Rule.
Second.
Which paragraph?
Para 11, Your Lordship.
Ah.
When rival applications are made before the tribunal for grant of occupancy right in respect of the same land, it is in our opinion the duty of the tribunal to consider together those rival applications and decide by a common order. Otherwise, there cannot be a proper adjudication of the rival claims.
There is no reference to the
Even-
provision. There is a provision which I pointed out last time.
Please, my lord. Rule 7 subclause 6. 48.
Yeah, 7.
Rule 17 subclause 6.
Rule 17 subclause 6.
Your Lordship, both these division bench judgments may be taken on record. It's on the same footing. They say that tribal applications have to be dealt.
Not refer, there is a provision, madam.
Yes, yes, Your Lordship. There's a provision.
I'm referring to the provision.
Yes, Your Lordship.
What about the other division bench judgment?
It does
There
not.
is a reference to the provision?
No, no, there's no reference.
So WP number 2024 of 2014. The petitioners are aggrieved of the impugned order dated 24/11/1979, passed by the Land Tribunal, Mangalore Taluk, in proceedings bearing number LRT 5 bracket close bracket 1981/1978-79. Next paragraph. It is the contention of the petitioners that although a claim petition was filed by Mrs. Louise Monterio, the mother of the petitioner Sharon, in form number 7, seeking occupancy rights in terms of section 48(1) of the Karnataka Land Reforms Act 1961. The Land Tribunal ಏನ್ ಮಾಡಿದಾರೆ? ಇಂಪ್ಯೂನ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ರೆಫರ್ ಮಾಡಿದಾರಾ?
ನೋ ಮೈ ಲಾರ್ಡ್. ಇನಿಷಿಯಲಿ ನನಗೆ ಆಕ್ಯುಪೆನ್ಸಿ ರೆಂಟ್ ಗ್ರಾಂಟ್ ಮಾಡ್ತಾರೆ ಆನ್ 4/10/1979 Annexure B.
Annexure B.
Annexure B occupancy right granted in my favor. In favor of my. So ಅದಾದ್ಮೇಲೆ Annexure D is occupancy rate granted in favor of this respondent. ಅದರಲ್ಲಿ they have included 60/7.
Again. ಏನಿಲ್ಲ. And the land tribunal passed an order on 4/10/1979 conferring occupancy rights in favor of the petitioner's mother. Nevertheless, it was later found that the land tribunal also passed an order on 24/11/1979 on an application filed by Mrs. Carmine Montero in proceedings bearing number LRT (5) 1981/1978-79. And ಎಷ್ಟು ಒಂದೇನಾ?
Only one survey number.
And survey number 60/7 measuring 15 cents.
14 cents.
ಅಲ್ಲ ಅವ್ರದ್ದು.
ಹೌದು, ಅದು ಕೇಳ್ತಾರೆ granted only 14 cents. Page number 31.
Measuring 14 cents were conferred in favor of Srimati Carmine Montero, while in the orders passed in favor of the petitioner's mother, the land tribunal has conferred occupancy rights in respect of 5 cents.
Please, my lord.
In survey number 60/7.
Sorry, my lord. 4 cents.
4 cents.
Please. Page number 21.
ಎಷ್ಟಿದೆ ರೀ ಟೋಟಲ್ ಎಕ್ಸ್ಟೆಂಟ್ ಆಫ್ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ?
ಟೋಟಲ್ ಇರೋದು 14 ಇರೋದು ಸ್ವಾಮಿ. ಅವ್ರು 15 ಕೇಳ್ತಾರೆ, 15 cents ಕೇಳ್ತಾರೆ, ಅಲ್ಲಿರೋದೇ 14 cents ಅಷ್ಟೇ ಸ್ವಾಮಿ. ನಮಗೆ 4 cents ಇನಿಷಿಯಲಿ ಕೊಡ್ತಾರೆ, ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿ ಅವ್ರಿಗೆ 14 cents ಅಂತ ಕೊಡ್ತೇವೆ. They have included 4 cents of our mother ಅಂತ ನಾವು.
Full stop. Learned counsel for the petitioner submits that the total extent of land in survey number 60/7 of Pachandi village, Gurupura Hobli, Mangalore Taluk is 15 cents.
14 cents.
14 cents only.
Actually incorrect, my lord. That is 81. Total extent available is 81 cents, my lord.
81 cents.
Their own document, my lord, lordships get it at page 43. 43, my lord, Akarban they have produced, my lord. Typed copy, my lord, gets it at page 45. Revision settlement Akarban, my lord, which says total extent is 0.1454 plus 0.75. It's not 14 cents, my lord. Typed copy may be erroneous, my lord, but original copy lordships.
Originally 14 ಅಂತಾನೆ ಇರೋದು.
14.
ಇಲ್ಲ ಸರ್ ಅದು
Page number
14
43.
ಅಲ್ಲ 14 ಪ್ಲಸ್ ಕೆಳಗಡೆ ಇದೆ ಸರ್ 67 ಅಂತ. ಅದ್ರ ಕೆಳಗಡೆ 67 ಅಂತ ಇದೆ. ಅನ್ನು ಟೈಪ್ ಕಾಪಿಯಲ್ಲೂ ಹಾಗೆ ಹಾಕಿದ್ದಾರೆ.
So ಇಲ್ಲ original ಅಲ್ಲಿ
ಅದಲ್ಲ. The one written below is not another extent of land. It's not so.
ಕನ್ನಡದಲ್ಲಿ ಬರ್ತಿದ್ದಾರೆ ಅದನ್ನು.
ಅದೇ ಕನ್ನಡದ
14 ಕೆಳಗಡೆ 67 ಅಂತ ಇದೆ.
ಅದು ಬೇರೆದಕ್ಕೆ ಸರ್. ಅದು
ಸಮ್ ಡಿಫರೆನ್ಸ್ ಎಲ್ಲಾದ್ರಲ್ಲೂ ಆ ತರ ಎರಡೆರಡು ಬರ್ದಿದ್ದಾರೆ. We do not know what is the meaning of the one written below.
And my lord, interestingly, claims is under different landlords, my lord. Not under the same landlord. So there will be, my lord, other lands.
Nevertheless, learned counsel for the contesting respondent number.
My lord, I have filed in fact, my lord, I have filed a memo of retirement, my lord, could not get the instruction. Are 5 and 6.
5 and 6.
Yes.
Points out from the documents submitted by the petitioner themselves at annexure L, which is a copy of the Akarband settlement, that the total extent of land in survey number 60/7 may be
14 plus 67.
81 cents.
Yes, ma'am.
Full stop. Next para. Nevertheless, comma, what is clear from the contentions raised by the petitioner as well as the contesting respondents is that the land tribunal has not followed the procedure where more than one applicant seeks conferment of occupancy rights in respect of a particular piece of land. Full stop. Learned AGA has pointed out from rule 17(6) of the Karnataka Land Reforms Rules, 1974, that if there are more applications than one for registration of occupancy rights by different persons in respect of the same land, comma, those cases shall be clubbed together and a common order is passed. We'll stop. Next para. It is also evident that the claims made by the petitioner's mother is against
Sanjeeva Rao.
Shri K. Sanjeeva Rao and Srimati Amba Bai, comma, while the claim made by
Govinda Rao. Carmen Levis and
K. Govinda. Page 30, our application.
Mrs. Carmen Montero was against Shri K. Govinda Rao.
Yes.
Full stop. Learned counsel for the other contesting respondent. ಯಾವುದು ನಿಮ್ದು respondents? 5 and 6
Or 5 and
4.
R4.
Has also sought to place reliance on 2 division bench judgments in the case of Pasappa Gurusangappa versus Land Tribunal, reported in 1979, bracketly 2, Karnataka Law Journal, page 370, and an unreported judgment of a division bench in the case of Sri M.R. Jairam and others versus Hanumanta Devaru and others in writ appeal number 2421 of 2005 and connected writ petition dated 1st of October 2013 to contend that the division benches have also held that the proper adjudication of rival claims by clubbing the matter and passing a common order. Full stop. Next para. In that view of the matter, the writ petition is partly allowed, while setting aside the impugned order passed by the land tribunal only insofar as survey number 60/7 is concerned.
Your Lordship, the earlier grant order also has to be set aside to that extent.
Yes, yes. Semicolon. So also, the earlier order passed by the land tribunal in proceedings bearing number RRT 51630 and 1998 of 1978-79. Insofar as survey number 60/7 is concerned. Next para. The matter stands remanded back to the land tribunal, Mangalore Taluk to
Both the claims.
consider the case of the rival claimants insofar as survey number 60/7 of so and so village is concerned and pass necessary orders in accordance with law.
Time period may be fixed.
ಈಗ ಲ್ಯಾಂಡ್ ಟ್ರೈಬ್ಯುನಲ್ ಅಲ್ಲಿ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಗಿದಾವ ಇಲ್ವೋ ಗೊತ್ತಿಲ್ಲ.
Election.
We do not know whether the land tribunals are now constituted.
If they are constituted means time.
Needless to observe that the land tribunal shall reconsider the matter in terms of the directions issued by this court as expeditiously as possible and at any rate within a period of 6 months from the date of receipt of a copy of this order. ಇನ್ನೊಂದು ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಇನ್ನೊಂದು ರಿಟ್ ಪಿಟಿಷನ್ ಕೊಡು. ಇದರಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ರೆ?
My lord, for issuance of Form 10, my lord. Survey number 113 ಬಿಟ್ಟು ಬೇರೆ ಸರ್ವೆ ನಂಬರ್ಗೆ Form 10 maybe.
ಇದರಲ್ಲಿ ನೀವೇನ್ ಪಾರ್ಟಿ ಇಲ್ಲ?
ಇವರಿಲ್ಲ,
Those people are not party.
Oh, my lord.
The petitioners are aggrieved of the impugned endorsement. Dated 25/4/2012, Annexure E, issued by the Tahsildar, Mangalore Taluk, declining to issue Form 10 consequent to the orders passed by the Land Tribunal in proceedings bearing number TRL 1998 and 1630 of 1978-79 dated 4/10/1979. Full stop. Next para. In another writ petition filed by the very same petitioners in WP number 2024 of 2015, in an order of even date, today this court has partly allowed the writ petition while setting aside the order of the Land Tribunal in proceedings bearing number 2 ಹಾಕೊಳ್ಳಿ, dated ಹಾಕೊಳ್ಳಿ. Insofar as survey number 60/7 of so and so village is concerned, for reconsideration of the rival claims. Full stop. Next para. Insofar as the opinion of the Tahsildar in respect of survey number 113/1 is concerned, that the name of one Celestine Miranda has been entered in the land records and therefore form number 10 cannot be issued in favor of the petitioners is concerned, this court is of the considered opinion that if the name of another person has been entered in the land records, then the petitioners are required to ascertain as to how such name was entered in the land records. Full stop. If there was no reason for entry of their names in the land records, then the petitioners are required to raise a challenge to such an entry in the land records, in a manner known to law. Full stop. At any rate, no orders can be passed by this court directing the Tahsildar to issue form number 10 in favor of the petitioners on the ground that the Land Tribunal has passed an order in their favor, without affording an opportunity of hearing to the person whose name has been entered in the land records. Full stop. Next para. However, insofar as the orders passed by the land tribunal in respect of other pieces of land other than survey number 60/7 and 113/1 as noticed herein above, there is no reason why the Tahsildar could not have issued form number 10 in favor of the claimant in whose favor the occupancy rights were granted by the land tribunal. Full stop. To that extent, the writ petition is partly allowed while directing the Tahsildar to consider the claim of the petitioners for issuance of form number 10 in respect of all other survey numbers as found in the orders passed by the land tribunal in RRT 5/1630 and 1998 of 1978-79 dated 4/10/1979. Full stop. The Tahsildar shall consider the grievance of the petitioners for issuance of form number 10 in respect of all other survey numbers except survey number 60/7 and 113/1 and proceed in accordance with law, as expeditiously as possible and at any rate within a period of 2 months from the date of receipt of a copy of this order. Grateful.
Serial number 32. O. Shivram Bhatt.
For the petitioner in this case, my lord, I have filed an application for amendment, seeking to amend the prayer column, my lord, which your lordship will get it at page number 2 of the application. ಏನಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 ಬದಲಿಗೆ ಅಲ್ಲ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ಬದಲಿಗೆ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 ಅಂತ ಹೇಳಿ ಪ್ರೇಯರ್. My lord, in the prayer line, my lord, respond number 2, delete number 1 and add number 2 ಅಂತ ಹೇಳಿ ಆಗಬೇಕು. Respond number direction is sought to respond number 2, my lord. It is only a typographical error. ನಾನು ಸ್ಟೇಟಿಗೆ and second prayer, my lord, dispose of the writ petition in terms of the order dated 5/3/2024 passed by this honorable court in WP number 6872 of 2024 following the judgment of this court in writ appeal number 5242 of 2024. Two prayers I want to.
Orders on IA number 1 of 2024. This application is filed by the petitioner seeking amendment in the prayer column. Full stop. On going through the application, it is clear that there are some typographical errors that have occurred in the prayer column. And therefore, the petitioner is entitled for the amendment as prayed for. Full stop. Next para. Accordingly, the application is allowed while permitting the petitioner to carry out the amendment in the prayer column as sought in the application. Full stop. The learned counsel for petitioner shall carry out the amendment and furnish amended copy of the writ petition within a period of 2 weeks from today.
This could be, your lordship can receive me. Memo, I have filed a memo. Along with memo, my lord. Otherly, your lordship was already
Similar matter, my lord, your lordship. Dispose of the matter.
ಏನಿದು?
ಇದು cashewnut cultivation.
ಹಾ.
My lord, on 5/3/2024, my lord, your lordship was disposed, similar to that.
Do one thing, then we'll keep it as a 1 week.
Yes.
Release this matter on 27th of March. Please carry out the amendment.
27th, ನಾನು ಇರೋದಿಲ್ಲ, 4th March.
4th of April. All right.
Serial number 33, Srikanth NV. For early hearing.
And for the respondent,
Application for early hearing.
and for the respondent number 2 to 5, my lord, I filed the.
About 2022 matters early hearing ಅಂತ ನೀವೆಲ್ಲ
It's urgency.
have been passing orders without even considering the fact that older matters are awaiting here.
No, my lord, the urgency is the petitioner harassing the respondent, my lord.
All
That's
right.
it.
List this matter for final disposal on 8th of April.
Master, please.
IA number 1 of 2024 is accordingly disposed of.
34, Mahesh Kiran Shetty, yes.
Petitioner sought for paper publication.
ಒಂದೇ ಸರಿನಾ?
Only one time.
ಒಂದೇ ಸರಿ ಆಗಿ
3 times. Yes, madam. In fact, on the earlier round of litigation, my lord, the Wakalath was forged and a compromise was entered to, and a direction was issued to the tribunal to record the compromise. We objected, we stated that we never appealed before the Honorable High Court, all those things we have brought to the
ಅಲ್ಲ
notice.
ಸರಿ ಏನೇ ಇರ್ಬೋದು,
True, my lord.
but the provision itself says
All right, I'll take one more time,
ಮಾಡ್ಬಿಡಿ.
please.
We will give short date so that you can take an emergent notice so that it will go and come back
Please,
faster.
please.
Pending consideration of IA number 1 of 2024, the petitioners are permitted are directed to take steps for service of notice on respondents number 2 and 3. Full stop. Emergent notice is ordered against response number 2 and 3, returnable by 3rd of April.
Please, public, keep your.
Serial number 35, Chandrapavi.
Know whether if a land can be granted or not. Respect agency section 69 of the land ordinance. I have grown in 57 meters of land. I have grown, mango garden is there, Melody, in the government land. I have made an application for grant of that land. There is a recommendation after the Mahazar drawn by the authority to grant the land in question. Respect agency section 69, Melody.
69
of the land union.
Last time note ಬಲ್ಲ ನಾವು
69 ನಾನು ನೋಡಿದೆ 69 ಏಜ್ ಹೊರಟೋಗ್ಬಿಟ್ಟೆ ನಾನು
69
section 69 subject to such rules as may be made in this behalf the state government, regional commissioner, the deputy commissioner, the district commissioner in charge of the Taluk.
All of them start from
67.
section 67.
Yes, madam. Yes. Then it is a government land, admitted to government land. I made an application for the simple reason, the adjacent land belongs to me. By oversight or I have fenced it and I have grown 40 years of old of mango trees are there in the land in question. Therefore, I am seeking a direction for grant of this land. Then respect 20C.
No.
Rule 22A.
Lands falling under this chapter can be disposed of only in a manner known to law. Not by way of an application by some person.
True, madam.
ಹಂಗಾಗೋದಿಲ್ಲ.
ಅಲ್ಲ, Rule 22A.
If the deputy commissioner is of the opinion that these lands are either landlocked or it have lost the character for which they were reserved.
Yes, madam.
And it can be disposed of. It should be done only by a public auction,
True, madam.
not by considering an application at the hands of one person. ಹಂಗಾಗೋದಿಲ್ಲ.
22A has been amended to the land grant.
So we will say, let the deputy commissioner consider your grievance in accordance with law, not by considering your application.
Okay.
22A has been amended to land grant rules, wherein my land, the land can also be leased for agriculture purpose.
Adane, for whatever
22A, my.
lands that are falling under this chapter
Yes, ma'am.
can be disposed of only in a manner known to law. So therefore, even if given an application, we will direct the deputy commissioner to consider it in accordance with law.
Yes, ma'am, only seeking a direction.
Yes.
Therefore, 22A, my land, at least on lease, if not for absolute right, absolute grant, it can be leased.
22A.
Rule 22A of land grant rules. These are the
On payment of market value, no ಕೊಡ್ಬೋದು.
market, whatever.
So land grant rules 22A.
22A. Lease to leasing it, if not for absolute grant manner, at least for lease. There is another column number 5 in that rule 22A.
Agriculture 20 times of
For
the
land granted under rules 19 to 22. 19 to
Notwithstanding
22.
anything
Lease of
contained
land.
in rules 19 to 22 and the superstition of the rates fixed on these basis under rules 19 to 22. The government hereby fix the uniform market value or guidance value in respect of private bodies or institution to form the grant is made on these basis as following in. Then agriculture is also there, column number 5. 20 times of the land revenue per year, 20 times of the land revenue per year as rent.
19D ನಲ್ಲಿ an individual also is entitled, but again 19D. The other provisions are for associations, farming societies and other. Individual comes under 19D.
Notwithstanding anything contained in rule 19. Therefore, I am relying upon 22A. Unobtained class is there in 22A.
19D ನಲ್ಲಿ the extent of the land may be leased to any individual.
19(1)D.
1D. Sorry, 19(2)D.
Huh?
19(2)D.
19(2)D.
An extent of land that may be leased to any individual or company ಅಂತಿದೆ. So they may be entitled, but only in accordance with law. Direction only can be given. So they cannot say as a matter of right.
Notwithstanding anything contained in rule 19 to 20. So non-obstant class is there in rule 22A.
(22A).
Yes, ma'am. Notwithstanding anything contained in rules 19
to
22 and in superstition of the rates fixed on these bases under rules 19 to 22, the government hereby fix the uniform market value or guidance value in respect of private bodies or institution to whom grant is made on these basis as following namely. So in this column, agriculture is also included. Other than
ಇದರಲ್ಲಿ ಇಂಡಿವಿಜುವಲ್ ಬರೋದೇ ಇಲ್ಲ. ಇಂಡಿವಿಜುವಲ್ ಬರೋದೇ ಇಲ್ಲ.
Agriculture may not.
Agriculture ಇದೆ, ಇಂಡಿವಿಜುವಲ್ಸ್ ಬರೋದಿಲ್ಲ.
It doesn't say whether body or private body or institution.
19(2)D ನಲ್ಲಿದೆ individual. 19(2)D ನೋಡಿ.
19(2)D. 19(2)D may not.
Is substituted by the word by later notification.
2D may not. 19(2)D.
2003 ನಲ್ಲಿ.
The extent of
insert
land
ಮಾಡಿ.
may be leased to any individual or company.
ಅದ್ ನೋಡ್ದೆ.
Will not exceed 4 hectares. It is 37 guntas only.
ಈಗೇನು ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಏನೋ ಇಶ್ಯೂ ಮಾಡಿದಾರಾ?
ಇಲ್ಲ, there is a recommendation may not. Now, annexure, there is a recommendation by the authorities at page 42. Deputy Tahsildar has recommended after inspection and trying hazard.
Sorry, Lordship, for that. 2D is only for non-agriculture purpose. For agriculture purpose is 19(1) ನಲ್ಲಿ. 19(2) Agricultural land only for industry or public. Individual ಕೊಡಕ್ ಬರೋದಿಲ್ಲ.
ಅದೇ
Individuals ಗೆ agricultural land ಕೊಡಕ್ ಬರೋದಿಲ್ಲ.
non-agricultural purpose. 19(2)(d).
For non-agricultural.
Non-agricultural purpose.
Not for agriculture. 1948.
It cannot be, see, that is why Karnataka land grant rules are there for grant of agricultural lands. There cannot be two separate statutes.
ಈ ಲ್ಯಾಂಡ್ ಅದರಲ್ಲಿ 22 ಏನಲ್ಲಿ ಲ್ಯಾಂಡ್ ಲಾಕ್ಡ್ ಗೌರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್.
Land locked government land.
7 ಅಲ್ಲಿ ಲ್ಯಾಂಡ್ ಲಾಕ್ಡ್ ಗೌರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್. Which have lost their original characters 10 years ago.
So there again.
Paid for corrupt land.
Which means if it is not fit for agriculture.
ನಾನು ಅದು ಕನ್ವರ್ಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀನಿ ಅಗ್ರಿಕಲ್ಚರ್ ಆಗಿ. It's a corrupt land. It's a government corrupt land. I have converted it to agriculture.
ಹಂಗಲ್ಲ.
ಅಲ್ಲಿ the rate for the land falling within the agriculture land shall fix at the guidance value of surrounding agricultural land.
It is clear from these provisions, it is not meant for granting agricultural lands. The entire chapter deals with government properties where roads, drains, canals and other public
belong to the other person.
All belong to the government. Adralli ಕೆಲವು ಜಾಗ which have lost their character of the usage for which it is reserved.
Yes, madam.
They can be disposed of.
Your lordship will kindly see 19(4)(A). 19(4)(A).
ಅದು ಬಿಟ್ರೆ ಇನ್ನು for non-agricultural purposes, for educational institutions, industries, companies,
cooperative,
ಅವ್ರಿಗೆ ಪ್ರಾವಿಷನ್ ಮಾಡಿದ್ದಾರೆ. It's not agricultural lands for them. Companies again, if they are asking for agricultural lands, some of them are agro-based agriculture companies. If they are asking for agricultural lands, again they have to fall back on the Karnataka land grant rules.
Permissions.
Not under this provision.
ಇದರಲ್ಲಿ 19(4)(A) ನಲ್ಲಿ lease of land sub rule 1 for the agriculture purpose shall be subject to the following conditions also. The lease shall not do anything. 19(4)(A).
19(4)(A).
19(4)(A). Lease of lands under sub rule 1 for agriculture purpose shall be subject to the following condition also. The lease shall not do anything which is destructive or permanent injury to health. The lessee shall not sublet or alienate the land. The land shall be cultivated personally or by the members of the respective institutions as the case may be. The land shall not be utilized for any purpose other than that for which it is leased. The lessee shall pay annual rent not exceeding 10 times the land revenue plus water rate if any so and so and so. The subject land to the condition that the water rate to the taken into fixing the rent shall be at rupees so and so and so and so for A class, B class and C class of lands.
It refers to lease under sub rule 1.
ಅದೇ ಅವ್ರಿಗೆ ಅದು ಇಂಡಿವಿಜುವಲ್ ಕೊಡಕ್ ಬರೋದಿಲ್ಲ.
Individual ಇಲ್ಲ ಅಲ್ಲಿ.
ಅಲ್ಲ ಇಂಡಿವಿಜುವಲ್ ಇಲ್ಲ. For those rule 1 ನಲ್ಲಿ
ಅದನ್ನು ಕೂಡ
society
comes with conditions. Purple. It is the contention of the petitioner that his father Shri Ramaya had planted mango saplings in 37 guntas of land in survey number 120 of Kamenahalli village, Kundana Hobli, Devanalli Taluk, commencing from the year 1980, and now the trees have grown and the petitioner along with his family members have been taking care of the land along with the trees, and they are eking out their livelihood. From the land in question. Full stop. It is contended that the petitioner's father's name was entered in the land records, and after the death of the petitioner's father on 11/8/2006, the revenue records have been mutated in the name of the petitioner and his brother, who are in possession and enjoyment of the land in question. Full stop. The petitioner has filed an application before the Tahsildar, Devanalli Taluk, seeking grant of the said lands on the basis of prevailing market value, since the petitioner and his family members are in possession of the lands for more than 40 years now. Full stop. It is contended that the Tahsildar caused a survey and report at the hands of the Assistant Director of Land Records and the Taluka surveyor. Full stop. The surveyor has measured the land and has prepared a sketch and has recorded the statement of the petitioner and submitted the same to the Tahsildar. Full stop. It is contended that the report of the surveyor is in favor of the petitioner. Full stop. Nevertheless, no orders have been passed by the Tahsildar till date. Full stop. The prayer in the writ petition is to issue a writ of mandamus directing the Tahsildar to consider the application filed by the petitioner on 25/2/2021 and grant the land in favor of the petitioner on the basis of market value, prevailing market value. Full stop. Next para. Learned AGA raises an objection that agricultural lands may be granted by the competent authority considering the provisions contained in the Karnataka Land Grant Rules, 1969, or the provisions contained in section 94 capital A of the Karnataka Land Revenue Rules, 1964, where provision was made for persons in unauthorized occupation of government lands to seek regularization of the unauthorized occupation. Full stop. Nevertheless, it is also submitted that it is evident from the material available on record that the petitioner has only given a representation to the Tahsildar on 25/2/2021 which will not fulfill the requirements of the provisions contained in section 94(A) of the Act. Full stop. Next para. Learned the senior counsel Shri R.S. Ravi, appearing on behalf of the petitioner, would draw the attention of this court to certain other provisions of the Karnataka Land Revenue Act of 1964, more particularly section 69, which enables disposal of lands or other property belonging to state government under section 67 of the Act. Full stop. The learned senior counsel would also point out to Rule 22(A) of the Karnataka Land Grant Rules, 1969, where provision is made for payment of market value or guidance value for lands granted under Rules 19 to 22. Full stop. It is submitted that Rule 19 of the Rules, 1969 provide for lease of lands at the hands of the competent authority. Full stop. Next para. The learned AGA would again submit that Rule 19 basically makes provision for the Deputy Commissioner to lease out lands to educational institutions, cooperative farming societies, local authorities, a company or association for purposes of agricultural industry or any public utility. Full stop.
Individually there, but for non-agricultural purposes. Individually the dean and labor. But it should be for non-agricultural purposes.
In sub-rule 2, bracket D, although provision is made for leasing out lands to individuals, nevertheless, it is only in respect of non-agricultural lands for non-agricultural purposes. Full stop. Next para. Having regard to the submissions made by the learned senior counsel and the learned AGA, this court is of the considered opinion that the petitioner will have to approach the competent authority, even in terms of the provisions noticed by this court seeking grant of land in accordance with the said provisions, full stop. If such an application is made by the petitioner, the competent authority shall consider the same and pass orders in accordance with law as expeditiously as possible, and at any rate within a period of 3 months from the date of receipt of a copy of this order, full stop, ordered accordingly.
Number 36. Chandana Tarika ke. Number 3, my lord.
But we have filed application of vacating the interim order, my lord, granted by this on court on my lord 29/3/23. My lord, in fact, this land is already reserved for the purpose of construction of a Taluk Panchayat building in the municipality limits of my lord Mudavidri, which is a newly constituted Taluk. Because when the construction was halfway, my lord, this honorable court granted a status quo order regarding possession. My lord, 2 acres of land in survey number 223. My lord,
Being the petitioner,
Lord.
may submit, my lord.
well, if he is for final disposal, he will submit. My lord, vacating, my lord, I will.
By which order?
My lord, dated 29/3/23. Lord, the last paragraph there, my lord, parties direct maintain status quo with regard to possession in respect of survey number 223/5, measuring 3.20 acres of
Ian, what
Marpadi
the-
village.
What the claim of the petitioner?
Claim is, my lord,
Lord, being the petitioner, may I submit, my lord? The petitioner had filed form number 53 on annexure B, page 20.
He was granted occupancy rights
He was granted occupancy.
in the year 1981.
Yes, ma'am. Subsequently, he filed this application because in his family there are number of persons. He sought for land under form 53. This application, my lord, was considered, that is annexure B, and this was considered a report by village accountant was obtained. My lord, finds it at page 23. 23 is the Xerox copy of it. There is a recommendation. And you see the last but one item, 220.
Allah, occupancy rights itself were conferred in the year 1981.
Yes, madam. That was 19.
Where is that order?
Annexure A.
Annexure A.
Yes.
he is claiming Kumki right.
That was in the joint name of petitioner and 5 others. The occupancy right was ordered 23/9/1981. To that land, this Kumki, this form number 53, which was filed, is a Kumki to that land. That was claimed. My lord, the Kumki, that was work land after occupancy right was granted. Kumki was claimed under form 53 annexure B. That it was recommended by the revenue department. Kindly see page 23. There's a report, there is a report of village accountant also. Last but one item, 223/5B, Sarakara 3.20 IR, that is the application, Mohan Kotyandra Agme, that is cultivation. Lordship got it, ma'am. In page 22.
You had filed application in form number 7.
Yes, that
Ah.
was granted,
Ah.
not only me, along with me, there are 5 other.
Yes.
Occupancy right was granted.
Ah.
Later, this land is a Kumki land to the land which is granted by occupancy right.
ಎಲ್ಲಿ ಹೇಳಿದಾರೆ ಆ ತರ?
ಇದ್ರಲ್ಲಿ
Where have they stated? In this order at annexure A,
Yes, annexure A doesn't speak because that was in 1981.
yes,
That was under form number 7.
Correct.
Occupancy right was
Yes.
granted. Occupancy right was granted.
Ah.
Subsequently, the petitioner before the court filed an application.
a particular survey number, the dispute is?
Yes, ma'am.
ಯಾವ survey
Not
number?
That
survey,
225,
it is
223.
Survey number
My lord,
223/5B. The petitioner makes an application in form number 53. Form number 53 is at page 18.
That is apart from grant.
18. That is under 108 CC. Rule 108 CC, an application is filed. He says that he is in occupation of this land.
In terms of rule 108 CC.
Yes, 108 CC. That is under section 94.
That is Kumki right is claiming. Kumki right. Regularization of Kumki rights.
Form 53 itself is not maintainable.
108 CC maintenance.
One not eight of
108 CC.
Karnataka Land Revenue
rules.
And revenue rules. Rules. It comes under section 94B, ma'am.
Yes.
For the purpose of section 94, so the Tahsildar of the concerned taluk shall on receipt of an application or by issuing a public notice in form number 53 and by sending individual notice to the occupants in form number 54, identify the unauthorized occupant. That is under 108C may kindly be seen. Any person who is in unauthorized occupation of any land may make an application in writing to the Tahsildar of the Taluk in form 50 along with a fee of ₹2 payable by affixing a court fee stamp. Immediately on receipt of the application under sub-rule 1, the Tahsildar shall cause the particulars of the application to be entered in a register which shall be in form number 51. Kept in his office, he shall thereafter place the application before the committee or the additional committee after such a scrutiny as may be necessary. That is for regularization. The application is.
It doesn't say anything regarding the Kumki rights.
No, it doesn't.
It is generally.
It doesn't say.
Yes.
It doesn't say.
Yes.
It's general, as my lord puts it, it's.
Yes.
Then form number 53, my lord saw. Then kindly come to annexure, next page 23, which I just now read.
This was filed on 9/2/1999.
Yes.
Yes.
Yes. Then there is a report that the petitioner is in possession. That is last but one item in ink page 23. It is in Xerox. Referring to the Xerox because 223(5)B Punja Sarakara 3.20 IR 141 of 99/2000 Mohan Kotyandra Agman process. Then there is a inquiry, a report was at, report is at annexure C, that is page 29. There is a report that petitioner is in possession of 223/5, 3 acre 20 cents. Kindly turn to the next page. I am referring to the Xerox copy of page. Kindly turn to the next page. Mandane, bottom of page 25. Xerox.
Page?
It is, I have noted it as page 25, my lord, annexures. Mandal. ಆಕ್ರಮಣ ಸ್ಥಳವು ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಕದೀಂ ವರ್ಗ ಸ್ಥಳದ ಕುಮ್ಕಿ ಸರಕಾರಿ ಸ್ಥಳವಾಗಿದೆ. ಆಕ್ರಮಣ ಸ್ಥಳವನ್ನು ಕಾನೂನಿನಂತೆ ಸಕ್ರಮೀಕರಣ ನಿಯಮದಂತೆ ಆಜ್ಞೆ ದರಖಾಸ್ತು ಮಂಜೂರುಗೊಳಿಸಬಹುದು. This is the report to the committee. This was on 29/2003. After that, nothing was done. Petitioner was not informed anything about the application. One fine day, the year 2023, the officials that respondent number 2 and 3 come and trample upon the property, and he is a poor agriculturist living along with his brothers and brothers' family, trample upon the property. Then immediately a notice was sent. My lord finds it at page 31, annexure D. My lord, in this notice, kindly permit me to read the second paragraph. My client and his, this was sent on 1/2/2023. Next page, date is there. He is an illiterate. My client and his ancestors have been in possession and enjoyment of survey number 223/5, measuring 5.70 acres of Marpadi village in Mudbidri town and Taluk since a time beyond memory, that he has been granted occupancy right for his tenanted land as per law laid down by the Honorable High Court of Karnataka. The agricultural tenant to whom the lands were granted under the Karnataka Land Reforms Act are entitled to Kumki privileges, that the entry in column number 11 of survey number 223/5 mention the name of landlord Raviraj, son of Krishnaraj Shetty, that therefore my client is entitled to enjoy the privileges and right over the said property, which even according to the government record have been in possession and enjoyment of my client as tenant of K. Raviraj. That is the other. The said property was enclosed by ancient mud wall, that without a denotification of the Kumki privileges and without following the procedure in accordance with law, my client cannot be dispossessed even by the government. The government will have to follow the procedure and principles of natural justice. The person is in settled possession cannot be dispossessed but by following the procedure in accordance with law. Then on 31/1/2023, in the early morning, the subordinate officials of the Tahsildar, the survey department, the chief officer, and the police visited the property and attempted to destroy the mud enclosure to the above property and also to destroy the valuable tree growth, stating that it is required for the purpose of the government. The above act of the government and its subordinate officials is high-handed, illegal, and calls for the legal action for the damages done for prevention. My client therefore hereby calls upon you not to interfere with my client's possession and enjoyment of the plot in survey number 223/5, measuring 5.70 acres of Marpadi village, and not to resort to forcible action. Please take notice that my client will file a suit that is for injunction. My lord, what happened was, entire extent 5/7, they come and trample upon, no notice, nothing. Then this illiterate person had to approach a council and got issued this notice. Immediately what he did was, then he also sent a petition to the Tahsildar. My lord, that is on 10 to next page, annexure E.
No, this land has been granted to this town municipality.
That is what they
Taluk
say.
Panchayat. Taluk
My lord, all that may be, but my application was pending. When the application was pending.
There is, when was it granted to you?
My lord, that was granted in the.
And there is some more subsequent events, I will place it before this honorable court.
My lord.
Just because a person is illiterate.
2/1/23, my lord. My lord, 2/1/23, the Kumki right was extinguished. And my lord, we have produced the orders, my lord. We have produced the orders. Kindly look at the order along with the statement of objection. In my statement of objection, R3, but kindly look at the order at annexure R4. R2, my lord, page number 9. My lord, here, last you kindly see, this is order by the Deputy Commissioner of Mangalore, reserving this land, my lord, in favor of Taluk Panchayat. And my lord, the construction was almost halfway. A tender was called for, and my lord, work order was issued. Construction began, and my lord, then it was stopped. Before withdrawal,
27/12/2022.
yes, ma'am. Then before that, kindly see, my lord, the order, annexure R1. My lord, his application was rejected. Yes. My lord, kindly look at page number 70, page number, my lord, 7.
ಅರ್ಜಿದಾರರ ಕುಟುಂಬದ ಹೆಸರಿನಲ್ಲಿ 6.38 ಎಕರೆ
ಸ್ಥಳವಿರುತ್ತದೆ. ಸ್ಥಳದಲ್ಲಿ ಪರಿಣಾಮಕಾರಿಯಾದ ಕೃತಾವಳಿ ಇರುವುದಿಲ್ಲ. ಮತ್ತೆ ಪ್ರಕರಣ ಕರೆಯಲಾಯಿತು. ಅರ್ಜಿದಾರರು ಹಾಜರಾಗುತ್ತಾರೆ. ಅರ್ಜಿದಾರರು ಮೋಹನ ಕೋಟ್ಯಾನಿಯವರು ಮಾರ್ಪಾಡಿ ಗ್ರಾಮದ 223 3.20 ಎಕರೆಯನ್ನು ಆಕ್ರಮಣವೆಂದು ಸ್ಥಳದಲ್ಲಿ ಕೃತಾವಳಿ ಇರುವುದಿಲ್ಲವೆಂದು ತಿಳಿಬರುತ್ತದೆ. ಅರ್ಜಿಯನ್ನು ವಿಲೆ ಇಡುವುದು. This is the order.
Never communicated to the.
He was present. Can you look at his signature, my lord?
Kindly get the
Can you look
record.
at his signature, my lord? In the other, my lord, page number 7, typed copy alla idralli, original order alli. His signature was there, and this order was reiterated. Later on, the reiteration ellide. Avarige matte helidiralla. Yes. Later on, my lord, can you look at the endorsement? My lord, his signature was there. He has put his thumb impression. Page number 7, thumb impression, Mohan Kotian. Then, my lord, can you look at page number 9? Page number 13, my lord, 13. Endorsement. My lord, this one 27/2/2023, page number 13. My lord, I will read. The ಮೇಲ್ಕಣಿಸ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿ ಮೂಡುಬಿದಿ ತಾಲೂಕು ಮಾರ್ಪಾಡಿ ಗ್ರಾಮದ 223 3.20 ಎಕರೆ ವಿಸ್ತೀರ್ಣ ಜಮೀನು ಹಕ್ಕುಪತ್ರ ಕೋರಿ ನಮೂನೆ 53 ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ರು. ಸದ್ರಿ ಅರ್ಜಿಯನ್ನು ಪರಿಶೀಲಿಸಿ ಸ್ಥಳ ಮೌಲ್ಯ ಪಾವತಿಗೆ ಆದೇಶ ನೀಡಬೇಕಾಗಿ ಉಲ್ಲೇಖ ಕೋರಲಾಗಿದೆ. ಈ ಬಗ್ಗೆ ಕಂದಾಯ ನಿರೀಕ್ಷೆ ವರದಿ ಮತ್ತು ಸಂಬಂಧಪಟ್ಟ ಮಾರ್ಪಾಡಿ ಗ್ರಾಮದ ಕಡತ TRS ಪರಿಶೀಲನೆಯಾಗಿ ನೀವು ಸಲ್ಲಿಸಿರುವ 53 ಅರ್ಜಿಯನ್ನು 26/12/2003 ಬಗರ್ಹುಕುಂ ಸಕ್ರಮ ಸಮಿತಿಯಲ್ಲಿ ನಿಮ್ಮ ಸಮಕ್ಷಮ ಆಕ್ರಮಿತ ಸ್ಥಳದಲ್ಲಿ ಕೃತಾವಳಿ ಇರುವುದಿಲ್ಲವೆಂದು ಅರ್ಜಿಯನ್ನು ವಿಲೇಡಲು ಆದೇಶವಾಗಿರುವುದು ತಿಳಿದು ಬರುತ್ತದೆ. ನೀವು ಸಲ್ಲಿಸಿರುವ ನಮೂನೆ 53 ಅರ್ಜಿ ಬಗರ್ಹುಕುಂ ಸಮಿತಿಯಲ್ಲಿ ಇತ್ಯರ್ಥಗೊಂಡಿದ್ದರಿಂದ ಉಲ್ಲೇಖವೊಂದರ ಕೋರಿಕೆಯನ್ನು ಮರುಪರಿಶೀಲಿಸಲು ಅವಕಾಶವಿರುವುದಿಲ್ಲ. ಅಲ್ಲದೆ ನೀವು ಸಕ್ರಮೀಕರಣ ಕೋರಿರುವ ಮಾರ್ಪಾಡಿ ಗ್ರಾಮ ಮುಡವಿದಿ ಪುರಸಭೆ ವ್ಯಾಪ್ತಿಯೊಳಗೆ ಬರುತ್ತಿದ್ದು ಕರ್ನಾಟಕ ಭೂ ಕಂದಾಯ ನಿಯಮ ಕಲಂ 94A ಉಪಕಲಂ 4 ಹಾಗೂ ಭೂಕಂದಾಯ ನಿಯಮ 1966 ನಿಯಮ 108I2 ಪುರಸಭೆ ವ್ಯಾಪ್ತಿಯೊಳಗೆ ಜಮೀನನ್ನು ಮಂಜೂರು ಮಾಡಲು ಅವಕಾಶವಿರುವುದಿಲ್ಲ. For 2 reasons, my lord, a reiteration was made.
This second reason is not forthcoming from the original order.
My lord, thereafter
ಇದನ್ನ ಸೇರಿಸಿದಾರೆ ಆಮೇಲೆ.
ಹೌದು, ಅದು ಮುನ್ಸಿಪಾಲಿಟಿ ಆಗಿದೆ ಲೇಟರ್. My lord, ಮುನ್ಸಿಪಾಲಿಟಿ ಆಗಿದೆ ಲೇಟರ್.
Therefore, that reason cannot be given now.
No, I am not saying that. My lord, it is within 1 kilometer, because within 5 kilometers, my lord, if the municipal limits, my lord, they are not enter for regularization. My lord, now he has not challenged any of these orders. Thereafter, my lord, in accordance with law, the Kumiki rate was extinguished.
27/2/2023.
Yes. Both of these orders, my lord, you should have gone to KAT and should have challenged it under section 49 by filing an appeal. Then, my lord, now extinguishment of Kumki rate annexure R3, my lord. R3. My lord, R2, my lord. Page number 9. On 27/12/2022. This is, my lord, order of the Deputy Commissioner extinguishing Kumki rights under section 71 read with 79(2), my lord. Thereafter, my lord, the Assistant Commissioner as per annexure R3, kindly see, my lord, annexure R3. So this is order under, my lord, only 2 acres out of 320. My lord, not all the lands. Still 1.20 acres are with him. Only 2 acres has been reserved, my lord. Can you look at, my lord, R3. R3, my lord, page number 11. This is the order of the Assistant Commissioner under section 71. Saying that, my lord, it is reserved for construction of the building of Taluk Panchayat. My lord, Mudabidri is a new taluk which is formed, constituted. My lord, they need a Taluk Panchayat building. My lord, only 2 acres, kindly note this, my lord, out of 3.3 acres. Now, my lord, he has not challenged the, my lord, the rejection of the Kumki right application before the KAT. It was of 2003 and it was reiterated. Now, these orders also not challenged. My lord, without challenging, kindly look at the prayer, my lord. Kindly look at his prayer now. Yeah, this writ petition itself is not maintained for this reason. Can you look at the prayer, my lord? He is seeking consideration of his application. But kindly look at the application he is seeking consideration. That is, my lord, annexure E. That is page number, my lord, 32. My lord, typed portion is 33. What he seeking is, my lord, Marutanaka Nadisi is not asking consideration. Well, can you look at the application which is regarding which he is seeking mandamus? Last line. Adira Dayamadi Sadri Kadatha Baki Marutanike Nadisi is aware, my lord, is rejected. He is seeking Marutanike. My lord, whether this petition itself is maintainable. On the basis of which, my lord, this honorable court granted status quo order because he is seeking possession of 3.2 acres. Whereas, my lord, grant was in favor of the Panchayat, my lord, only 2 acres. Still, he is in possession of 1.2 acres of land. We are not interfering. But moreover, it is within the municipal limits, 1 kilometer, my lord, it's Marpadi village. But 5 kilometers within which, my lord, they are not entitled. That I am not pressing before your lordship, my lord. But can you look at, he has not challenged any of the orders. Our Marutanik and the Kelogli, it's very crystal clear that he is aware. So, my lord, this petition itself is my response submission, my lord, is not maintainable. And he has no legal right to claim a mandamus.
My lord, my learned friend read R2. And
My lord, before that, 1 minute, my lord, I will not waste lordship time, my lord. Can you look at the construction at my vacating application, my lord? Vacating application, construction agi, my lord, 1.5, my lord, 6, 7, 8 months in the stop agide. Yes.
my lord, my learned friend says that is extinguishment of Kumki right. My lord, kindly see annexure R2. R2 is dated 27/12/2022. Does not refer to my application or the Kumki privilege. It is not communicated to the petitioner. Kindly see this, my lord. Without extinguishment of Kumki.
Sir, their contention is your application has been considered and disposed of.
Therefore,
Therefore, there is no question of referring to your application.
if it agreeing on the statement of respondent maybe, but it is kept pending. It is not disposed of. My lord, at least the reasons are not forthcoming. Kindly see the village accountant, he recommends that I am in possession. Kindly see annexure C. Kindly see this, my lord. Maybe man is very poor, he is illiterate, doesn't know anything, but his rights cannot be trampled upon by the state.
What to do, sir? There is a thumb impression and along with your signature.
He kindly, how and when this was brought, my lord, this cannot be, kindly secure the records, my lord. And this honorable court, after hearing at the stage of admission, did not grant. There was an objection and there was a caveat entered. After hearing, the court was satisfied that there is a merit because caveat is caveator who was heard was not a party to the proceeding. That is on record. That is on record. That is the order. And my lord, who has filed this application? The chief officer. Tahsildar has not filed. Revenue Department has not filed this application. Can you see this? And before that, this it says clearly says Akramana Sthalahu Kadim Vargada. I am at page 25. Why I am saying is this person
He is pointing out your own representation which says Marutanike.
ಅಲ್ಲ ಮರು ತನಿಖೆ ಅಂತ ಹೇಳಿದೆ ಕೂಡಲೇ
Why, sir?
ಅಲ್ಲ ತನಿಖೆ
Why Marutanike?
Because it is kept vile idalagide.
No, no.
Kindly see this, my lord. What they say is it is
ವಿಲೆ ಇಡಲಾಗಿದೆ ಅಂದ್ರೆ that disposal.
disposal ಅಂತ ಹೇಳಿಲ್ಲ.
Yes, ವಿಲೆ ಇಡಲಾಗಿದೆ ಅಂದ್ರೆ disposal.
My lord, ವಿಲೆ ಇಡಲಾಗಿದೆ ಅಂದ್ರೆ ಇನ್ನು ತನಿಖೆ.
No. That is the wrong understanding, sir.
Yes, yes.
Many of the learned councils are saying this.
Yes.
ವಿಲೆ ಇಡಲಾಗಿಲ್ಲ ಅಂತಂದ್ರೆ ಅವರ ಲ್ಯಾಂಗ್ವೇಜ್ ಅಲ್ಲಿ disposed of.
My lord,
They have given a reason that you are already holding 6 acres of land.
Yes.
And therefore you are not entitled to it.
6.83. 6.83.
Not me alone. It is the entire family of five.
There is some reason.
My lord, there is.
Therefore,
Yes.
that was an occasion for you to challenge that order.
My lord,
You are
that
not
was
challenged it.
That was not to the knowledge. And when, what did they do when I issued a notice? They come and trample upon and take possession. My lord, I will take my lord through the each and every document.
I have passed many orders
Yes, ma'am.
where I have accepted the contention that when the application is pending consideration.
Yes, ma'am.
The government or the competent authority cannot dispose of the land to any other entity. I have held so.
Yes, yes.
But here is a question, here is a case where your application has been considered and rejected.
My lord, and
Sir, we cannot go into disputed questions
my lord,
under
I'm
Article 226.
I'm not on
If
that.
if your contention was acceptable,
Yes,
that your application was pending consideration,
yes.
and without pending consideration, they have allotted the land to another entity,
That is,
then it was a sure case where I would have allowed the petition.
my lord, that is one of my contention. My
Your
lord,
content, but they have produced documents now,
that is,
along with your own representation seeking reconsideration.
that is, I have stated. My lord, one more submission is, they say that Kumki privilege is extinguished. Where it is extinguished? Kindly see annexure R2.
Adalla is
My
not
lord, I
necessary.
am making all this.
That is not his prayer at all.
Your application in form number 53 is not for Kumki rights.
My lord, I can.
It is an application under section 94A for regularization of unauthorized occupation.
94B. Kindly see 94B for a minute.
The entire chapter is for that only.
Grant of land.
Form number 50, 53, 57 are all for regularization of unauthorized occupation of agricultural lands.
Yes.
There is no question of Kumki rights, even in an application.
No, Kumki rights, because it is a work property, there is a judgment of this honorable.
No.
court in
Your
INR
application is in form number 53.
Yes,
That will be under section 94A,
yes,
only for regularization of unauthorized occupation.
94B, ma'am. 94B, the capital B, kindly see this.
All this beyond his prayer now.
Ninety-four B. Notwithstanding anything contained in this act, if the deputy commissioner or other officer authorized by the state government in this behalf is satisfied, after holding such inquiry as he deems fit, that a person has prior to the 14th day of April 1990 unauthorizedly occupied any land, including land referred to in subsection 2 of section 79, from which he is liable to be evicted under section 94. My lord, I come under this, being eligible for grant of such land under section 94 capital A, has failed to apply for such grant under subsection 4 of the said section within the period specified therein, and provided that nothing in this clause shall apply to a person who has become eligible for grant of land by virtue of Karnataka Land Revenue Amendment Act, has continued to be in actual possession. My lord, I qualify in all this. I continue.
See, but if your application has been disposed of long ago.
My lord, I will make an effort that it is not so. And my lord, it's a, otherwise also, there is this Kumki privilege is not, has to be extinguished in a manner known to law.
Unless you had challenged that order, it is difficult for this court to accept this contention, please.
My lord,
that order contains a thumb impression along with your signature.
No signature.
It is there. Signature is a
Now you cannot.
ಅವ್ರು ಬರ್ದಿರ್ಬೋದು, ನಿಮ್ಮ ಹೆಸರು ಬರ್ದಿರ್ಬೋದು.
ಹೆಸರು ಬರ್ದಿರ್ಬೋದು.
Correct, ಇರ್ಬೋದು.
Therefore, my lord, my
thumb impression is there. Thumb impression is there.
Thumb impression also. is-
And along with that, your application for reconsideration.
My lord, reconsideration will not defeat my rights for this reason. Nanu, that is, I am at page 33.
Yes.
ನಾನು ಮಾರ್ಪಾಡಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 223/5 3 ಎಕರೆ 20.
ಇವಾಗ ಸ್ಟಾರ್ಟಿಂಗ್ ಅಲ್ಲೇ ವಿಷಯದಲ್ಲೇ ಹಂಗೆ ಬರ್ದಿದ್ದೀರಾ. ಸಕ್ರಮ ಕಟ್ಟಡದ ಬಗ್ಗೆ ಮರು ತನಿಖೆ ನಡೆಸಿ
ಸ್ಥಳ ಮೌಲ್ಯ ಪಾವತಿಗೆ ಮರು ಆದೇಶ ನೀಡುವ ಕುರಿತು. ದಟ್ ಇಸ್
ಮರು ತನಿಖೆ
ಅಂತ ಹೇಳಿದ್ದಾರೆ. And my lord, this poor illiterate person, how should he know all this, the acts of the government? My lord, and they come and trample upon, take possession without the extinguishment of Kumki privilege. Can they do it? And who has filed this application? My lord, they kindly see the application for vacating stay is filed by respondent number 3.
Yes. Because that is the beneficiary.
No.
It is aggrieved because the interim order is causing difficulties for them.
Chief officer of a municipality, whereas this property they say should go to the taluka office. That is what? Establishment of taluka office.
Who is putting up the construction? Third respondent.
Taluk Panchayat.
Taluk Panchayat. The very same reason the
Taluk Panchayat construction, my lord, chief officer of municipality, Muduvidri, my lord, he has not made them a party. Taluk Panchayat and party madilla.
Land is granted to whom now?
That is Taluk Panchayat.
Then how are you aggrieved?
My lord, that is within the municipality limits. Municipality limits ಒಳಗಡೆ ಇದೆ.
But how are you aggrieved, sir?
My lord, earlier, my lord, there is an order 29/3/23, my lord.
ಅದಂಗೆ ನೀವು ತಾಲೂಕ್ ಪಂಚಾಯತ್ ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ?
ಅಲ್ಲ,
ಅವರು ಬೇಕು ಅಂತ ಮಾಡಿಲ್ಲ ಪಾರ್ಟಿ.
ಆಯ್ತು ಸ್ವಾಮಿ.
Because land is granted to Taluk Panchayat for
I
construction.
did not know, my lord.
My lord, it is a public construction. ಇವರು ಸುಮ್ಮನೆ
No communication to me about all this. Kindly see when this was communicated to me.
My lord, he is arguing on merit, my lord. Now he is looking at the, my lord.
Because it is my survival.
Not survival, my lord. He is having 7 acres of land granted by the under Land Reform Act. Moreover, we are claiming only 2 acres out of 320. My lord, Form No 53 is filed for 3.2 acres. ಇನ್ನು 1 acre 20 ಗುಂಟೆ ಅವ್ರ ಹತ್ರನೇ ಇದೆ.
Kindly see the.
ಅವರು ಡೆಲಿಬರೇಟ್ಲಿ ಮಾಡೋ ತಾಲೂಕ್ ಪಂಚಾಯತ್ ಪಾರ್ಟಿಯೇ ಮಾಡಿಲ್ಲ.
Let them come on, my lord.
Come on, you should have done that. But what is the prayer is?
It's difficult to understand how you are aggrieved.
That is exactly the earlier order of this honorable court, how they are aggrieved. And office was directed to put up a note how the caveat was put up. There is the cost list also shows that.
My lord, kindly look at the Taluk Panchayat earlier filed a caveat. Kindly look at the order, my lord, on 29/3. 29/3/23. 14/8/23, my lord. In the light of the report of the registrar, note that the cost is showing the land council.
Correct. ಇದರಲ್ಲಿ ತಾಲೂಕ್ ಪಂಚಾಯತ್ ತೋರಿಸಿಲ್ಲ ಕಾಸ್ಟ್ ರೈಟ್ ಅಲ್ಲಿ ಅಂದ್ಬಿಟ್ಟು that caveat has not been put up.
It is noticed that Respondent 3 is the chief officer town municipality Muduvidri and the caveat was filed by executive of Taluk Panchayat.
ಹೌದು.
Caveat now Taluk Panchayat ಹಾಕಿದ್ದು Muduvidri, which is
now you are making submission on whose behalf?
Respondent number 3, man.
How is the Respondent 3 aggrieved?
Lord, this is within the municipal limits, my lord.
If the land has been granted to the Taluk Panchayat, how are you aggrieved, sir?
But because he has deliberately not made a party, we are being
at best you could have, in the first instance you could have brought to the notice of this court. You would have come along with the Taluk Panchayat saying they have deliberately shown the name of the chief officer town municipality.
But can you look at
when the grant is made in favor of
executive. Can you look at the order last line, man? Petition is also permitted to take out notice responsible by way of hand summons, release the matter and so and so. My lord, the inspector, all these things, but kindly look at the 14/8 order, my lord.
Hello, sir. Please tell us how is this chief officer of the town municipality aggrieved of this petition?
ಇವ್ರು ಮಲೋಡ್ ಅವರೇ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ಅವರು ಆಕ್ಚುಲಿ ಇವ್ರು ಕೇವಿಟ್ ಹಾಕಿದ್ರು
You should have, the Taluk Panchayat should have come there.
ಕೇವಿಟ್ ಹಾಕಿದ್ರು ಅವರು ಕೇವಿಟ್ ಹಾಕಿದ ಮೇಲೆ ಅವರ ಹೆಸರು they also filed affidavit also. Affidavit ಹಾಕಿದೆ. Can you look at the order? I will read the order.
Sir, what is the use now? You please tell me.
ಅಲ್ಲ ಯೂಸ್ ಅಂದ್ರೆ ಪಬ್ಲಿc construction ಮಲೋಡ್ it is within the municipal
Let the
limits.
Taluk Panchayat come, how are you aggrieved? Who are you?
That panchayat should have filed, they should have been impleaded or malot, they should have made a party. But he deliberately has not made a party. Our relief ಕೇಳಿಲ್ಲ our prayer ಅಂದ್ರೆ revenue authorities against. His, I look at the confines of his prayer.
Sir, he is aggrieved of the action of the Tahsildar and the Deputy Commissioner.
Yes, my lord.
So that is the reason he has come before this court.
Yes.
He says he was not aware that the land has been granted to the Taluk Panchayat. Even otherwise, the moment the caveat petition was not put up and interim orders were passed by this court, the Taluk Panchayat should have come before this court and said, look here, this grant has been made in my favor, but they have arrayed the town municipality as the party.
My lords, earlier instance, my lords, Taluk Panchayat filed caveat. He has represented the court. He has filed, this honorable court directed the Taluk council who appearing Taluk Panchayat to file affidavit on behalf of the chief officer of the Taluk Panchayat. Subsequent to it, it is noticed that they have not arranged the Taluk Panchayat as a party. Subsequent to that,
what you should have done?
We have entered the
who?
Respond number 3 municipality, my lord.
For what purpose? If you are not in any way the owner of the property or the grantee or the person who is putting up the construction, why are you before this court? You should have informed the Taluk Panchayat of what has happened.
No, my lord.
At least they would have come and filed an application for impleading.
My lords, earlier instance, my lord, the executive officer Taluk Panchayat filed his affidavit.
ಗೊತ್ತಾಯ್ತ್ರಿ ಎಷ್ಟು ಹೇಳ್ತಿರ್ರಿ? Which means the Taluk Panchayat is aware that the writ petition is pending consideration. Where is the application to implead? ಬರ್ಕೊಳ್ಳಿ.
ಇದರಲ್ಲಿ the state.
After
State
hearing
is a party, my lord.
After hearing the learned counsel for petitioner and the learned senior counsel for respond number 3, town municipality, Mudbidri, this court finds that the deputy commissioner has granted 2 acres of land out of
3.20.
3 acres and 20 cents,
20 cents.
In survey number 223/5 of Marpadi village in favor of the Taluka Panchayat for construction of
Taluk Panchayat building.
A Taluk Panchayat building.
Within the municipal limits.
Full stop. Nevertheless, the Taluka Panchayat is not made a party to these proceedings. On the other hand, statement of objections have been filed at the hands of the third respondent, town municipality, which is in no way concerned with the land in question, since land has not been granted in favor of the third respondent and construction is not taken up by the third respondent. Full stop. Next para. Having regard to these factual infirmities, the petitioner is directed to implead the executive officer of the Taluk Panchayat. Mudbidri, na? Mudbidri.
Mudbidri Taluk. The newly constituted Taluk, Mudbidri.
That order of the deputy commissioner?
That is annexure.
New statement of Nimma statement of objections ತೆಗೆದಿದೆಯಲ್ಲ ಅದು.
Annexure R2 page 9.
R2 and R3. Page number 9 and 10. 9 and my lord.
10 operative portion at 10 minutes.
Mudbidri. Taluk Panchayat, Mudbidri. A party respondent to these proceedings. Learned counsel for the petitioner shall carry out the amendment in the cause title forthwith. Full stop. Issue notice to the newly impleaded respondent number 4. Full stop. Release this matter on 2nd of April. Please. Huh?
Next matter.
Matter reach agade and extend ಮಾಡೋದು ಬೇಕಿಲ್ಲ. Not necessary.
Serial number.
All matters that have not reached today will come up next week.
Serial number 38, you know.
ಏನು? ಇದರ ಇದ್ರೆ ಕೇಳಿ.
Serial number.
Matter reach ಆಗಿಲ್ಲ. Next week ಬರುತ್ತೆ.
Serial number
38, Mayor.
Harish sir. ಹೇಮಾವತಿ ಆರ್ಡರ್ ಆಯ್ತು. ಹೇಮಾವತಿ ಕಾಪಿ ಆರ್ಡರ್. ಒಂದು ನಿಮಿಷ ಬಿಡಿ. ಆಟೋಮ್ಯಾಟಿಕಲಿ ಬರುತ್ತೆ.
39.
ಎಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಸರ್, ಆಲ್ ಮ್ಯಾಟರ್ಸ್ ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಆಮೇಲೆ ಕೊಡಿ.
Week after next.
ನೋಡ್ರ
ತಾಲೂಕ್ ಪಂಚಾಯತ್.
ಇದು ಲಾಸ್ಟ್ ಮ್ಯಾಟರ್ 2nd April ಅಲ್ಲ?
2nd April. ಮತ್ತೆ
ಯಾವತ್ತು ಬರುತ್ತೆ? 27 28 ಸರ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಯಾವತ್ತು? ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಯಾವತ್ತು?
ಡೇಟ್ ಇಲ್ಲ,
ಏನಿಲ್ಲ.
ಆಟೋಮೆಟಿಕ್
ಹೌದಾ?
ಗೊತ್ತಲ್ಲ ಡೇಟ್ ಕೊಡೋದು. ಅದು ಲಾಸ್ಟ್ ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಎಷ್ಟೊಂದು ಆಗಿದೆ. ಹಳೇದು ಯಾವ್ದು ಎಷ್ಟೊಂದು ಆಗಿದೆ, ಒಂದೆರಡು ಅದು ಚೆಕ್ ಮಾಡಿದ್ರೆ ಗೊತ್ತಾಗ. ಎಕ್ಸೈಸ್ ಲ್ಯಾಂಡ್ ಅಂತ ಸ್ಟೇಗಳೆಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ, ಎಷ್ಟೊಂದು ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರೆ. ಸ್ಟೇ ಎಲ್ರಿ